Machiloko, a Newa. Engaria, Yataki Hukina, Hokinga, Kodiro, or Polopich, or Umachi, or Kutsupon. Kitorato, Kodiro, Kiana Rata, the Faka Papa Kato, Kitene Mahi, the Mahia Namata, Tiatane. I just want to return to our recording of our ancestors, our prophets, that will see that every plan we do has a whakapapa. Has a whakapapa. Whatever came out of the Iran, ko te kōrero nā te whiti o rongo mai, to hukākahi, te kōchi, o rātau katoa ngā poropiti, ana ka kia tu rātau, te kaumā rua ke ngā peka ki tēnei mea, te whakarite, whakamāhere. A tuatahi nā ki ana rātau, whakatongi te kākano. There's 12 parts to Rangara, a proper plan for anything, which we tend to forget. The first thing they say, plant the seed. Whakatongi te kākano. Anei reira ka puta mai, o ngā peka o tēnei kākano. Ki ana rātau nā te kune, te pūpoke, nā te pūpoki te hihiri, nā te hihiri te mahara, nā te mahara rā, te hini ngaro, nā te hini ngaro, te manoko, nā te manoko, ko te wairua rā, ko te mauri rā, ko te aroha, ara ko te aroha rā, ko te wānanga, ana ko pēne rā mātau i tēnei wā, kei te noho mātau ki te wānanga. Me pēhea rā, e takoto rā i tēnei whakatakoto kaupapa. Ara mai te wānanga, ko te āwhiro, ana ka puta mai po tēnei te kaupapa. Koe nā o rātau kōrero, o mātau porapiti tau wawā. Our prophets and ancestors see this. Every plant has a whakapapa, and to every plant there's 12 leaves that we plant. And we plant the seed first, and from that seed comes all different leaves for us to use in a planting. So koe nā rā o rātau kōrero. He ahau ke ngā kōrero, he piri atu ki wē rā kupu ko takoto hau ni mo ia tātou I tēnei atu. I have the I suppose, part knowledge of some of those words that I laid out here this morning. And o reira rā, kia kuta katoa ko tai mai tēnei wā, mohio ke au, ana ki te noho rā mātou, o ngā pamahere, o ngā whakatakoto kōrero, I roto I tēnei rohe, ana haere ki ngā rohe katoa. No reira, kāre tōro te kōrero, engari ko taku nei kāro, e takoto rā ue rā kōrero rātau, ki te kōrero o taku porapiti a te kōchi, ki mai te kōchi, e kare mā, kei te rere rā o koutou whenua, ki te moana, kei te rere rā ngā whenua tō ki te moana. Pē ngā kōrero katoa, te kōchi said, to be careful to telling us that the land is getting washed out to sea. And so me pēhea rā, aha ko te mahi o mātau I tēnei wā, ana aha ko te kaupapa, whatever kaupapa planning we're doing here today. There's the same thing happens when rātau kōrero, aha ko te whakamāhere, mo te ngāhere, mo te moana, mo te whenua, o ngā mea katoa he whakapapa no, kei te tūkehau o taua te Malu. I'm standing here on behalf of us as Malu, just to let you know, you plan, please consider those leaves, 12 leaves, that our people said. Kea he nā kōrero, kea hau nā kōrero, a ko tupu nā tūrā, nā kōrero ki te kaungi hera, nā ko mahi ara rātau, I wēnei kākano, wēnei peka. Our council have used those 12 seeds, 12 leaves. We've done it with tūmai pāna, nā ko mahi e rātau. Kia urua tūrā wēnei kōrero, o kōrero hi rā e. Kōreira, kia koutou katoa, ane rā, e tua ke nā tēmi, na tahara o tōku pāpa no ngai tūhoi, te arawa, tahara o tōku māma, no te aitanga māhaki no ngā whakaata, na mai ane rā hau e tua ke te pihi atu kia kōtau. My name is Rako Te Ora. It means a living tree or tree of life. I'm from Tūhoi on my dad's side, and in Te Arawa. On my mum's side is from Aitanga Mahaki, Ronga Whakata, from the Tairāpiti. And that's the place that been hit the hardest. So no reira, mena ke tuhina koutou ngā kōrero, mo te nei, o ene plans, me mahara rā koutou ki o ene kōrero, ka takoto hau ki mo i hā koutou i te rewa. Me ne hehi ana rā koutou ki te mohi, e hanga kōrero ne, e a hau ki ngā kōrero mo te. No reira, ka tira te kōrero, hami hui kia koutou, e te pāpā, koe rā i tūmata tā māta hui, ane rā toko mi, e tātou katoa. E whāna ko tahi rāpata, e hara ko te kiri e ki, he pāke a rā tēnā, he mauri tērā, he haina mana rā tēnā. Mai ko, he said when he was lecturing up in Auckland, he gave these people a question. Who is a Maori? This ka haere rātou ki te wānanga tēnei kupu. Now, who is a Maori? And they come back, they never had an answer. And what he said is, a Maori is not by the colour of your skin, it's but by the colour of what you have in your heart. So I hope when you plan this, ka puta mai wera kōrero mai o tō pati manu, mai tō ngā kau, no reira tēnā koutou, tēnā rā tātou katoa.
O mai tōpohu, hei me. O mai tōkere, kia rongo te. Kiri o mai te kapu. Kia kōrero, te kupu, kia kōrero. Nau nei o, nau nei o, nau nei o.
You are the haven for writing out of this sheltering haven for us, for this kaupapa you have in your heads today. Whatever words you use, you have the words and we have to see your plan half. I hope there's a bit of dollars in there for me. This is our waka group from the council. We come here this morning, we're heading off to America tomorrow. So, tēnā koutou, kia ora tātou katoa.
Eke tango, wano, aramake stoki, amie, uie, tai. Natira e ki matanga kore runga, e tika ana me mihi ki te runga rawa. Ana hoki tātou I tai pai mai I kone I te neia, I raro te karanga, te whakapai ki maki kuni. Te karanga te mui a tātau, a tai waki ngā kōrero mo te kaupapa. Engari e kōrero nei koe mō ngā mai ki tūkino a tāpiri mātea. Heke mai waua tika ngā i a rātau. Hai te mea mātau e ki me pēhea. Te tiro mai ngā atua ki a tātau, te ka mea mai me pēne me pērarane. A tai hoake, rututu haere, a tāwhiri māte i a tātau. Engari kei te tangi atu ki a koe, te pake, ia koe ki nei, ko koe tonu te tahi o ngā mea i patua te uruta nei a Gabriel. O tira tātou katoara. Tātou katoara. O tiro hare atu a hau ki tōrohe. Turanga nui a kiwa. Ki tā aku o te Tairāwiti. I patua mai rātau. Engari ki te hare tonu ngā mai. Anei ko tā mai te rangi nei mo tēnei tāku. Mo tēnei tāku. Nane era me ki mai rā. Ni hi mai. Tapi ki pēne ahau. Te turu atuau ki taku maunga ki a tihira. Mai ākuri a whare. Ki taku paraia tūkaki. Te tamata rā tamahaya te whanua puri tēnei kōtoni. Te mihi nei ki a koutou katoa. Ngā ti toa, raukawa, te atiawa. Koutou katoa tēnei rohe. Te mihi rā kati. Me mihi rā kati. Au atu ngā take te mui a tātou. I ngā noatu. Engari ko te take o tēnei hui. E whakara wake au, te kahatonu koutou ki te mauhaere i ngā mana, i ngā tika, i ngā whakapapa, i whakarere mai rātau. Te kahatonu te kuhu haere, i roto i nei mai, i a koe korona. E ari te mea nā rātau anake tēnei hi koe. I ki ake nei koe, e hate māu. Nani tātou katoa. Tātou katoa, nā te mea, nā koutou tēnei whengu. Nā koutou. I tau iwi e ngā mei haru mai ki kone i te no. I te whakatakoto i warātau ture, warātau kōrero. Nani tātou e whiriwhiri haere nei ngā pōre rea tau. Ahai ana, engari kei te mihi atu ki a koutou katoa. Te mihi. Te pea ke he kore. Ke mutu rāno tēnei hui ki te mena ke te tika ngā kōrero ke te hera nei. Kei te aha. Engari me mahi tēnei i nei maki. Ke uru atu. Ki te ao. Hei waiotanga mai atu mua tātou mūhu. Nei tātou e kōrero nei mo te take mo te rangi nei. Nei gari ko te ukitanga o tērā, kua tātou mūhu. I waiwake te ao mo rātau, te ao tūturu, te ao Malu, e mo i tēnei tāu. Te i tā, nanuinu i uenei mihi kia tātou tēnei o. Engari te mihi atu ki a tātou katoa, e maware nei tēnei kopa. Te whakaparo ake, anei te koraki mo tātou katoa. Nai te mea, mo tēnā iwi, mo tēnā iwi, mo tēnā iwi ana. Engari ko te peketanga katoa, wa tātou whakaro, wa tātou iwi, ngā whakapapa, ngā uri kua ko heki mai ara ta ne lu ni trangin ni da itu kita ta ibar ta tu nau ngai no ni itu tu ta tu ni da nanti dah ada video betul-betul baru ini ru karena tu ini yang kata buri no tina ko itu Ini kata waya tu tekan.
Kaya ako
Agura kawe, karama kita bangke, aluroya kanto, temade ante kaliba. Hey, aku tangi pokok mau butuh poteri kamu wai toju tepen tua eta kotone nanti kudu itu dua eta kotua kene ne te take mo tata te fan te filmu eta kotua kene Porque tu está falando de meta calada, o te filme. E quando te filme, que fez a tal que pronto. Ali era o último, tem na coisa, tem na coisa. Eu vou dar.
We'll come around there. Up beyond this.
Sorry?
In our way, I think I have a leaf in your side and after me, photo, Nato, Nakapa Haka, Wata, and the later, who called it or computer mind, Takoto Mai, Mani, Mata, and it are chicken and market, 2 of the earth, and we like a way down the pathway to Kako to Pato. You didn't take that photo, you know, that's after.
Well, thank you very much, Koro and Tangata Whenua. For me, it reminds me that the job of decision making is an act of service and an act of aroha, and hopefully we can keep that in our heart as we also struggle with the hard edges of law. This mahi that we have for the next 2 weeks has largely been put on the council and others by the wharenui at Papatia. Parliament has passed a law which requires us to look at housing demand and other factors and so forth to respond to people's needs. So that's the process that we're working through. And so we're very grateful for that mihi and that quote that we can run the process appropriately. So thank you. Kia ora. So as I mentioned, we're here to hear Plan Change 2, which is to implement the medium density residential standards as passed by Parliament under the Amendment Act 2021, and also to implement policy 3 and 4 of the National Policy Statement as directed by Section 77 capital G. And our process is a little unusual in that it's not a decision-making role, it's a reporting and recommendatory role to the council about the proposal and the recommendations that we have from council officers and consultants. And if the council accepts our recommendations, then there isn't actually any right of appeal except on a question of law. So there's a special responsibility on us to conduct a robust process and one that's fair to all people. Our job as decision makers is to act independently and to follow the guidance of our treaty partner in terms of how we approach the care of the environment and the care of people. So my name is John Maassen, and I'm a barrister that has had about 35 years experience working in this field. And most of my career has been advising local authorities in terms of meeting their local government and resource management responsibilities. And I'd like each of my panel members to introduce themselves. So Jane.
Kia ora, ko Jane Black Tokawenga. I'm from Te Whanganui Atara, born in the Waikato, but mostly lived in Te Whanganui Atara, which is where I do most of my work. I'm an urban planner. I have my own practice and I work in mostly urban design, the area of urban design, got to do with housing and city centres. And I'm a commissioner, so I do some hearings as well. I'm looking forward to this process here. Thank you.
Kia ora, I'm Rauru Kirikiri from Te Whanau Apanu. which is the real capital. I've lived here for quite some time now, you know, but like my colleague to my left, I've been in the resource consent game for quite some time now. In fact, right now I'm doing one down in the South Island, and regional policy statement for Otago. I've just had into our 5th week down there. I've taken a break to come to this one for a couple of weeks, and I'll go back down there again after, carry on for another 6 weeks. But I've lived in Wellington for quite some time now. I moved down here in 1980 something, and my kids, my grandchildren think they come from me, but they're not really, because the one side is from Te Whānuapuni, from their grandmother's side is from Ngāti Kahungunu and Ngāi Kahu. But I'm glad to be here, because I've lived here for quite some time now. And you know, you look back at those who've gone, you think about the things they said and the things they did, and here we are these years later, and we're still trying to say the same things and do more of what they wanted and what they had in their mind about what was good for this country, not just for Māori, but for everybody. So, yeah, so that's me.
Thank you.
Tēnā koutou. So I'm just going to introduce myself and my name is Watene Kaiho. I come from the Tainui canoe. My people are Ngāti Raukawa and Whakatau on my mother's side. So, tēnei te whare o potatau ni hana kia koutou. Te rai te taho ki te pāpā. Tēnei te uri o mōtai tangata rau. O hoki roa, ni hana kia koutou. Pāpā ki. I'm an advisor for the Carpentry Council, and I work in the iwi partnership team. I'm here to support the kaupapa and listen to the great kōrero that will come our way. We support them on us. Tēnā koutou.
Tēnā koutou katoa. No ko te rara no ingarangi o tūpuna, i te waki au ki Tāmaki Whāuro, hei kaimahi ahau mō Atiawa ki Whakarongotai. Ko Clega taku ingoa, ka hoki mai au at Paraire, i te taho o ngā hinarangi Baker, mo te tuku e te kāro mo Atiawa ki Whakarongotai. Tēnā koutou, I'm Claire, I work for Atiawa ki Whakarongotai, and I'll be coming back on Friday with my hinarangi Baker to provide our solution.
Malu ora ki pare o te rā so very morning tēnei rā o inei wiki reira I te taho o pāpā o Aotea o te rau po oka and te whānau Pātia hau I te taho o mana me tainui mo ka hau o Ngāti Raukawa ki te tuka o Ngāti Māoka ka hau o Tapia hau ko au te kai tōku tuku Maxwell ko ngā iwi mo te kaunga. Tēnā rātou koutou katoa. My name is Deanna. I am the Senior Program Advisor for the iwi Partnerships team, Kapiti Coast District Council. My whakatau on my dad's side is to Taranaki to Aotearoa, to Purahauka Waka, to Wairopo. On my mother's side, I'm Tainui, and I'm from Ngāti Raukawa Te Tonga. From the Hapu Ōtaki. I'm one of the Hapu, or a group of Hapu of Ngāti Raukawa who reside in the coast area. Again, to kōrero katoa, o te matua, te rāko ora o te maipi, o taku tungane wātini, the mihi atu kia katoa, kia whiti kōrero mai kia a ka whakarunga ki te kore te katoa i nei o ki rua. O reira, kawatu kia katoa.
Tēnā rā tātou katoa kua ai. Ko tarana ki tīmanga, tarana ki tūturu te iwi. Ka whanga ai I rupana te oringi piko te tahi o ngā marae I pari aka. Ka roa ai pēnei. 50 years I've been here now. I've been with my I have 4 children here, 9 grandchildren and 17 great-grandchildren. And I've been above the corridor for many years. We actually had a couple of group that used to perform in Parapara that we've been together for a long time in this sort of I for June dates. I declare all to get it apart.
I said my name is Whakatau, but it's been changed to Donald. I don't have a better number. My mum will call me Donald Duck, so that was the same. So not Donald Trump. It's 2 years ago, Donald Murray. Yeah, so I'm the Malu for our council, our local council. I've been there 22 years and with them, and I was really pleased to be with them, with the council. So all the people I work there, but I'm still on them. So I'm still here now. When there's a kill the task.
We're Aaron trying to do my name is Aaron. I'm with the advising the communities team.
Kura ki te maunga ko waipu te awa nā te kura ki iwi whiwhi wai te puinga o reira kata māri e koutou rā mai haramai ki te rohe o Kapiti. I'm a staff member of council. I've been in council for 10 years. My family's been affected by Gabriel, whānau in Hawke's Bay, and my brother lives right up the coast, and they're still blocked off up there. There's a little village called Whakatau Bay. But he's resilient, and he's keeping on with life. So, yeah, I can understand your mahi here, whānau. It's a process, and it's a process that we're all going to be interested in. And your outcomes in your mahi.
Thank you. And our thoughts were with you, Donald, and your family and others who have been affected by the cyclone. So I just wanted to introduce some other people. So Hannah McCashin is the administrator, and she's the go-to person for organising your submissions and any other administrative matters. And I'm grateful for her stepping in because we had someone else, Abby Morris, previously, and she's been assigned to a new role. So Hannah very kindly took up that role. And then, of course, we've had 2 major reports from council consultants. The first and probably lead person is Andrew Banks, this gentleman here, and next to him, Katie Maxwell, and also Derek Todd, who's a coastal geomorphologist. And so they've done a huge amount of work to get this project underway, notify a plan, and present information to us to assist in terms of reporting to the council. So that's been a huge piece of work. And the work is a very high standard in terms of the structuring and all of that sort of thing. So that makes our job a lot easier. Like any other report from a council officer, it's part of the totality of the material we must consider. Just because it's been under the umbrella of the council doesn't mean to say we give it greater weight for that reason alone. But we're very grateful for what is obviously a very substantial piece of work to assist the council in its job. That all evidence, most people have cooperated with our pre-circulation directions or requests, and we're very grateful for that in a sort of way. It's burdened us with a lot of reading and thinking, but it has, I guess, helped us to focus our minds on types of questions that we might ask, and that's sort of our exclusive role. No one's asked for a right of cross-examination, which unusually could happen in this environment. But we do need to ask questions. And if anyone else has any questions that they think are worthy of asking, then perhaps they should let Hannah know, and the panel will consider that and see if we want to explore that line of questioning to make sure that at the end of the day, we produce the best report possible for the council, in light of the fact that, unlike the council, we will have heard the evidence and considered it. So that's really important. And in terms of the process, this is actually a council-initiated plan change. So the council, in a sense, is the proponent of the process, and so they have the right to speak first. However, in the schedule, we've only been given 10 minutes to ask Andrew and Katie questions, and unfortunately we have a lot more questions than 10 minutes will allow. So what we're going to do this morning is flag the areas where we have interest, big topics that need exploration, and then we'll use other times within the hearing to pursue that. So even though we want to keep some shape to the hearing, we need to be fluid and flexible, and so we'll run it that way. And in the course of this, we'll hear from submitters. And we've done a site visit, so Jason and Abby very kindly took us around the communities and the impacts. So we went to Paekakariki, Paraparaumu, Waikanae, and Otaki. I'm personally very familiar with Otaki because I have been in that area for about 15 years, and not so familiar with Paekakariki in places, but it was a very useful just survey, and it's helped me personally. I found it very helpful because I could look at the evidence with a sense of spatial understanding. Yeah, so in terms of just behaviour, the rule, we set out our kaupapa in our first minute, but basically it's a case of do unto others as you would have done unto you. So let each group or person speak to us, and we respect each other in terms of the different perspectives, and then we have to then go away and distill that and put it within the legal framework. There is a schedule published by Hannah which has the morning tea, lunch and afternoon tea breaks. And all I would ask is that people turn off their cell phones and listen attentively. Are we being recorded? Yes, so is that going on to YouTube? Yeah. So we're also, just to be aware that in the modern environment, you end up being, if you take any role in these proceedings, being projected into the cloud forever to be remembered for whatever you say. So that reminds me to be very careful with my words. And so I just thought I'd let you know that that is the case. And it's lovely that the Mihi and Tangata Whenua's contribution to set the canoe and let us going is at the forefront. So thank you very much. So what I would like to do, what I would like to do is hand it over to Mr. Conway, who is the lawyer for the council, and he's going to lead the team and present some submissions. He's pre-circulated his submissions, but he's as the lawyer guiding his team, so we basically hand it over to him.
Nā koutou katoa, or Matt Conway tōku ingoa, no te whakanui a tara ahau. And this, as the chair has said, I'm the lawyer here assisting the council team. I have prepared some written legal submissions, and I have circulated those as I've indicated. I have some hard copies here in case it's any use, but I anticipate we will have copies of those already. And I've got it's a 15-20 minute time window that's been allocated, and I'm very comfortable to use that in whatever way it's not just useful to the panel. What I envisaged was that I would step through the topics that I've covered in my legal submissions with a brief summary with reference to some of those key paragraphs, and then I can put up the questions. But I'm very happy to go through more quickly or more slowly as the panel wishes.
Yeah, it would be great to have a summary, and then we do have some questions. Can I just ask a question? How do we pronounce the correct name of the urapa that's referred to in your submissions? Is it Harivel?
Harivel.
Yeah.
Thank you. Well, I will take you to the end to start of my legal submissions, and on the first page here of text at 1.1, I've set out the broad coverage, and what I've endeavoured to do is first set out briefly the purpose and statutory scope of the plan change, being an intensification planning instrument, and then I've covered two matters that are legal questions that have been raised in submissions. There may well be more that arise during the hearing, and I'm very happy to assist with anything further as part of the council's reply. But just to frame what I've covered here, these were the matters that jumped out to the council team when they were looking at the submissions themselves. So the first is the questions of scope, and another matter is in terms of kāre warewa urapa, as you've identified. The reason we have covered matters relating to the urapa in some detail in opening is that is a matter that has been raised alongside this hearing as part of a directly referred consent application to the Environment Court. And so it's a matter we had some, I guess, interaction with the submitter on beforehand, and so I thought it might be useful to set out in some detail the discussion of that matter so that you have that from the outset. So turning first to part 2 of my submissions, the purpose and statutory scope of the plan change. You see there in 2.3, the core elements of the plan change are to incorporate the medium density residential standards into the district plan, and then to give effect to policy 3 of the National Policy Statement on Urban Development. Those 2 points, A and B, are the 2 mandatory components that the council was required to implement through an intensification planning instrument. And then points C to E are part of the discretionary elements that councils may include if they wish to. And so the first there under C is provide for qualifying matters, which are essentially reasons to exclude the full application of the medium density residential standards. And then D is an amendment to enable papakainga, and E is to amend the financial contribution provisions. I very briefly touch on the process in 2.4, and as the chair has outlined initially, that is a different process and somewhat unusually in a public participatory scheme of the RMA. There are no appeal rights from decisions under this regime. There are judicial review rights, but that stands as a separate form of challenge. And the background to that seems to be the government's intent to have these medium density residential standards implemented as soon as possible. And that's part of the reason for the statutory timeframe that's been given. 2.5 really, I think is probably the engine room in terms of one of the key provisions that is relevant for the scope of this plan change. It's section 80E of the RMA, and essentially if you don't fall within section 80E, you cannot be done through a plan change under the intensification streamlined planning process. So you'll see there in 80E paragraph A sets out what an IPI must do, and that's incorporate the MDRS, which are in Schedule 3A of the Resource Management Act, and secondly give effect to what is the relevant point in Part A there, because the council is a tier 1 territorial authority. So we've got to give effect to policies 3 and 4 of the NPSUD. And in B and following, those are the may do's. So we've done the must do's. The may do's are some of the provisions you'll see there, and there are matters in this plan change under both the Roman numerals 1, 2, and 3. You'll see there over the page, subsection 2 addresses other matters that may be included without limitation. And so those are some district-wide matters when it comes to things like the land development minimum requirements. Those relate to the whole of the district, but they are centred in matters that arise as a result of implementing the MDRS. So stepping through some of those matters, I mention in 2.8 related provisions. The key factor is that related provisions must either support or be consequential on achieving either of the two mandatory outcomes that I've touched on in section, and sorry, that should be 80E 1A. So section 80E is framed in such a way as to demonstrate that the mandatory outcomes are critical, and it's only after or as part of satisfying them that related provisions can be included. In 2.10, I briefly outline my interpretation, and I must say it's that at this point. It's one we've adopted consistently, and other councils we're advising in terms of what support will be consequential on me. And I've suggested there that an amendment would support the MDRS if it assists or enables the MDRS to be incorporated or assists with giving effect to policies 3 or 4. And over the page, an amendment would be consequential on if it follows or is required because of the council's obligation to incorporate the MDRS. And a little bit later on, I've used Ka Rewarewa Urupā as a bit of an example of how, in that case, the council says the inclusion of that Urupā as a site and area of significance to Māori support is consequential on implementation of the MDRS. I then touch on what relevant residential zone, the requirements in terms of relevant residential zones, and that includes every residential zone except large lot residential in urban areas with fewer than 5,000 residents. And then 2.13, I just touch on an initial point in terms of scope, because in order for a matter to be within the scope of this hearing and to be a matter that the panel can make a recommendation on, it needs to be within the scope of what the plan change is notified. And likewise, submissions need to be on that plan change as well. So both submissions and the panel's recommendations need to be on the plan change. Now, there is also an ability for the panel to make recommendations that go beyond the scope of what's raised in submissions. But that, I think, needs to be seen in context of matters that are still on the plan change. So once you're in that realm of being on the plan change, you're not confined to matters that are within submissions. And therefore, if you see alternative ways that would better achieve the purpose of these provisions. Even if they're not raised in submissions, those are matters that you can make recommendations on, provided they're within that broad scope of what the plan change addresses.
Yeah, it was slightly different than how I initially saw it when I issued my first minute, but I'm picking up the point. I thought that maybe people could make proposals for other pieces of land that weren't on the plan change, and it would still be available to recommend, but you're actually taking the position that scope still operates, but not in the strict way of, well, if there's another method to achieve fundamentally that the plan's purpose, but it's still on the plan change, then we have that latitude, but not to go around picking up pieces of land that aren't really within the scope of or on the plan change. Is that what you're saying?
Yes, that's essentially what I'm saying. What I'm not saying is that the spatial area that is specifically covered by this plan change is the sum total of the areas you can consider. But beyond that spatial area, I would say you have a limited ability to extend matters, extend areas. And so you'll see when you come to the discussion of submissions that Mr. Banks and Ms. Maxwell have addressed, that seek rezoning of further areas. There is a bit of a distinction in terms of the ones they've recommended can be accepted and the ones they can't. And so at a very broad level, areas that are contiguous with the area of this plan change have a higher degree of likelihood of being within the scope, whereas if there was an area much further away that's not connected, then it would be more difficult to find that as being within scope.
Yeah, and that's sort of trying to make an assessment based on the motor machinist type of criteria and saying what's sort of a logical step, but still anticipated or within reason anticipated, and those which are quite outside that.
Yes, that's right. And I've touched on motor machinists later, and I'm conscious you're familiar with that case, but that is a useful example, I think, of some of those spatial limitations.
Yep.
So in part 3 of my submissions, I touch on the permissible scope of submissions, and I've set out the relevant provisions there. And you'll see there that in 3.2, clause 6 requires a submission to be on the plan change, as I've mentioned, and likewise under clause 99, the panel's recommendations need to be on the intensification planning instrument, but under 2B are not limited to being within the scope of submission. So that's where that discussion arises from.
Thank you.
Now, over the page in 3.5, to provide some further framing as to the way that the usual legal requirements in terms of scope would apply, we've looked into this and looked into other plan processes that use a more streamlined process, and the consistent approach in the case law and the Auckland Unitary Plan seems to be one of them, is that the orthodox resource management approach applies to determining scope in terms of when a submission's on a plan change. The Albany North case is an example of that, albeit a different approach or a different situation, because in that case, that was a full plan review. And so the questions of spatial extent didn't really arise in the same way. And so the court there said, well, it's a bit different from the motor machinist situation, because here everything's up for grabs. But essentially the principle we've taken from that case is that the court there still applied the orthodox case law that applies in full plan reviews when deciding whether a submission is on the plan in that case. And so extrapolating that to a scenario where a streamlined process is being used for a specific plan change, it seems quite logical then to apply the same case law that would apply if this was a regular Schedule 1 plan change. And so that's what I've set out here. And hopefully nothing in that following section is is particularly surprising because it essentially just sets out those two tests. And in 3.10, that's the clear water test that was applied in motor machinists, where the dominant consideration is essentially whether a submission is addressed to the extent to which the variation changes the pre-existing status quo. And that's elaborated on in some ways under 311B in the motor machinist case, where the question is looking at things like, does the submission seek a new management regime for a particular lot that the plan change didn't propose to alter? So in other words, is this dealing with the same pieces of land that the plan change is addressing, or areas slightly outside that, or is it something that's quite different? And that in turn steps back to the second clear water test, which is really about natural justice considerations. So in other words, if the relief that's being sought would mean that someone who initially looked at the scope of the plan change would be surprised that you're making or recommending those particular changes, then that suggests it might be something that's outside the scope.
I think there was one site in Otaki where there was a process of subdivision and new boundaries occurring and so forth, and a submission sort of an extension, and I think Mr. Banks proposed, agreed with that extension. Is that an example of that acceptable change?
Yes, I think to the extent it's extending an area that's already addressed, it's essentially an expansion of one of those areas around the boundaries of something that one can see as more readily suitable. And it's connected too with the question of what the Section 32 report addresses, and whether it's evaluated some of those areas and whether they might be larger or small.
All right, we'll just adjourn for a moment, sorry. Sure. Safe travels. But I'm wrong about that. So it makes sense to release to the grades. We can discuss that. You're right. Right, thanks.
Thank you. So I'm at paragraph 3.12, and that's really the last point I want to touch on in terms of scope. And this is the way in which the motor machinist case dealt with extensions to the spatial area covered by a plan change. And the court found there that the tests I've just outlined won't altogether exclude zoning extensions by submission. However, it would be limited to incidental or consequential extensions, provided that no substantial further Section 32 analysis is required to inform affected persons of the comparative merits. And I think the motor machinist case, it was about 10. The extension was requested in submissions to a site about 10 sections away from the edge of the plan change. And I think in that case, the court confirmed that that was too far. Now, there's not I don't think anyone's ever proposed a hard spatial, limit in terms of number of meters or number of sections. So it becomes a matter of judgment as to just how far the extension is being sought and the way in which that would relate to the Section 32 analysis that's required.
Yeah, I think that's a fair summary. I think the sort of phraseology is it comes out of left field. And in that case, I think it was an industrially zoned, residentially zoned land in a street some distance away that was to be rezoned industrial. But as Justice Futter mentioned, it's a context, it does a different, bigger project than in motor machinists, but scope still operates. So it's just getting that judgment right. And the planners have explained how they've applied that.
Yes, that's right. And so I think that's a useful thing to step through in terms of that analysis that Mr. Banks and Ms. Maxwell have carried out.
Thank you.
So turning over to Karewarewa Urupā, I'm just going to briefly step through a few key elements of this, if it's useful, starting with the location of where the supply is and then the way in which it's played out. So on page 10 of my submissions, paragraph 4.2, I've included the map that's proposed to show the amendments to the plan in terms of where this Urupā is. So this is in Whakatau, and you'll see there in that map, there is a red shaded area. That's the full extent of the Urupā. It's divided into two components that don't relate to differences in significance of the area. They relate to whether the land is already developed or not. So you'll see there the red area on the right-hand side is Wahangatahi, and that's a largely undeveloped area of land. There are also two other small components on the sort of top left and the bottom. And then the other component is Wahanga. And the restrictions that apply in those areas are different, but in terms of Wahanga, the broad intent is that, well, this land has already been developed. So it would be challenging to apply exactly the same rules to that area as the other. For further context, the Environment Court direct referral that I mentioned earlier and I've touched on in here is in the piece of land right at the bottom of that picture. You'll see the one right down the bottom where there's a small access way heading to an area that broadens out into an area of land, some of which is covered by the proposed listing for the Urupā. And then you'll see there that just outside that hatched area, to the bottom left of it, there's an area you can see that's undeveloped as well. And it's that whole land there, which carries on slightly further south of this picture, that is the subject of the subdivision consent application and land use consent application that's been directly referred to the Environment Court.
So it's not the development of the Wahanga Rua, the Wahangatahi.
Only in respect of the bottom left part. So it's not the large area to the top right.
The one in the corner at the bottom.
yes, it's only the bottom corner part. So what would be required for that subdivision, and I'm sure the Whakatau Land Company will explain this further, is that there would need to be what's partly a subdivision of land that is within Wahangatahi, and then but that's partly because they need that land to get to the balance of the site that's outside the scope of the proposed Urupā listing. So that's the context within which the discussion has arisen in the Environment Court, because this the consent application was lodged before this plan change was notified, and so as a result of that matter being raised in that context, Mr. Slyfield for the Whakatau Land Company raised it with the court and said, well, we need to understand how this applies, and we've got concerns about vires as well as in terms of the merits about whether this is an Urupā at all. And so that discussion is happening in those two parts. The court has only heard the component relating to vires. Judge Dwyer held a one-day hearing last month on that question, and that's in the context, obviously, of Section 104 of the RMA, where the judge is looking at how much weight should be placed on these provisions. And there's a question mark as to the extent to which the judge will grapple with issues of vires as opposed to issues of merits, because interestingly, this is a situation where, but for that direct referral or any direct declaration application, this matter simply wouldn't get in front of the courts because there's no right of appeal on the IPI. So it's a slightly unusual situation where—
So, can I just clarify? Has the court claimed jurisdiction to declare something about our powers?
Not specifically. What it's the judge has grappled with that question as to whether a declaration is possible. The way it's framed at the moment is the judge has said, well, I need to identify what matters I can consider under Section 104, and the status of this proposed listing is therefore a legal question to be determined in the course of those consent proceedings. And it's not clear at this point the extent to which the judge would look to do that by way of a declaration or simply some findings as to weight. But those are matters that have been raised with the judge as to the bounds of jurisdiction there, and it's a matter that I think is troubling the court as to exactly the way it can approach it. But at this point, we don't have a decision, and it's unclear when that might arise. But the balance of the hearing is not to occur until May or June.
So is there a formal application for a declaration, or did that arise as more of an ancillary aspect of it?
It's not a formal application for a declaration in terms of Section 310, but it's simply a matter that's been raised in the course of those proceedings. And the challenges with broader notification as to if it was a true application for declaration were raised, and so that's part of why the court's wrestling with that particular matter.
So your advice to us is that we, well, of course, the Environment Court may not be the end of the road, because if the court says the rule doesn't have legal effect, for example, then the council has the right to appeal that decision as well. So your advice to us is just to get on with our role, and that may well be the advice, even if whatever the decision of the Environment Court is. It strikes me that this is a type of issue that's been, it's a difficult issue, and it's not going to go away.
Yes, that's right. And I think what is clear is that the merits and vires questions that have been raised by the submitter in this process, they are matters that will need attention through this process and need to be considered, and you're seized of the ability to go through and consider those matters and make findings on them.
And am I right that really the difference between you and Mr. Slyfield is they would not object to the qualifying matter if it only operated to prevent the MDRS standards applying. Their objection is to its net, the net being cast further and operating as a rule with all of the consequences that identification as a wahi tapu causes under the plan instrument. Is that the essence of the dispute?
That's essentially it.
So he would be saying to us, have no problem with the idea that it's a qualifying matter to prevent the MDRS applying. Our problem lies with its wider implications.
Yes, that's essentially it. And so that narrows down, as I understand it, the scope of matters that you might need to consider, because there doesn't seem to be any dispute that you can add a new qualifying matter. The question is, what's the effect of that? And if I think about it visually, I think, okay, the existing plan would allow this amount of development. The MDRS would bring that up to a level up here. Now, Mr. Slyfield's argument is that the qualifying matter that's added can bring the development down to exactly where the district plan currently allows. But in this particular case, because the qualifying matter is a matter that triggers more restrictive provisions that are in the operative plan, the effect of listing it would bring the development ability down a bit further. And so essentially there's a question of whether adding a new qualifying matter can trigger those other protections that have been found to be appropriate because of Section 6 matters, or whether there's a bar on making it that restrictive. And I've set out in these submissions the reason why I say it can have the full effect. And I'm quite relaxed as to whether it's useful to take you through that, but I've endeavoured to do so in a way that is logical, so that when you're considering those matters, you've got the benefit of that discussion.
Just as a matter of interest, does this plan change for the area identified as Wahangarua? It's still a qualifying matter in terms of the MDRS, because the view is that given its status as wahi tapu, it's inappropriate for further levels of intensification. So that's my first question. Is that the consequence of identifying the whole area, or at least for Wahangarua?
Yes, and Mr. Banks may be able to assist you in further detail in terms of the precise provisions, if that's useful.
No, it's okay. I just get the sense of it. So, but does the plan change also provide a additional level of protection in Wahangarua in terms of controlling earthworks and things that were not there at the time under the current plan? Is that correct? So that, in other words, both areas have a lift of stringency or impact, but not to the same level.
That's correct.
Right.
So it essentially, yes, it triggers the level of restrictiveness that would apply under the operative plan in those different areas. And the provisions are more restrictive in Wahangatahi than they are in Wahangarua. But in both cases, they're more restrictive than the base residential zone rules.
And in terms of the consultation that occurred for residents within Wahangarua, did Mr. Banks liaise with the landowners and explain what was going on, or did the council?
So, we prepared a full draft of plan change 2, and as part of that, the owners of land in both Wahangatahi and Wahangarua were directly notified of the draft.
Right.
And it was specifically the draft for them pointing out how the provisions would work in relation to their land. And that was at the draft stage, and then again they were notified at the full notification stage as well.
So do we have any other submissions from individuals within Wahangarua?
I believe we do have some submissions.
Yeah.
Within Wahangarua.
Okay. So in that sense, it's not just Mr. Spyfield, it's other people have some concerns about the stringency or not.
Yes, it's fair to say other people have concerns, but if the Whakatau Land Company is the only submitter that has raised the fireys issue.
Right. And just a couple of other questions as we work through. The small one off Mararewa Place that leads to the lagoon, is that a local reserve? And the other question is, I read the Waitangi Tribunal report, and it seems they escalated this as a matter of urgency and produced that report. And as I read it, originally when the landowners sold the land, there was a small quorum and there was issues around the process. But at that time, there was a designation as a Māori cemetery under the Horowhenua district plan. And the Waikanai Land Company applied to remove that on two grounds. Either it wasn't an urapa, or secondly, it wouldn't best serve the purpose of the Town and Country Planning Act to retain that designation. And leaving aside the historical interest of the fact that a designation was used not for a prospective public work, but for essentially a cemetery. The flavour of the Waitangi Tribunal report is that that decision-making was defective. And to some extent, the process was a little bit like many Waitangi Tribunal reports, not about the private individual and what they did to Māori, but what the Crown failed to do. So I'm not sure that Waikanai Land Company were present at that hearing. But there's a sense in which this is seen as slightly different from a situation where a landowner never knew about the existence of an urapa and has purchased land in good faith. And this case where Waikanai Land Company bought land knowing it to be a cemetery, initiated a process to change that designation on incorrect grounds that it wasn't an urapa. And now it's simply going back to recognition and contemporary context of that reality. And I personally would I'd be alive to those distinctions myself, because they all have to go into the mix. And I'm hoping that if there are errors in the Waikanai Land Report, this is a signal over YouTube to Mr. Slyfield, if there are errors in the narrative of the history, we probably do need to know about them, because this is their chance, because they would not have had that chance in the Waitangi Tribunal, but they do have that chance now. And as far as I can tell, subject to vires, we're the last stop shop. So they need to engage with that. I'm not expressing a view about whether it matters or not, or how it would make a difference, because that's for us as a panel to decide. But I'm just signalling that there seems to be a flavour that this is restoring what should have been to a purchaser who knew about its status, and therefore factually different from another situation where, for example, there's an accidental discovery of urapa and so forth. So we'll need to be told about that and process. But is that something that you wanted to comment on in any way, Mr. Conway? Because I've had cause to look at section 6E for other reasons, and it led me back to reading a case of the Court of Appeal in EDS and Monganui County Council, which was when the Town and Country Planning Act had Section 6E, which is the relationship of Māori or tangata whenua to ancestral lands. And the Court of Appeal, Justice Cook and Justice Mullen said that private land interests were relevant, but it didn't exclude it from being ancestral land. And so, typical of Justice Cook, context mattered. And I'm conscious that context could matter here. And currently we have the report, which is a context. But as you know, the Waitangi Tribunal does not investigate the implications for private land. So it doesn't make recommendations to change private land. But there is this sort of shadow effect of the consequences of its determinations. And I'm just interested whether you have any reflections about that. I know it's a complicated question.
Yeah. I suppose the first reflection I'd make is that, yes, I think you're right. This is not a situation where the landowner would have become aware of the potential for this outcome was when it was consulted on this draft plan change because of that history. The other side of that history is that because of the several decades of this being a matter that's been in the consciousness, the landowner has information relevantly that it wishes to present, and I understand it's done that. It's certainly done that in the Environment Court proceedings to address the merits, and likewise Aotearoa Ki Whakarongotai has been very clear in its evidence on those matters too. So those are I suppose the factual matters that can be considered and will need to be weighed by this panel. But in terms of the procedural fairness component, yeah, the lack of a surprise, I think, is probably at least relevant as part of the context. But it is also clear when one looks at the particular development that the landowner wishes to carry out why this matter is so important to it because of the limiting effect of those provisions. So nothing particularly further beyond that.
And so does the Environment Court in that day long, is the council calling evidence from Te Atiawa?
Te Atiawa is a party in its own right in those proceedings, and so it's provided evidence, and that'll be tested in a couple of months' time.
And there is a contest between the Waikanae Land Company and Te Atiawa as to the significance and status of that land?
Yes, that's a core part of it.
Thank you. Well, I did have some questions around the strict legal issue, which is whether this matter is in support of or consequential. So I'd just like to ask you some questions about that, if I may.
Yes.
I think you draw our focus to Section 80 rather than, I think, Section 77 and the limitation on what can be restricted or controlled with the requirement to produce to address the NDRS. So if I just look at those words in Section 80, I'm not quite sure I follow your argument. Like, if you look at 81B, it talks about related provisions that support or are consequential to the NDRS. And then you go on to say, the key question is, first of all, whether or not the provisions can adequately be described as in support of or consequential to the NDRS. And if so, if they fall within these additional related provisions. But I think there's a slightly more expansive potential interpretation, which is and it arises from the words in subsection 2. And it certainly references back to 1B3. With the word in, but I'm not sure that preposition is limiting, because it says related provisions also, and the word also suggests beyond, includes provisions that relate to any of the following without limitation. And that suggests to me that the intention is to slightly untether these matters from what would be described as truly in support of the MDRS, because the MDRS is quite a narrow defined thing. It's the thing in Schedule 3. And I think if we were to tie that to saying, well, is this Part 2 matter in support of the MDRS, it would be hard to say it was. But if you read it slightly more expansively, related provisions and also includes, and without limitation, there's a sense in which slightly untethering it from the MDRS and policy 3 and 4. And that seems to be consistent with your reference to the committee report that said, well, when you're dealing with this whole intensification question, you need some latitude to be dealing with Part 2 matters. And so one possible interpretation of these provisions is that Parliament said, what the MDRS does is such a transformation of the residential zones in the country. We've got to give the council some latitude to look at how their residential zones will operate. And that is why it's expressed itself in quite in slightly broader language in 2. So I guess the slight difference I have at this present point of time in my thinking from you is your somewhat more stringent view about the relationship that 2 must have to 1. And I understand that it does, in a sense, have to have a connection with, but I can't help but feel 2 is slightly more expansive. It's really facing the reality that if you're asking a district to look at the residential zone and the consequences of the MDRS and policy 3 and 4, inevitably you can't lose sight of Part 2, and if that needs to catch up matters, then so be it. And bearing in mind that qualifying matters is a class expressly or preeminently focused on Part 2. So do you have any response to that?
Yes, I think it's a helpful discussion because, as you have picked up, we've focused primarily on the question of whether the inclusion of this qualifying matter in the way it's done supports or is consequential on the MDRS, and we've not claimed it to be in support of, because it's something that essentially does change or limit and reduce the application of the MDRS. But and I have set out, and I can take you through the reasons why we think it is consequential on. But I also am quite comfortable with the interpretation you've posited now in terms of subsection 2, because it does include, as you've said, the word also, which suggests it's something in addition to, rather than something that's tightly within the scope of what's consequential on. And I'd be very comfortable with that interpretation being correct. And the use of the words without limitation, well, I guess we look at those and say they should mean what they say. The reason I suppose we're focused on it a bit about being consequential on is because I think it does provide an additional layer of comfort. So you can see the logical connection. But part of this comes back to an element that's at the core of the difference between our interpretation and that of the land companies, which is how does section 6 and 6E in particular relate to this? And one of the concerns I have is if you apply an approach that says section 77I, which is the bit about removing or reducing the enabling effect of the NDRS based on a qualifying matter. If you say that that's the full extent of what a qualifying matter can do, you're essentially creating two classes of section 6 matters. You'd be creating through a process that's under the standard schedule 1 an ability to fully give effect to part 2 by fully protecting section 6 matters that you've identified, including Whakatau. And then you'd be saying, well, under an IPI, you can only create a Whakatau that reduces the enabling effect of the MDRS, and you can't actually properly protect it. And in the context of provisions that that came into the Act through a piece of amending legislation, it would be too limited a view to say that it's only the purpose of that amending legislation that gives you the perspective on what you can and can't do. Here we need to look more broadly at the purpose of the Act, and the purpose of the Act clearly places Part 2 matters in Section 6 in particular at the heart of it. And therefore, in order to properly give effect to those matters, which all still apply, the interpretation that you can have a more limiting effect in a qualifying matter area than simply the reduction in the enabling effect of the MDRS. To my mind, that's inevitable. You do need to be able to properly give effect to Section 6. And so I think the interpretation you've outlined, where you look at Section 80E2 as enabling without limitation the implementation of a Section 6 matter as a qualifying matter, is entirely consistent with that overall perspective on a view of the RMA here.
Yeah, and I don't know that I would take an antagonistic view to qualifying matters to the extent that Parliament has acknowledged they are necessary to give effect to Part 2, because otherwise the Act loses coherence, because its purpose is to give effect to Part 2. So what you're really saying is, for example, let's take it off topic, in interrogating, as the ISP will force you to do, the residential zone entirely, and see where the MDRS is appropriate, you may discover natural hazards that apply that are not properly addressed in the plan, and in some cases should remove the potential for development. And in doing that, you may actually not only deprive the land of the MDRS, you may deprive it of even its existing development capacity. And that's the sort of example you're talking about, isn't it?
Yes, and I think that's a good example because, and I know we've had pretty significant recent experience nationally of matters like flooding hazard and what happens when things go wrong. But it does strike me, if we look at that as an example, flooding hazard, could it have been Parliament's intention that a council, having identified a further flooding hazard area, is nonetheless bound to enable people to continue to build in that area, albeit at a level lower than the MDRS, but still as enabling as the existing residential zone? Or could Parliament conceivably have thought, well, it's important if that matter has been identified that it's properly provided for? And I think it must be the latter. And so if we see that in the context of flood hazard and the significance of that for potential loss of life and damage to property if intensifications area is enabled in that qualifying matter area, and then we apply that across to other Section 6 matters and Section 6E in particular, I don't see a basis to apply a less stringent view to those matters because the Act clearly places significant importance on them too. So to me, it all points in that same direction. And I guess you'll want to explore this with Mr. Slyfield, because he has a different view on this, that actually 77I is essentially all that a qualifying matter can do. It can only reduce the effect of the MDREs, whereas I would say that section is only going so far as the impact on the MDREs. It's not sum total of what a qualifying matter can do. And the reason for that is a qualifying matter is not only a qualifying matter, it's a section 6 matter in this case. And so the key relevance for the MDRS is as a qualifying matter, but the RMA gives it more relevance in a broader sense and enables you to properly give effect to recognise and provide for, I should say, that section 6 matter. And so a part of that is reducing the enabling effect of the MDRS, and the other part is properly providing for the significance of that matter in the context of the RMA as a whole. So I think that's a more complete view of the way these provisions must work, but I appreciate it's a point that will be debated further in front of you.
So just what's the provision, section 77?
77I. Yes.
Yeah, so which subsection?
So the header of it really is talking about what the council may do, and then it lists the various qualifying matters that might apply. So the first point A, is the matter of national importance under section 6. So that's essentially identifying that section 6 matters can be qualifying matters, and that's not something that's new under the Enabling Housing Act, because there was a very, very similar list already in the NPSUD prior to the enactment of that Enabling Housing Act. So again, to the extent that these are matters that have been given a particular name for the purposes of urban development, it's not a completely new concept. But I think the words that Mr. Slyfield would encourage you to place reliance on are essentially the ones in the CHIPO there, where it says a specified territorial authority may make the MDRS and the relevant building height or density requirements under policy 3 less enabling of development in relation to an area. And so that's the gap. We think back to the gap between the MDRS enabling level up here and the existing residential zone somewhere in the middle. Essentially, I would say the only part that this does is deal with what would otherwise be enabled on top of the residential zone rules by the MDREs, and that this can only speak to that component. It can't speak or put another way, it can't constrain what section 6E would otherwise have you do with section 6E matter.
I suppose the surprising aspect of that interpretation is that the ISP process could be used without rights of appeal, and someone could have section 6 matters substantially alter their rights from existing provisions. So, for example, let's say coastal hazards was a section 6 matter, and the effect of it was not only that you couldn't apply the MDRS, but that you actually couldn't do any further development on your land. On your argument, that's permissible for the council to promote in an ISP, and there is a one-stop shop.
Yes, and I think that is exactly one of the challenges that people face through this process, is the limiting nature of that. But
and so on that topic, is it correct for me, that's a new paradigm, because I'm steeped in the appellate rights. But at another level, it seems to me that we're seeing more of this than other planning processes, that actually Parliament's not seeing the de novo appellate jurisdiction as so much an intrinsically fair part of the process. In other words, other processes. Is there any comment on that? Because that's certainly true of fresh water, which has massive implications for people.
Yes, that's right. Freshwater, the Auckland plan process, the Christchurch plan process, other ones, there are more in the COVID fast track process. They're all, I suppose, processes that have been set up to enable some things that have been deemed quite important to happen quickly and efficiently without being caught up in the courts for a long period. And here, that it's a more drastic step than under those processes, because judicial review is the only right to challenge an outcome. So I think that's right in terms of perhaps a direction of travel that Parliament has looked at. It has identified some processes where it said this is important enough that we're willing to constrain those rights. I suppose if there was a scenario where there was one of these processes used for much broader purposes, it could be more challenging to see the natural justice in that process. Here, I think that the tie back for this particular Whakatau site is perhaps made more crisp in the context that there are specific development plans for it, and there and it's land that the MDRS would otherwise enable further development on. So perhaps that's part of the context, as well as the fact that, as you outlined earlier, there's a long history to the knowledge of at least the debate around whether this is an urupā. So I think that's probably relevant to some of those factors, albeit that not all of the fora for debate of that in the past have been able to involve the landowner.
And just one final question about that. Initially with my reading had been that my assumption was that the application was for the larger area of the Wahangatahi, but you've described it as actually just the small area to the south. Does the Waikanai Land Company, I know they'll speak to this, but does the Waikanai Land Company contest the entire Wahangatahi as urupā, or only the portion that is within the application area?
It is certainly probably a question that's worth putting to Mr. Slyfield. My understanding is that there is a question mark that's been raised by them about the whole thing, but the focus to date, from my purposes, has been on that bottom left-hand corner.
Right. So,
but I guess the same questions would then apply in terms of the constraints it might place on potential development of that larger area.
And I understood also from the Waitangi Tribunal report that is it Mary O'Keefe had done some reports, archaeological reports, and confirmed that it was an urupā?
There is, I'm not as familiar with the details of what each of those things has found, but certainly there has been some archaeological investigation of the site.
Yeah. All right. If you have any further questions. Thank you very much. I think we've covered it. It's been very helpful. So I appreciated that orientation and argument or discussion. So it's probably a good time for morning tea, I think, and everyone to have a break. And then we'll go to Andrew Banks, Mr. Banks, for his presentation. And we'll identify, before we start, we'll identify, I think, some of the key issues that we would like you to think about. All right, so 15 minutes. Come back together. So we're just running a little bit behind time, and we have submitters obviously that we need to respect and make sure we're here at the correct time. So what we'll do is we'll have Mr. Banks and Ms. Maxwell just introduce themselves, and then we'll just give you our shopping list. And then we'll go to submitters. Is that all right?
Okay, Tēnā koe Chair, tēnā koutou to the panel. Ko waio, ko Andrew Banks aho. I'm a planner at Optimistal. I am here to present evidence on behalf of council in response to matters raised by submitters, but I was also involved in the preparation of plan change too. I was the lead planner for the preparation. And with me I have Katie Maxwell, who is the reporting officer looking specifically for rezoning submissions. We had prepared a presentation, but if you're happy to set that aside and just look for just ask us questions, we're really happy to do that. The presentation did cover the preparation of the plan change, the key changes to the district plan, matters raised by submissions, key amendments recommended by us in response to those matters, and then key matters in contention. And that was about half an hour worth of chat.
Yeah. Well, we've got a submitter scheduled for 11 AM. Is that correct, Ham? So unfortunately, I think we should allow you the chance to do that, but not just at this time.
Yeah.
But what we'll do is we'll just quickly identify some things that, and I'll kick off, but my other panel members will have. In terms of in scope, out of scope, Mr. Conway has explained that and refined my thinking about that. And we'll just go through each district or each community at some point and identify these areas and where you've said in scope, out of scope, so that I have a spatial understanding of that better. I'm very interested in the Otaki character identity issue. The reason is that as a partial resident of that community, I'm very familiar with the tangata whenua flavour of that area, and I appreciate that you've tried to examine that in terms of what that would mean for the MDRS in this particular project as opposed to a wider project, but that's an area I want to explore. Coastal hazards and qualifying matter. This is slightly an area I'm also familiar with as having a history of contention. And one of the councillors felt it has had to address this issue because of the job it's been given with the ISP, and I understand that. But there's an underlying concern that there were other processes to run, and it was the cart before the horse, and that echoes concerns of other previous processes. My questions are not technical ones, which I will tentatively address with Mr. Todd and I think Mr. Rush, but more whether a solution to this problem is a time-bound rule. In other words, that the qualifying matter has a life, because a rule can have to apply for a period. And I think the underlying concern is that this process will entrench a line that is still properly up for debate as whether it's a good method or whether it's the right line. And so I'm interested also to explore other alternatives that go to the underlying need, which is around, do we give this qualifying matter a life? So that it's an information component to the plan change that explains it operates as a qualifying matter because of the way the ISP developed, but there'll be another process. Does that make sense?
Absolutely.
My next one is on flood hazards, and it's not really the point that Crew are making, although it's related. Crew's objection is, well, you're focusing on the hazard, which is quite remote, they say, and yet you're ignoring a 1 in 1% AEP in the flood hazard zones. I'm not really so much interested in the comparison as just more generally about the sufficiency of a 1% AEP. And I think that's an issue that's really relevant today, post Gabriel, in terms of where you've struck that balance. What does necessary to give effect to the RPS? Is that level of resilience consistent with the RPS? And is the thinking, well, if we exclude everything, it's going to very much limit the effect, and there are still ongoing issues that need to be addressed about addressing flood hazards. So what is the thinking around that? Kiwi Rail, I'm very interested in your views around Kiwi Rail now that you have the evidence. I'm interested in their propositions. So that, and then the Retirement Association and whether there should be a policy supporting that. And in terms of Kāinga Ora, a little bit of a better feel for me of the unintended consequences of changing the zones as opposed to simply, I mean, the provisions are structured in such a way that accounts as a choice between applying the MDRS to its existing zones or changing its zones, like, and you've followed the overlay precinct approach and the retention of the existing zone. Are there unintended consequences arising? And to give me some examples of practically how that would operate. So how their regime would lead to unintended consequences, if any. I'm not suggesting they do, but I'd just like to get a sense of how you've flagged this issue of unintended consequences. I'd just like to land that in terms of practical examples. So that's my shopping list. Now, Jane, do you?
Yeah, I was just going through my, I would be good to get your presentation if that, because I think just hearing what you think of the key issues is really part of it. I had an issue around character as a qualifying matter, similar as Commissioner, but have that been considered? There's under OTAKis, there's also a question around capacity. I'd like to hear a bit more about capacity, feasible, realisable, actually a bit more on that. I was interested in the discussion on the high density residential and medium density residential as a technique as opposed to precincts, and whether there's national guidance on that matter. I see where you've landed, I get it, but just whether there's what's the national guidance on there, if there was any. I've got a lot of detailed things which I won't, they're quick yes no answers really, but one of them, for example, is the heights for 6 stories of 21 and 20 variably. So I'm not quite sure what that is. That'll be a simple answer. Retirement villages, I had issues around that, and it's also Te Ara Putama as well, because they raise it in relation to the difference in effect between supported housing accommodation and residential accommodation. So and I'm sure they'll Putama will raise this in this too. So what are the effects if you have if it's discretionary restricted above 6 occupants? What in effect is that different from a flat, you know, a large family living in there? And I know our Putama are particularly concerned about the social perceptions of their health. So then I think there's some question. I'm not going to find it now. There's quite a lot of obfuscation, I think, around retirement villages in the language used, residential retirement villages and units, and the distinction between those. And I'm thinking, well, what's the difference between a residential unit and a retirement as opposed to a residential unit in a block of apartments? How they're treated in centre zones and town centre zones, and why not? If you have apartments above ground floor commercial, then it doesn't matter if it's old people or young people. And because of thinking about the importance of people being able to walk everywhere, particularly elderly people. And I'm not sensitive just because of my age. Yeah. Then I had I did notice in the design changes have been made to the design guide. I have a question around the changes that you suggested be made in response to submit a Templeton may have lost some of their effect and meaning. So and that would be a matter of going through those design guides. It's good to get to that point at some point. Well, there's I think it's quite a discussion around the coastal thing, but I think you covered it too, sorry. It's 1541. I did have a question around the criteria you used for scoping and scope in terms of property, just more explanation around those kind of development both. In relation to the Jacob assessment, your paragraph 542, I just quickly reset, you have a look at it. I've got my notes as a holding position. Would it be extensive enough? Is it sufficient? Coastal risk, just as what you'll see when you get there. Yeah, it was in this character around your paragraph 546, being an assessment of character values and areas in Kapiti. It comes up a lot in submissions about the coastal character, not just the coastal edge, but the coastal neighbourhoods. Was there a consideration given to that aspect of character? I think the bottom report changed that. And I think Whakatau East as well. I think that's was that how was that considered? You know, what did you go through to consider that it wouldn't be included? I think that's all of that.
Seems like you got enough questions to last you for the rest of the week. That's why I'm here. I'm guessing I'm going to pick up a lot of my stuff out of some of the discussion here. The main questions I have are sort of higher level things around. There's been a number of references to things like cultural practices and cultural effects that sort of intersect in various different bits of the whole document that you. And I started a list and I got to about 20 and I thought, oh, that's far too many kind of stuff. But they're small but big, you know what I mean? I mean, it's things like how meaningful are some of these things in a cultural context, in a Māori cultural context? It's one thing to say, you know, here we've identified some issues and well, MDS question that we were talking about earlier was a classic for me. I mean, how do you incorporate that, you know, tikanga into that sort of stuff. The Otaki question that my colleague to my left here highlighted is another one that I'd be quite interested to have some conversations on. And even as some of the more not so obvious ones around process, timing, consultation, and all that sort of stuff, there were a number of issues that, I mean, the Hapu of Otaki, for example, you know, they came in, and there's so many unanswered issues there that on the one hand might have arisen out of a timing issue and that sort of stuff, you know, something like which comes first, the egg or the chicken. So, and I might just pick those up as we're going through some of these other questions, issues that my colleagues have highlighted, because they're subsumed in some of these. And there's some questions around Papakainga I'd quite like to have a bit more of a discussion around as well. The Harivel was one, but I think we've sort of got most of the answers I was looking for out of our previous discussion here this morning. Yeah.
Great. All right, so that's your homework.
Yep.
And we-
Dubai.
And we promise to allow you the opportunity to make that presentation. It's just that we'll do it at points where it's sensible to interpose. Because I think Commissioner Black is right that it'd be useful to have that. So if I just move away from you then to the schedule. The first submitter we have is John Harivel. John, would you like to come forward and take a seat? And
Cheers.
we'll have to get a chair for you. Yeah, sure. Thank you. Thanks very much. Thank you. Welcome.
Right, kia ora tato. I'm John Harivel, retired architect with many years' experience in social housing and sustainability. Is the sound okay? Is the sound all right? Yeah, okay. My presentation is a generalized one and touches upon the issues around the need, designated areas, delivery industry, the site, effects on neighbours, the building process, the need for good design and implementation by all the parties, and the implications for KCDC, and related considerations that go beyond just the proposed plan change, but nevertheless need to be addressed to ensure a good outcome for housing intensification. The following quote summarizes the background issues around the legislation for housing intensification. I think it fits quite well. The government legislation is a political process that is misconceived, ignores the complexity and variety of different cities, assumes one size fits all, ignores the effects on neighbours of privacy, sunlight, daylight and landscaping, urban design, and the need for sustainable neighbourhoods. I feel this very much applies to Capity's approach to housing intensification. Regardless of that, I conditionally support housing intensification with safeguards, but it's got to be carried out well to be successful. So why the need for housing intensification? The obvious ones are more efficient use of land, restrict urban suburban spread, reduce reliance on motor cars, reduce influence of roading engineers and subdivision surveyors, improve climate change outcomes, hopefully. Housing intensification is a great opportunity, but it's potentially the next building crisis, unless it's dealt with correctly at all levels. So to use another quote in summary, what's required is a holistic and evidence-based approach to plan and deliver sustainable neighbourhoods that include higher density housing in appropriate locations, linked to transport and infrastructure networks, and that provide a quality compact city that encourages peri-urban sprawl, with development aligned to employment opportunities, better utilisation of current low-rise commercial industrial zones, and uses mixed-use housing opportunities. Moving on to designation areas, I've only got a few comments. I'm very unclear about what the criteria are exactly for declaring certain areas for intensification. And just two examples, one which I have a personal interest in because my elder daughter lives there, is in Queen's Road, and it's proposed to use 6 stories. Really? Do the planners actually realise that there's probably, it's a very steep section where she lives, it's probably equivalent to 3 or 4 stories high, and you're proposing to use 6 stories in that area? Crazy. And it's supposedly linked to a commercial area. There are 3 commercial units there, a dairy, a bakery, and a fish and chip shop, which is only part-time. In Kenna, for example, you're also proposing 6 stories, but it's only on one corner. I don't quite understand why it's on one corner and not on another. And it's limited, and yet you have 6 commercial units there. So my question is, where are the urban design considerations? Where is the 3D modelling to demonstrate effects? Where is the consideration of infrastructure issues? But moving on to delivery and industry issues, and I realise this isn't necessarily directly related to the plan change, but it's very important because there's a distinct lack of industry experience and understanding in all aspects of procurement and delivery of medium and high-rise housing in New Zealand. And I speak from bitter experience by working with Housing Corporation and Wellington City Council Housing Upgrade Project. So the poor understanding of urban design, poor understanding of building medium and high-rise residential development, there's a poor understanding of the role of developers, there's a poor understanding of construction issues around fire and sound separation, and there's a poor understanding among the trades involved in what's needs to be done in terms of multi-occupancy buildings. There's a poor understanding of consent requirements and particularly the enforcement of consent and site oversight by council. And again, I can verify this through personal experience. The legal issues involved in private multi-ownership of buildings are horrendous. As somebody who's worked in Glasgow for many years on tenements can attest, it's horrendous to try and get people to agree to improve common parts of their buildings or repair them in the long term. So consider some practical site issues, which I don't think are addressed. Infrastructure capability. I don't quite get where the infrastructure capability is related to these zones. For example, in the horse paddock, where I think there's 134 units proposed, that's on Kapiti Road. I don't know what the conditions are in terms of the main pipes, but assuming that somebody had to put in a completely new sewer system, who's actually paying for that? And presumably they're not just paying for the developers, not just paying for the immediate connections. In terms of hard landscape and increased runoff, especially in view of recent cyclone damage, most of these developments, and if we look at particular examples of what's been completed to date, and I'm not clear exactly under what conditions these have done, because a lot of them are in commercial zones, but if you look at Kapiti Road, you've got road access, you've got units, and then you've got very small decks at the back. There's very little hard, soft landscape there. It's nearly all hard landscape, so there's very few porous surfaces. There seem to be no minimum standards for dwelling size or visual separation distances between buildings. So if you consider the effects on existing neighbours, which I don't think are met at all, especially during construction, and again, I can testify from a very practical experience, there's damage from dust, piling, and tracked machines. So there should be restrictions required in terms of the consents. In the long term, there's huge issues around reduced privacy and overlooking, not just to the new units, but to the existing ones. For example, in Raumati, there's a scheme of 2 blocks of townhouses, which are separated by 6 meters, bedrooms looking directly into each other. There's obviously problems of the lack of solar access and daylight and shading. And a classic example is McLean Street, where currently there's a scheme 3 stories high next to the beach villas, and they're only 2 meters apart, less than 2 meters apart from this blank wall. I mean, how is that allowed to happen? It's crazy. There's a danger of a lack of diversity of house types and hence sustainable communities. If you look at Hakia Street, which is under construction at the moment, it appears to be all 2-story, 2 beds. Therefore, there's going to be a predominance of the same sort of occupants. And this is not good for long-term sustainability. There's also a severe issue of the lack of communal space. If you think of Kapiti Road, there's virtually no communal space at all. There's a tiny little bit at the front, which I think is car parking. And again, something that's never been considered is the effects of changing wind patterns due to the proximity of high-rise buildings creating turbulence at street level. Again, I can attest to some very practical examples of this. So if you consider the building issues, there's huge problems about fire and acoustic separation on site around vented cavities, the lack of fire barriers and fire stops. The deemed to satisfy requirement, which is gleefully signed off by the consents people, but is never actually tested on site. We have no sound testing, for example. So all these deemed to satisfy specifications probably don't meet the requirements in actual practice. I mean, we know, for example, in insulation, if you test a building for insulation in terms of what's actually been installed, you'll find there's huge gaps and it doesn't actually comply. There are huge problems around service penetration and issues involved. Weather tightness issues are increasingly going to be a problem due to increased height and exposure of buildings. Many of these buildings are actually within the coastal hazard zone, and yet they seem to take no account of this. Height brings different issues of unfamiliar construction, steel, concrete, and LVL to a limited extent. There's evacuation and fire brigade access requirements and equipment. To actually have a turntable ladder in Capri can reach 6 stories. I doubt it very much. Lifts and 4 stories and above, and all sorts of extra things that are required in high-rise buildings, and the number of escape routes. We just need to mention Grenville Towers, which is a fire caused by a stove going on fire. And I think that was a 20-story building and the effects of that. And the other issue, which isn't really dealt with at all, is the legal issues due to private multi-ownership, ongoing maintenance repairs. So it's essentially, to make this work, it needs good design and the consideration of a lot of factors not dealt with in the plan change. And I list all of these, from solar access, etc., privacy, and all the rest of it. And the good outcomes need a combination of all these things. They need good developers, good development, good standards, good construction, good compliance, and a good regime for ongoing maintenance and repair. And considering the implications for KCDC, there's a huge need to upscale staff to understand what the issues are involved when they look at applications, for in-house expertise to evaluate these properly, to improve the compliance regime, especially on site. There are lots of consents, but very rarely are they actually enforced. And there's a huge need to change the building envelope requirements to allow for minimum requirement for solar access for buildings. I mean, the current requirements are so simplistic to be absolutely ridiculous. I mean, the sun doesn't follow the paths that the building envelope dictate. So you've got to change that dramatically. And you've got to increase the understanding of solar access. There's a need to understand, or there's certainly a need for facade engineering when you're going higher, and issues due to increased height and exposure. And you've got to understand the fire design issues resulting from increased height, and enforce the consent conditions during construction to reduce damage to neighbours. I don't think that's dealt with anywhere as far as I can see. Enforce consent conditions during construction to ensure that construction actually meets the consent conditions. And this is particularly so around subcontractors, because they have no idea about sound transmission, whether it's airborne or impact. And so all sorts of services get whacked through without any understanding of how you maintain these details on site. And there's definitely a need to insist the provision of a body corporate to ensure future repairs and maintenance. You only have to look at the leaky building problem to realize how horrendous it is. We have friends who are still trying to get their building improved because they're of existing owners and all the problems, etc. There's a need to ensure diverse housing types and sustainable communities. Otherwise, you're going to end up with a whole lot of ghettos. And there's a need to ensure applicants produce 3D modelling to ensure they understand the effects of this. And I'm very disappointed that in the council's submissions, there is no thought given to actually what the effect of 3D modelling would have on the areas that they're proposing, that would give a better understanding of what the effects would be. And lastly, although I'm not necessarily in favour of design panels per se, I think a design panel with powers at the preliminary design stage would help obtain better solutions. Otherwise, it's going to be another disaster like the leaky building problem. Thank you.
Thank you very much. I'll just check if there are any questions. Do you have any questions?
I'm trying to pull up maps at the same time. You're talking about Queen, your daughter's property. Is that in the Whakatau beach?
Yeah,
area?
it's where the old beach bakery is.
So I understood that was 4 stories. That
Well, it may well have changed, but the original documentation I saw proposed 6 stories.
I just what I've got here is up to 15. Whakatau Beach local centre zone up to 15 metres, 4 stories. But
Okay.
but your point would
That's still
still
a
be
problem because it's a hell of a steep site, and to put another 4 stories on top of that, I mean, it depends where you count where the ground level is, obviously. You know, is it the bottom of the site, the middle of the site, wherever you start building?
Yeah.
I just think there's a disconnect between some of the physical reality on the ground and what's being proposed.
Yeah.
And I don't understand why there's a high density around what is essentially 3, possibly 2.5 commercial units. You know, that it seems to be quite extensive, whereas in other areas it isn't so extensive.
It's the result of the government. Yeah, thank you. Thank you.
Yeah, I don't really have any questions, but just a couple of observations. I mean, the points you make are well made and well taken. And if you look at things like the issue raised around being car dependent and the planning not being able to, I guess, clearly or obviously deal with that. The question I always have in my mind is, how do you deal with it? And what sorts of things as an architect? Man, identifying the problem is one thing. Suggesting how we might actually deal with it is may well be quite another. In the local context, and I'm not from here, so I don't know the area that well. But if that were to be a key issue, how would you suggest?
Well, obviously, if you're locating the high rise near transport nodes, you have less need for a car because hopefully you're using public transport. And if you improve the public transport links, like the bus links, or you have a different system of bus links that's on demand, then presumably, and you've got cycleways, etc., then people will be encouraged to use these more. I mean, I think it's a bit like smoking, isn't it? It's got to become a state of mind where people think it actually is a bad thing to smoke, so it's a bad thing to use their cars. And it takes a lot of time and several generations to get through that, but it's going to have to happen. Yeah. I mean, I live out at Otahanga and I don't have a public transport system nearby at all, so I have to use my car. I have a cycleway and I do cycle, but you know, it's not the easiest of things. But that's part of the problem. We're building these subdivisions which are car dependent, which have huge roads. I mean, you take Kutuku Park, it's got 11-meter wide roads, 8-meter wide roads, it's got huge service zones. Do you ever see anybody walking there? No, of course you don't. They're all in a bloody car.
And just one other thing that caught my attention when you were going through the Kena issue that you raised here, sort of 6-story in one corner, nothing on the others. Can you elaborate a wee bit on that?
Well, as I read I mean, there's a hell of a lot of information that's never got to absorb, but as I understood it, it was proposed to build 6 stories on one part of the area and not another. I didn't understand what the logic was. Why would you build just on one part and not the other? And yet in the cabin, in the Whakatau bit at Old Beach Bakery, you've got 6-story, or maybe it's 4-story, around the whole area. I don't understand how, what I'm saying is, how has it been decided that these are the specific sites that will be developed for higher rise building, particularly in the context of scale and understanding urban design and how it affects other buildings. I mean, the classic one, if you think about it in Auckland and Herne Bay, which was years ago, you've got this circular multi-story building right next to a historic villa. I mean, how they ever managed to decide that? And if you had a church, for example, of Marae, would you allow, you know, intense development right up to the boundary?
Well, that was in the back of my mind.
Yeah, I mean, there should be, okay, it's about good design and good designers understanding what the issues are, but you've also got to steer these people in the right direction. And they've got to understand the scale they're building it and relate to the area that they're building in. I mean, you take the development in McLean Street, 3-story stuff, it's completely out of context. And yet with a good architect, you could have actually designed that well, so that it actually fitted in better by maybe reducing some of the scale or adding extra features to it, instead of this huge block with a pitch roof.
So you know, a retired architect that could do the job.
Well, I do live in a solar passive design house with the grass roof, so I'm doing my bit.
Thank you.
Thank you very much,
Thank
Mr.
you.
Harivel. Now, Leith Consulting.
I think this one. I haven't heard it.
Welcome.
Thank you. Kia ora, Commissioners. Thanks for this opportunity to speak in support of our submission. My name is Louise White and I'm a planner at Leith Consulting. Leith Consulting prepare a range of planning applications for the Kapiti area and Harivel and also the Wellington wider region as well. I note that the Council Officer's Section 42 report, 42A report adopted in full or in part our relief sought on a range of matters in our primary submission. Where they rejected our relief sought or in relation to our further submission points, we accept this outcome based on reasons given in the Planning Officer's report. My submitted statement was provided to the panel before this hearing, so I hope you've had time to have a look at that. And it highlights two matters we believe should be reconsidered, which relates to hydraulic neutrality for land use consent applications, not just at the time of subdivision, and the list of matters of discretion for height encroachments for buildings exceeding 12 metres in the town centre zone. So I'll talk about hydraulic neutrality first. For hydraulic neutrality, we recommended in our relief sought that a new rule for land use be included in the infrastructure chapter, which clearly sets out the standards for hydraulic neutrality. In the Council's 42A report, they rejected this and said that hydraulic neutrality was provided in the district-wide subdivision standards and considered that it wasn't necessary to have a land use consent rule for that approach. For hydraulic neutrality, someone giving effect, for an example, hydraulic neutrality, someone giving effect to the NDRS standards without needing a resource consent would be required to comply with the infrastructure rule, which is INF menu-R12 in the infrastructure chapter, which requires permitted activities to be undertaken in accordance with the Council's land development minimum requirements. In this land development minimum requirements document on page 56, under the heading performance criteria, it references the requirement to that development must achieve hydraulic neutrality up to a 1 in 100 year design rainfall event. I consider a matter of this level of importance to be a clear rule in the district plan for land use consent, or when you're applying, the permitted activity criteria. The planner has considered important enough to be a rule for subdivision purposes. I consider the same should be considered for permitted land use activities. So a clear rule in the district plan upfront which says that you must achieve hydraulic neutrality for applications. For example, you could buy a bit of land and it be a permitted activity with 3 houses on that plot of land under the NDRS rules. And just making it clear upfront in a rule rather than buried in a document incorporated by reference, I consider quite an important element, especially given all the flooding and stormwater issues of late.
Just clarifying that, you're saying that there is a clear rule for subdivision?
There are a couple of rules which require hydraulic neutrality.
Yeah.
They've got the standards in the subdivision rules, district-wide rules.
Right.
Yeah.
And does that refer to a document by reference?
No,
as
that
well?
actually states the hydraulic neutrality requirement.
And that's defined
And that's defined,
as the
in
1
that
in
rule.
100.
It defines it in the different stages, like 1%, 2%, up to 1 in 100 year flood event.
So you're promoting a rule if the development occurs without subdivision,
Yes, yeah.
and you see that as more important now because of the liberality of development potential arising from the NDRS.
Correct.
But why did you say find it in a document incorporated by reference? What is that?
What I meant was that currently, as the district plan currently stands, there is a rule in the infrastructure chapter which requires any development to comply with the council's land development minimum requirements. And in that document, it has reference to hydraulic neutrality. So technically you have to comply with that document for any development. So it is captured there in the district plan, but I'm saying such an important element shouldn't just be in a document incorporated by reference. It should be upfront in the district plan.
And so what do you see as a consultant as the problem with the current regime, and how will it be exacerbated with the NDRS?
I think it's the council do have the that land development minimum requirement document, so you do have to comply with hydraulic neutrality. So that is captured. I just would like it clearer in the district plan, just as it is in the subdivision chapter. So I think they have covered it, and they have got standards in place to capture stormwater issues for medium density developments or high density developments. But I just wanted to have it clear up front, and potentially the infrastructure chapter that requires at the land use consent stage or building consent stage to comply with hydraulic neutrality, just make it clear.
And why do you single out hydraulic neutrality as opposed to other more important, equally important matters in the land development standards?
I think because it's in the subdivision chapter, so it's obviously made it as an important element to be put in the subdivision district-wide chapter. So I thought equally, and it comes up quite a lot with development, like every development has to achieve hydraulic neutrality. So I thought having that as a standalone rule would be a good requirement to have. Yeah.
Okay.
And potentially there would have been, there could be, I don't know if there's scope to include other important elements in the land development and requirements, but as a consultant, hydraulic neutrality always comes up as one of the most important matters. So that's why it was in my mind when I was looking at the amendments, rather than other things that might be in the land development minimum requirements. Yeah.
Yep, I understand that.
And especially since there's a lot of sites in Kapiti that are subject to like ponding, there is issues with achieving hydraulic neutrality. So that's why I thought this was quite an important issue to be clearly defined in a rule for land use.
Okay.
Oh, and for the other matter. Which is, I think, height in relation to boundary. Yes, the height encroachment rule in the town centre. So we submitted that the rule should be enabling, and we accept the council officer's recommendation that it is enabling being a restricted discretionary activity, being able to go up to 21 metres in height. We would just suggest that the potentially 13 matters of discretion could be reduced to give effect to policy 3 of the National Policy Statement for Urban Development, better give effect to that. There's 13 at the moment, and I think reducing that to matters in relation to urban design, more urban design and form would provide more of an enabling pathway, consent pathway for a height breach in those areas.
But wouldn't you also have to not have an eye to the fact that the matters of control fall off the matters of discretion as well?
What do you mean, sorry?
So I'm not quite sure I've got the rule in mind, but with an RD, a matter of discretion also becomes a legitimate matter of control by conditions and so forth. So perhaps the list is that long because of all those matters.
I think some of the matters are probably dealt with in other chapters of the district plan, like, for example, one of the matters of control are traffic and transport effects of a height encroachment. So I'm just trying to understand the relationship between the height breach and some of these matters of discretion that are listed, noting that they are already in the district plan. They haven't been introduced, they're that are existing at the moment for height encroachments. So,
Yeah, well, it'd be interesting to get Mr. Banks' view on that, but perhaps one reason is that it's just the plan wasn't designed with that level of development in mind, and perhaps to capture a holistic assessment, it was easier to have a full suite of matters of discretion.
potentially at that time, and I just think moving forward with the MDRS and the National Policy Statement for Urban Development, that this long list could be consolidated, and there seems to be a little bit of repetition in it. So noting that this list, the matters of discretion, are also repeated, and not just the town centre zone, but the medium density zone, the mixed use zone and the local centre zone. So any changes to this list would probably have to flow into those chapters as well, whether there's scope to do that. I'm not sure. But
we may not be affected by scope quite as much as usual, but
yeah. So for example, one of the matters of discretion are number 13 is the consistency with the relevant objectives and policies. I just think there's a bit of a repetition because you have to make that assessment anyway. So and public safety is another one, and nuisance effects. I think potentially there's an opportunity to consolidate this list of just better reflect a height encroachment. It may mean that the rules are reconfigured slightly. So I think the way it's set up, it relates to other restricted discretionary activities as well, potentially. So, but if the panel would just like to consider consolidating that list to provide a clearer pathway for restricted discretionary activities, encroachments.
Did you, in the course of engaging with this plan change process, look at the proposals from Kāinga Ora?
No, I haven't read. Yeah, I know it's quite extensive.
Yeah,
the level of rezoning and height increases that they want, though.
right. In terms of the way in which the council has promoted this implementation of the MDRS and so forth, and the precincts and all of that sort of thing, does that all work logically in your mind as a plan user? Like, can you understand how they've implemented those requirements in the way they have?
Yes, I think it's quite logical. I haven't done I suppose I haven't looked from it works. It does work in terms of implementing the district plan. I haven't looked at certain sites or anything to see if they would be could be more enabling or not, like probably Kāinga Ora has done. But my only suggestion would be that maybe the general residential zone is called the medium density residential zone, to make it clearer that that's what is provided for that zone, if the planners have already considered that. I know other district plans have done that. Just change the general residential at the moment.
Right. Okay. Thank you. Well, it's very helpful. Thank you. Thanks for your participation. And obviously, a number of your ideas have already emerged as successful.
Yes, and just commend the council on their section 42A reports and the tables that broke down the submissions and their recommendations. It was very clear and easy to follow. So
great.
Yeah.
Thank you.
Right. Thank you.
Now, Mandy Savage. Welcome.
Kia ora. My name is Mandy Savage and I'm representing the Cancer Society. I'm the Senior Health Promotions Coordinator and Centre Coordinator for the Kapiti Support Centre, part of the Cancer Society's Wellington Division. Today, I'd like to speak to two aspects of our written submission, namely our recommendations for the Centre's Design Guide and our recommendations for the Residential Design Guide. The Cancer Society applauds KCDC's commitment to improving shade and shade structures in our community, as evidenced by the shade installations at Masengard Reserve, continued tree planting in our parks and playgrounds, and the improved built shade structures at the revitalised Mahara Place in Whakatau. We acknowledge that you are taking the well-being of our community seriously, as this is indeed an important public health issue. In New Zealand, skin cancer is by far the most common cancer type. It's estimated that there are around 90,000 cases of non-melanoma skin cancer and around 2,500 cases of melanoma diagnosed in Aotearoa each year. Exposure to ultraviolet radiation, whether from sun or artificial sources such as sunbeds, causes skin cancer. Around 90% of these skin cancer cases are preventable. The Cancer Society applaud KCDC for acknowledging the necessity of shade provision in its planning guides. The Cancer Society supports the rezoning of areas listed to residential zones, general residential zones, with built and natural shade an integral part of any new development or neighbourhood. The proposed residential design guide and centre design guide provides opportunities to enhance community wellbeing in the following ways. Plan for the needs of cyclists and pedestrians in all new developments. Provide additional recreation spaces in our community. KCDC is also in a unique position to ensure that sun protection options are provided in all new housing developments and shared outdoor public spaces. This is particularly with respect to built and natural shade. In recent years, much effort has gone into encouraging personal sun safety behaviour. All the messaging on sun safety encourages people to use shade, but if it's not available, then it is not possible. Shade is one of the most effective forms of sun protection. Good quality shade can reduce an individual's UV exposure by 75%. In terms of the residential design guide, we support the need for deciduous trees to ensure summer shade and light in winter. We encourage the use of eaves to limit the duration of sunlight penetration in summer so indoor spaces don't overheat. Planned planting can improve the design of neighbourhoods and help reduce the urban heat island effect. We recommend the use of impermeable surfaces to manage and dispose of off-site stormwater. The use of permeable paving in locations such as parking spaces or areas is encouraged. The Cancer Society strongly advises that in any new subdivision, the developer be required to include adequate tree planting. We acknowledge that there are infrastructure issues such as tree roots, which can disturb water or gas pipes, but these can be mitigated. Australian research suggests trees can actually lessen stormwater management costs by reducing the need to construct additional retention, detention, and treatment capacity. Additional Australian research found that broadleaf evergreen trees provided an interception rate of 60%, thus reducing runoff volumes and delaying the onset of those peak flows from the rainfall. As part of the consent process, property developers should also be required to include and develop adequate public green spaces in any new subdivision or extension of an existing subdivision, not just adding a pocket park with a swing. These green spaces should include natural shade and seating. If anything, the recent floods in Auckland have taught us that the more we build, the more stormwater we need to drain. Each new building or road replaces the planet's natural stormwater system, plants and soils, and channels for runoff. Trees can help future-proof current growth against future temperature rises and climate change. In terms of the Centre's design guide, the Cancer Society supports improved connectivity and opportunities for our communities to use active transport. We support improved shade provision, both built and natural, in our local public spaces and town centres to make the commute healthier in terms of UVR protection and more attractive. The provision for both built and natural shade at transport hubs provides sun protection while waiting for public transport. The presence of trees encourages people to walk for both exercise and transport. This promotes physical and mental health and well-being. Adequate trees are not only visually attractive, but can help cool our urban areas, reduce greenhouse gas emissions, enhance the mode of land and water, enhance biodiversity, and improve public health and well-being. Tree canopies can reduce the temperature of the surfaces they shade by as much as 10 to 25 degrees. In Kapiti town centres, as with our residential neighbourhoods, access to shade is an equity issue. The Cancer Society Wellington Division requests that increasing shade in our lower socio-economic status neighbourhoods be made a priority. Tree canopy mapping, as in other areas, would enable a priority planting program. Thank you for the opportunity to speak with you today.
Thank you, Ms. Savage. Let's just check if there's anyone got any questions.
Did you think the design guides, that they do require vegetation,
Absolutely.
possibly for other reasons? Are you suggesting that it needs to be more specific in relation to the vegetation for the purpose of shade?
Yeah, it's got to be the right tree in the right place. It's got to provide that summer shade and ideally shed in the winter. I recognise that there would be problems with, removing leaves, whatever else. But the advantages of planting trees is demonstrated, particularly in the States and in Australia. They more than pay for themselves. If you put the right tree in the right place.
Okay, I just want to also think whether it's more of a building act, not the trees necessarily, but when it's structures. That's more of a building act requirement.
Sure,
thank you.
I just have one question. Indigenous trees.
Yes.
Talk to me about. Are they the kind of? You're talking about specific kinds of trees.
Yes, 100%.
Yeah.
So I'm a health promoter. I have no background in horticulture or town planning, but I do know that particularly your Indigenous species hold more carbon. They provide more benefits in terms of providing shade in your subdivision, the right shade in the right place, and also with regards to your town centre plan. So that is what we would promote. Yes.
No, that's it. Thanks.
Thank you very much. Now, John Baldwin for Kapiti Cycling Action.
You've got a different program for you.
Oh. Right.
We've got that we've now got, we're not lunch till 20 to 1.
So let's do the presentation.
Keep your toes jumping.
Thank you. That's good.
It's like a couple of slides. And to the next one. Kia ora koutou. Because I've already given you the outline, I won't labour on stuff we've already talked about. I will do a bit of talking, but I will hand over to
So I'm just going to start in front of you here is the timetable that shows the development of PC2 from late 2021 through to notification in August 2022. The development of PC2 progressed from the council's work on the development of Te Tupu Pai, the district growth strategy. Te Tupu Pai was developed under the Local Government Act through engagement with the community throughout 2021 and adopted by the council at the beginning of 2022. So it sets out strategic goals and implementation methods for sustainable growth and development in the district. And because of the timing of its development, it incorporated high-level direction for how the council intended to give effect to policy 3 of the NPSUD. So then at the end of 2021, the government promulgated and then quickly passed the Resource Management Enabling Housing Supply and Other Matters Amendment Act, which ultimately set the scope of PC2. So following this, in the first 3 months of 2022, we prepared a full draft of the plan change. This draft was released for public consultation for 5 weeks over April and early May. And over 200 submissions were received on the draft. These were considered and PC2 was subsequently refined in response to those submissions. And then the council approved notification of PC2 at the end of July, and then it was duly notified on the 18th of August. Council engaged with iwi throughout the development of PC2, and on behalf of council, I wish to acknowledge the significant mahi of Ngāti Toa Rangatira, Te Atiawa Ki Whakarongotai and Ngā Hapo o Taki, including through hui and feedback throughout the development of PC2, their extensive work on the development of the Papakainga provisions, and their detailed submissions on both the draft and notified versions of the plan change. So I'll now summarise the key changes to the district plan proposed by notified PC2 as set out in the Section 32 evaluation report. So firstly, PC2 amends the district plan to incorporate the medium density residential standards. The MDRS are required to be incorporated into every relevant residential zone, which in the case of the operative district plan means the general residential zone. PC2 amends the rules for subdivision, use and development in the general residential zone so that they are consistent with the requirements, conditions and permissions set out in Schedule 3A to the RMA. PC2 also amends the district plan to give effect to Policy 3 of the MPSUD. It does this by firstly enabling increased building heights within the operative metropolitan, town and local centre zones, commensurate with their position within the operative district plan centres hierarchy. Secondly, it enables increased building heights within a walkable catchment of the metropolitan centre zone at Paraparamu, the train stations on the Kapiti line at Paikakariki, Paraparamu and Waikanai, and areas adjacent to town and local centre zones throughout the district. As part of incorporating the MDRS and giving effect to Policy 3, PC2 proposes several supporting or consequential amendments, which include amendments to objectives, policies and rules and other provisions throughout the plan, where these are inconsistent with the requirement to incorporate the MDRS or give effect to Policy 3, replacing existing design guides with the new residential incentives design guides, rezoning several sites throughout the district as general residential zone, and updating reference to the council's land development minimum requirements document. This document outlines a range of requirements for the design and construction of infrastructure as part of subdivision and development within the district. PC2 also recognises and provides for a range of qualifying matters. So functionally, qualifying matters are provisions that have the effect of making the district plan less enabling of development than otherwise required by the MDRS or Policy 3 of the MPSUD in relation to a specific area. Existing qualifying matters are ones that are already provided for in the operative district plan. So PC2 ensures that these provisions continue to apply. So a good example of this are the operative district plan flood hazard provisions. I explain these in detail in 4.10.1 of my evidence. However, in summary, the district plan identifies flood hazard areas throughout the district, which are mapped in categories according to their level of risk. In lower risk areas, such as ponding areas, existing rules require, amongst other things, the construction of new building floor levels above the 1% annual exceedance probability flood levels, and restrict the amount of earthworks that can be undertaken. In high risk areas, however, such as overflow paths, new development is generally sought to be avoided through rules that prescribe new buildings as a non-complying activity. So these rules override those of the underlying zone and will continue to restrict development regardless of whether the MDRS or Policy 3 are incorporated into the underlying zone. So the range of existing qualifying matters provided for by PC2 are set out in Appendix D to the Section 32 report. PC2 also provides for 3 new qualifying matters. Firstly, and in no particular order, PC2 provides for a coastal qualifying matter precinct. The precinct covers parts of the district that have been identified as being potentially susceptible to coastal erosion hazard. Its purpose is to identify the area within which the level of subdivision development, otherwise required by the NDRS and Policy 3, will not be enabled until the management of this hazard is addressed through a future plan change. It achieves this not by applying new restrictions, but by maintaining the status quo in this area. Preparation for this future plan change is progressing as part of the Takutai Kapiti Coastal Adaptation Project. Secondly, PC2 adds Karewerewa Urupa to the schedule of sites of significance to Māori. Karewerewa is located in the general residential zone at Waikanai Beach. Incorporating Karewerewa into the schedule recognises the significance of the area as a wahitapu to tangata whenua, including Te Atiawa ki Whakarongotai. And thirdly, PC2 incorporates a marae takiwā precinct into the plan. This precinct recognises that marae and the tikanga and kawa associated with them are sensitive to the impacts of surrounding intensification by restricting intensification on areas adjacent to Raukawa and Whakarongotai marae. A significant component of PC2 are the amendments to the district plan to enable the development of papakainga. These provisions are the result of extensive work undertaken with and by tangata whenua through Ngāti Toa Rangatira, Ngā Hapua o Taki and Te Atiawa ki Whakarongotai. As part of PC2, papakainga are defined as housing and any ancillary activities, including social, cultural, educational, recreational or commercial activities for tangata whenua on their ancestral land. While this definition recognises that housing is a key component of a papakainga, the purpose and value of papakainga to tangata whenua is articulated in the objectives for papakainga, which describe papakainga as a taonga that provide for tangata whenua to maintain and enhance their relationship with their ancestral land and achieve a thriving whānau hapu or iwi community. PC2 incorporates a district-wide set of objectives and policies for papakainga and embeds rules within the general residential, town centre, future urban and rural zone chapters that provide for their development. Finally, PC2 proposes some general amendments to the financial contributions provisions to better align them with the requirements of Section 108 of the RMA. Council currently collects the majority of contributions for infrastructure development through development contributions under the Local Government Act. While the operative district plan includes a policy that provides for council to take financial contributions for infrastructure in circumstances where the development contributions policy may not apply, there are actually no rules or standards in the operative plan that guide how contributions in these instances would be determined. In addition to this, there is no policy or standards to provide for the taking of financial contributions for the purposes of offsetting or compensation, where this is considered to be appropriate in the circumstances. The amendments to the financial contributions provisions address these gaps. I'll now outline what we consider to be the key matters raised by submitters on PC2. So tangata whenua groups, including Te Atiawa ki Whakarongotai, Te Runanga o Toa Rangatira, Ngā Hapua o Taki, Ngāti Haumi e Tupai Kakariki, and the Arts Confederation, provided detailed submissions on PC2. Matters raised in the submissions of tangata whenua include the ability for tangata whenua to meaningfully participate in all aspects of the plan change, the approach to incorporating the MDRS and giving effect to Policy 3, including at Otaki, concern that reduced protection of existing amenity values in urban environments will lead to reduced protection or recognition of cultural values, the ability for infrastructure and the environment more broadly to adequately provide for increased levels of development, recognition of sites and areas of significance to Māori, incorporation of tangata whenua values into the design guides and establishing a design review panel process, recognition of tangata whenua within the financial contributions provisions, and support for incorporating Karewerewa Urupa into Schedule 9. Tangata whenua generally support the papakainga provisions, but seek some amendments, including application of the provisions to the metropolitan centre, local centre, and mixed-use zones. There were several notable or recurring matters that were raised by submitters generally. These include general support or opposition to incorporating the MDRS and giving effect to Policy 3, requests to either reduce or increase the level of development enabled by PC2, concerns around the provision of sufficient infrastructure to manage growth. Some submitters sought provisions to enable additional activities, including emergency services facilities, retirement villages, and community corrections activities. Several submitters sought amendments to the subdivision provisions for consistency with the requirements of the NDRS. And submitters both support and oppose incorporating the design guides into the plan. In relation to qualifying matters, there is both support for and opposition to the coastal qualifying matter precinct. Some submitters question the purpose of the precinct and the information used to justify its extent. Submitters also requested that it be expanded to cover large areas of the district or reduced to cover a smaller area. Some submitters question the lack of recognition of natural character in the coastal environment as a qualifying matter. And submitters question the lack of recognition of the beach residential precincts, which are special character areas in the operative district plan as a qualifying matter. Submitters also supported and opposed incorporating Karewerewa into Schedule 9 of the plan.
Just as a matter of interest on that beach precinct, how do those precincts meaningfully survive the MDRS?
So they, the MDRS and Policy 3, the rules that permit development in those areas apply. And consequently, the existing rules for those areas that permitted less development than that have been removed. The policies for those areas have been significantly amended. The policies are previously focused on variously either protecting or retaining existing character and amenity values in those areas, whereas we've amended those policies to require consideration to be given to certain specified characteristics which are set out in the policies. So that's a switch from maintaining or protecting to consideration be given to. Essentially, the higher order emphasis from that comes from Objective 4 to the MPSUD, which seeks that urban environments develop and change over time, including their amenity values. So that was we read that as direction that at least in urban environments, maintaining or protecting existing amenity values would have been contrary to the objective.
Let's just take the Otaki example. Hi, sorry, just a moment. I'll wait.
Yes, to put urban character in the city residential environment. Yes.
I don't know. Really powerful with some that feels like almost
Did you have any of them?
them.
Or did you want to escape? Sorry? Oh.
I didn't really feel I think that's quite clean.
Yeah.
It wasn't so miserable.
We're related, however.
And of course.
Well, I think that it's she talks something like a terrible summer thing. Where it be? With the correct energy company comes. I was at
Well, yesterday when they even though they are school, so it's keeping like that or something.
Yeah.
So taking note or taking for an example, that had a precinct, I think, because of its special low-key character. Are you saying with the MDRS, there is now obviously going to be a higher level of intensity development. But where discretions are triggered, there's still this policy impact.
That's correct. But it's fair to say that those discretions would only be triggered at densities beyond the MDRS.
Yeah.
Yeah.
Yeah. Okay.
So in relation to rezoning, submitters supported, opposed, or in some cases sought further information on sites proposed to be rezoned by notified PC2. And in addition to this, there were a notable number of submissions seeking to rezone sites throughout the district through submissions on PC2. So in response to matters raised in submissions, we've made several recommendations to amend the provisions of notified PC2. These are set out in full in Appendix A of our evidence, and I'll cover the notable ones here. So in relation to matters raised by tangata whenua, recommendations include expanding the application of the Papakanga provisions so that they apply within the metropolitan centre, local centre and mixed use zones. Improve recognition of places or areas of significance to Māori and natural wetlands across matters of control and discretion in the urban subdivision rules. Adjustments to the boundaries of Whakarongotai Marae and Kārewereba Urupa sites of significance. And we also recommend amendments to improve recognition of tangata whenua within the financial contributions provisions. In response to submissions generally, our recommendations include amendments to district plan strategic direction to better align with the requirement to incorporate the NDRS and give effect to policy 3. Application of public notification preclusions in the centres and mixed use zones consistent with similar notification preclusions required by the NDRS in the general residential zone. In response to several submissions from the survey and land development community, we've made recommendations to simplify the subdivision rule cascade. In relation to qualifying matters, we've recommended expansion of the coastal qualifying matter precinct at Peka Peka Beach to recognise that existing flood hazard provisions do not manage potential coastal inundation in this area. We've also recognised areas mapped as having high or outstanding natural character in the coastal environment in the district plan as a qualifying matter. In all cases, we consider the recommended amendments better achieve the objectives of PC2 and the purpose of the RMA than the notified provisions. So there are several matters that remain in contention, and I'll set out what we consider to be the key matters. In relation to the matters raised by tangata whenua, I note that tangata whenua have sought in various terms broader review of several matters within the district plan, including better recognition of tangata whenua cultural values throughout the plan, review of provisions related to sites and areas of significance to Māori, and development of design guidance specific to tangata whenua. I consider that it would take time to work with tangata whenua to address these matters beyond the time available under the ISPP. However, I emphasise that my recommendations to not incorporate these reviews into PC2 is not a reflection on the merits of these requests. I note that the Council welcomes further discussion with iwi about how they might work together on these matters through ongoing preparation of future plan changes, including the Mana Whenua plan change and coastal environment plan changes. A further matter is the application of the NDRS and Policy 3 at Otaki. As set out in their submission, Ngā Hapu o Otaki consider that the NDRS and Policy 3 should not apply at Otaki, at least for now. In response, I note that Otaki is a Tier 1 urban environment, and as a result, the NDRS must be incorporated and Policy 3 must be given effect to. To avoid this requirement, it would be necessary to demonstrate that there is a qualifying matter that applies across Otaki, and that the appropriate means of accommodating this matter is by avoiding the application of the NDRS and Policy 3. I do not consider that there is such a qualifying matter. Notwithstanding this, I note that PC2 provides for several qualifying matters within spatially defined areas at Otaki, and these will have the effect of restricting development in various ways. These include the Marae Takiwa and coastal qualifying matter precincts, provisions that protect sites and areas of significance to Māori, flood hazard provisions, provisions that protect historic heritage, and provisions that protect scheduled trees and ecological sites throughout Otaki. Additionally, tangata whenua seek that infrastructure capacity is provided for as a qualifying matter. Infrastructure capacity is not listed as a qualifying matter, and as such, it would need to be given consideration as an other qualifying matter. This imports a range of additional statutory requirements. including a requirement to demonstrate why the level of development that must be provided for is inappropriate in light of the objectives of the NPSUD. On this point, Objective 6 of the NPSUD seeks that local authority decisions on urban development are integrated with infrastructure planning and funding decisions. At a district-wide level, this integrated approach is facilitated through the monitoring of infrastructure capacity through the Housing and Business Development Capacity Assessment, which occurs on a 3-yearly basis. If this assessment finds that there is insufficient capacity, then the implementation clauses of the NPSUD direct the council to amend its long-term plan and infrastructure strategy to address this. I note that the current HBA indicates that there is sufficient existing or planned infrastructure capacity to provide for at least 10 years population growth. The district plan itself also includes a range of provisions that provide for integration between development and infrastructure when and where development occurs. This is achieved through provisions that require stormwater, wastewater, potable water supply, and transport infrastructure to be connected to or suitably provided for as part of development. I do not consider that there is sufficient grounds to provide for infrastructure as a qualifying matter, as I consider that integration between urban development and infrastructure planning is provided for through the council's long-term plan and infrastructure strategy, ongoing monitoring of this through the HBA, and through district plan provisions that direct the provision of sufficient infrastructure as part of development as and where it occurs. This is not to dismiss the concerns raised by tangata whenua in relation to infrastructure capacity. Rather, it is, as directed by the NPSUD, the most appropriate place to address these concerns is through the council's long-term plan and infrastructure strategy. So, in relation to general matters, related to the MDRS and Policy 3, some submitters have requested that PC2 be amended to be more enabling of development. A notable submission in this regard is the submission of Kainga Order, which generally seeks to increase density within centre zones and walkable catchments, expand the size of walkable catchments, and amend various other rules and density standards to be more enabling of development. I note that the amendments sought in this regard particularly seek to enable greater levels of higher density apartment development, in other words, development that is denser than the MDRS. A key issue with respect to the amendments sought by Kainga Order is whether they support the district plan to give effect to Policy 3 of the NPSUD. I have to say there was very little reasoning contained in the submission on this matter. My key concern was that the level of enablement sought by Kainga Order without support for its feasibility would lead to uncertainty as to where development would actually occur and risk a diffuse pattern of higher density development that was not focused around centres and rapid transit stops. However, I've read Kainga Order's evidence filed for the hearing, and I recognise that they are now seeking a more refined approach. I'm open-minded to the matters raised by Kainga Order, but wish to listen to submitters before confirming a position in reply. So some submitters have also requested that the design guides proposed by notified PC2 be removed from the plan. There are concerns that the design guides would act as de facto rules and limit flexibility for development and to respond to circumstances. In response, I note that the purpose of the design guides is to provide urban design guidance to encourage high quality development. The guidelines are particularly relevant in the Kapiti Coast context, where there are few existing precedents for the level of development enabled by PC2. I disagree that the design guides are de facto rules. They're not provided for as a rule or an activity standard, and they do not determine activity status. Rather, they're a matter of discretion for restricted discretionary development and function as assessment criteria. As assessment criteria, the design guides recognise that urban design matters are contextual and most effectively addressed in an integrated manner. To provide for this, PC2 amends the district plan to require a design statement to be prepared for resource consent applications where the design guides are relevant. The design statement enables applicants to set out which guidelines are relevant to the proposal and its context and demonstrate how the relevant guidelines have been applied in the circumstances. On this basis, I consider the design guides already provide for the flexibility sought by submitters. From a plan administration perspective, I consider that the design guides will improve efficiency for applicants and council officers processing resource consents, as they provide greater certainty for a common framework of assessing consent applications in relation to urban design matters. These benefits would be lost if the design guides were removed from PC2. In relation to qualifying matters, submitters have questioned several aspects of the coastal qualifying matter precinct. Firstly, several submitters have questioned the purpose of the precinct and whether it should in fact be used to address a range of matters in addition to coastal erosion. In response to this, I note that the purpose of the precinct is intentionally narrowly focused on coastal erosion because, as set out in the Section 32 report, the provisions of the operative plan simply do not adequately address this issue. The council and the community are in the process of addressing this issue through the Takutai Kapiti and subsequent coastal environment plan change processes. However, until appropriate provisions to manage coastal erosion hazard are incorporated into the plan, the coastal qualifying matter precinct ensures that the NDRS and Policy 3 are not applied in this area until this matter has been addressed. This approach is a necessary first step to giving effect to Policy 25 of the New Zealand Coastal Policy Statement in relation to coastal erosion hazard, because it avoids enabling intensification in areas that are potentially susceptible to coastal erosion hazard, which may need to be subsequently reversed in order to implement coastal hazard management provisions in this area. Several sources of data were considered in preparation of PC2, and the Jacobs Coastal Hazard Susceptibility and Vulnerability Assessment was found to be the most appropriate source of data in relation to the purpose of the precinct. As set out by Mr. Todd in his evidence, the assessment sets out several scenarios for the potential impact of coastal erosion throughout the district over the next century. These scenarios are calculated based on a robust methodology that has been peer-reviewed by experts. Some submitters consider that it is inappropriate for the council to use this assessment. However, I disagree. I consider that the assessment represents the best available source of information on the potential effects of coastal erosion hazard in the district. The purpose of the assessment is to provide base data to inform district planning processes, and I consider that it has been used for this purpose. In addition to this, the scenario from the Jacobs assessment used by PC2 is consistent with the recommendations set out in the National Adaptation Plan in relation to the consideration of appropriate climate change scenarios for planning purposes. Several submitters have requested that the precinct be defined using alternative sources of information. One source referred to is the Takutai Kapiti adaptation areas. The purpose of the adaptation areas is to identify boundaries to facilitate the Takutai Kapiti community planning process. Alternatively, submitters seek that the precinct is expanded to include all land within the mapped coastal environment in the operative district plan. I consider that neither of these alternatives are justified because it's not clear that all land within these areas is subject to a qualifying matter. Further, whereas the spatial extent of the precinct proposed by PC2 covers approximately 6% of the district's urban environments, extending the precinct to cover the adaptation areas or the mapped coastal environment would have the effect of not incorporating the NDRS or Policy 3 across approximately 50 to 80% of the district's urban environments, respectively. This is a significant change that I consider would be contrary to the narrowly focused purpose of the precinct, as well as the purpose of PC2. As a further alternative, submitters request that the precinct be reduced in size to match the operative district plan 1999 coastal yards. This option was evaluated in the Section 32 report and was found to be less appropriate than the proposed approach on the basis that these yards simply do not address by a significant margin the known potential for coastal erosion. Overall, I consider the range of alternative spatial extents requested by submitters for the precinct are less appropriate than the proposed extents. And on this basis, I do not recommend that the alternative approaches are accepted. The proposal to incorporate Karewiriwa Urupa into Schedule 9 of the district plan as a qualifying matter is a matter that remains in contention. Mr. Conway has addressed the legal basis for the council's through the council's legal submission. From a planning perspective, the area has a complex history, and this is documented by the Waitangi Tribunal in the Kariwerewa Urupa report. Engagement with tangata whenua in the development of PC2, as well as the publication of the report, substantiate both the existence of the Urupa and its cultural significance to tangata whenua, including Te Atiawa.
Did you engage with them yourself on that issue?
Through the development of PC2. Yeah.
And in terms of that little area that's affecting the current subdivision, is the rationale from their point of view that it is still part of the Urupa?
Yeah, I can go a little bit deeper in terms of my analysis of the overall set of issues here. From one side, from particularly the Whakatau Land Company side, there is an argument around the evidence of archaeological values in relation to the Urupa. Archaeological values are obviously important, but they are not the sole aspect either of historic heritage or of cultural significance. There are also cultural values to be taken into account, and in that regard, I find the report of the Waitangi Tribunal compelling, and alongside the representations of tangata whenua as to the cultural values they ascribe to the block, as opposed to, or not as opposed to, in my view, that shouldn't be seen to be set aside by a lower degree of recognition or evidence in respect of physical archaeological values. Yeah, so that's so on that though, the council has heard and considered the concerns of current landowners on this. However, knowing its significance, the council has a duty to recognise and provide for the relationship between tangata whenua and the Urupa as a wāhi tapu, as part of considering how to incorporate the NDRS into the plan. So while the approach proposed by PC2 incorporates Kariwerewa into the framework for operative district plan provisions for wāhi tapu sites, the Section 32 report evaluated two alternative approaches, one being to incorporate the NDRS, and the other being to provide for development, but to a lesser extent than required by the NDRS. Both were considered to be less appropriate on the basis that they would provide for and result in both uncontrolled disturbance of the land at the Urupa, and that development would have unacceptable adverse impacts on the relationship between Te Atiawa and the Urupa. I do not consider that there's any new information contained in the submissions or the evidence that would cause me to reconsider the conclusion arrived at by the Section 32 evaluation in this regard. And the most appropriate approach to incorporating the NDRS into the district plan in relation to Kariwerewa Urupa is to incorporate it into Schedule 9 of the district plan. So yeah, I'll now hand over to Katie in respect of rezoning submissions.
Andrew. So the council received a number of submissions requesting the rezoning of sites which were not proposed to be rezoned as part of PC2. As part of assessing these submissions, consideration must first be made as to whether or not they are on the plan change and in scope. If they are not, they cannot be considered as part of this plan change process. Legal advice established the key legal principles and tests that needed to be considered when undertaking a scope assessment.
Can you speak up a little?
Oh, sorry. I then applied these in my planning assessment. The first test is whether or not the submission relates to a variation on the status quo proposed as part of PC2 or was otherwise addressed in the Section 32 report. The second test is whether affected persons have had a real opportunity to participate in the process. Following assessment of all rezoning submissions under these two tests, I made a recommendation on which are in scope and require further assessment, and those that don't meet one or both tests and therefore out of scope. For those submissions deemed to be in scope and on the plan change, I undertake a further assessment on which I make my recommendation whether or not to accept the request. I undertake this assessment using the same criteria originally used to evaluate the sites proposed for rezoning as part of the notified PC2. These criteria are set out at page 139 of the Section 32 report.
And those criteria are: the site is located next to an urban area that is connected to infrastructure services. The site has a relatively low degree of constraints, and any existing constraints can be managed through existing district plan provisions. The site is not sufficiently large or complex enough to require a structure planned approach. And the site would provide a notable contribution to plan-enabled housing supply, or where this is not the case, rezoning is appropriate to regularize the area into surrounding zoning pattern. These
So I see. So when you did the 32 analysis and you were looking at these extensions, those criteria were being applied anyway. So part of the argument is, well, if that's the scope of what we were looking at in the 32, it's logical to say, well, someone who's applying to areas that would fit within that, but we didn't account for them, is in a sense in scope.
Yeah.
Thanks.
These criteria are based or designed based on the council's understanding about the type of rezoning that would be appropriate to include within PC2. While I find the majority of the requested rezonings to be inappropriate, I have made some recommendations to adjust rezonings as part of PC2 in response to submissions.
Yeah, so that's us. I also wanted to note that we've read the expert evidence filed by submitters as well, and are open-minded to the matters raised in this expert evidence. But yeah, we'll listen. We want to hear submitters before we come to any positions on that. So
that's fine. Thank you very much.
Yes. I'll give them a quick, yeah, because I think it's 12:50 to 1:40 or something.
All right. Well, we'll break for lunch.
12:40.
Thank you. That was a great cruise through the context. It's amazing how many times you need to keep on hearing that to keep it in your head.
Yeah.
The next person's at 1:30.
Right. All right. We'll come back at 1:30.
Great.
Yes.
Can't hear you, sorry.
Well, just here is, I'll have to go to another meeting and just ask that Malu with this meeting that full bond partner and that finance rolling is continued to look after.
Yeah.
And I'll ask take those responsibilities fully.
Yep. Had to pay.
I'll be with like you to visit the forest visited and landed here so we can stay and
Greetings, everyone. So my name is Brian Carter. I'm a structural engineer, retired now. I've lived in Auckland until May last year. So retired down here. My family's been down in the area for 30, 40 years. So familiar with the place. So basically, I've got opposition to a 3-story housing situation that's proposed for reasons elaborated by a first speaker, the architect. And basically, I mean, invasion of privacy in your backyard is something I strongly oppose. There's the light issue, the space for children to play in their backyards, and the general increase in site coverage that is associated with this type of scheme. I guess there's going to be other speakers that repeat on the same issue, but I'll repeat it, and basically I'll endorse very much everything the first speaker said, the architect. So we've got a structural engineer doing the same. So there's like nearly 100 years of professional building experience that's telling you not to do it. Okay. So, and it's also, it's not from an engineering point of view, it's from a social point of view, because when we get this high intensity living, like I've seen in Auckland, we start to develop social problems. And I've got a beautiful place here in Kapiti, and you know, why ruin it? Now there is a place for intensification, and along the main corridors. Okay, so we do the. Am I shaking something? So we do the intensification along your rail lines, motorway, but coastal side, it's just insane. Really, there's no need for it. The yeah, I'll just want to harp on about the projections and, you know, the reasons behind this legislation came through. Like when it was first put forward, it was a legislation that would increase intensification in the 4 main cities, with option to implement in other places as well. So that's Dunedin, Christchurch, Wellington, Auckland. So it was not, I'm not sure, maybe it was Hamilton, but it was not intended when it was first promoted that it be applied to places like Kapiti. So, I mean, you've got to ask the politicians who decided to suddenly increase the game and impose that on the rest of the country who had no vote on that matter. So it's pretty disappointing that we, elect these people. They're in there 3 years, 6 or 9, and then they disappear and they damage our environment that we live in. Okay, because this is what's happening. This is what will happen. Okay, and like council and the planners and the lawyers jump on the game, and it snowballs and it gets out of control. And like, yeah, so basically it's an unnecessary thing. If you look at the population projections and the documentation, we've got something like 50,000 or something in the area, and it's going up to 85,000 within another 25, 30 years or so. Now, the amount of intensification that is available from this plan change would allow a population probably in the order of 300,000 or something, or even more. I mean, so like what we're doing is out of scale for the current demand. I know we've got to look further than 3 years, 10 years, 20 years, 50 years. You've got to look like with this sort of thing, you've got to actually envisage what's going to happen in 500 years' time. Okay, and that's where you build your resilience in. And basically, there's plenty of scope for more plan changes in the next 500 years without doing what we're doing now, or what you're proposing to do now. Right. I'll just jump onto resilience, which is something that cropped up earlier, as talk of 100-year return periods. Now, in engineering, we design a building for a certain return period, and generally it's not to be damaged in a certain time frame, earthquake return. Then there's another time period which say my building shouldn't collapse, so it might shake a bit, crack a bit. But then there's another criteria that's been introduced more recently, where you take the 500-year and you say you want that building to be resilient. Okay, so it's not going to collapse like a pack of cards, but it's going to stay and it's going to end up in a crumpled heap, but it's resilient and we survive. So when we talk about our coastal environment and we look at the hazards and we look at the flooding hazards, like talking 100 years is not really correct, because what happens when the levees in America, they have a 1 in 100 years storm, and then they have a 1 in 150 year storm, and it floods, and the system breaks down because you get devastation. So when we come back to look at our coastal environment, you've actually got to look at what's going to happen in that 500 year return, because here we're not dealing with a 50 years scenario, we're dealing with a longer term thing. So the hazards for coastal, you've got the crackpot things as the asteroid, you've got your climate change things. So Wikipedia was looking up that the other day. Some guys said that if we burn all the fossil fuel in the world, sea level will rise 58 meters. So, I mean, that's way over our heads, but that's not going to happen, we hope. But you've just got to look beyond the 50-year projection into a longer time frame when you're dealing with something of this nature. Okay, so you've got your coastal hazards, you've obviously got coastal erosion, you've also got the tsunami factor as well, and I'm not quite sure where the assessments have gone, but certainly there's evidence of forest devastation on this coast from tsunami, because all the trees get flattened in a parallel fashion. And it's not something that happens in a windstorm. So there's evidence of large tsunamis here historically, but we don't have the microscope to go back and see when that was, or like not exactly where it came from and stuff like that, to get the sort of risk assessment that we need. But like that's where you build your resilience in it. And so what I'm suggesting is that we don't have 3-story development in coastal zone where there's risk of sea level rise impacts. And that also applies to, it sort of moves on to my feelings about Paraparaumu Beach Centre. So I'm living in Paraparaumu Beach, so the local area is McLean Street. Okay, so we've got on this plan change 2, for some reason, it's been deemed that we can build 6-story in the current business area, which is basically a little village of shops. It's been there for years, and also 4-story for quite some distance down the neighbouring streets. So you've got to look at the what's happening to the character amenity associated with that. I mean, it's perpendicular to the beach road, so it's the one that all the shops are on. But basically in that precinct, it's the right angles to the beach line, so it's the main little shopping street. But basically that precinct which is on your map, we've allocated proposed 6-story. I mean, that's a fairly decent chunk of land. Sorry? Oh no, I'm further away, but I'm just saying that it's not appropriate to be building that high, that close to the beach. Partly you've got coastal hazard, but also you've got landscape issues and coastal issues to deal with. Because if you look at there's a probably I'm not sure what you call a landscape amenity, but there's a line on your planning maps which shows the coast on the beach running down having sort of moderate or whatever you call it, amenity value in terms of coastal landscape. And that mysteriously stops when you get to the creek down at the sailing club. And then it starts again another couple 100 meters further on. So I'm not sure whether, what the sort of thinking is behind that, how you can sort of suddenly have a landscape value as you go walk down the beach and then it suddenly stops. You get to this no man's land and then it starts again. I mean, it's sort of like, it might facilitate the justification of 6-story construction, but apart from that, it's just sort of a bit strange. Anyway, yeah, so basically, just getting back onto some of the construction issues, they really sort of marginally impact the plan change, but like our first speaker, actually, he was talking about problems with 6-story construction, and certainly I've seen a lot of that with Leith building repairs, done a lot of work with that, and there is a problem with skill level and having the construction infrastructure to actually build those buildings, which I mean, it can be developed, that's not a problem, but with those, with that sort of construction, you do get complication of issues like the sound transmission between units. You get parking issues. You get a whole sort of. So what you're doing is you're introducing a few problems. I mean, they can be overcome technically, but you've got to be aware that things won't be as simple as they are now. Like when you want to do a development here at the moment, you know, it's pretty straightforward. I mean, this sort of thing, it's simple and it doesn't cost the community that much. Okay. I think that's probably all I need to cover. I think you've probably got the general gist of where I'm coming from.
So your view is the policy 3 and 4 encouraging intensification and
correct, yeah. That's what's happened in Auckland. I've come living in Mount Albert, so we've got a train line coming down within half a kilometre of our house, and yeah, and that's what happened. But just touching on that, the whole process with the unitary plan in Auckland, it went out comment with a certain plan, and then towards the end of it, after all the submissions had been made, they decided that they would add a whole lot of areas to that unitary plan. So where I lived wasn't going to be affected. It was going to be stay as the 8 metres ceiling height. But then it was last minute changed 11 metres, and yeah, there was no sort of good facility to sort of get the neighbourhood together to start posing that. I mean, consequently, house down the road was demolished, 4 3-story units put up, you know, square boxes, and yeah, so I don't know how many people live there. It's probably 16 or 20. The type of development is pretty bad. Like one of the units, the driveway is so steep they can't get cars in, and it seems to me that people aren't actually using the garages as garages. So they'll use them as studies or spare bedrooms because, like, that's what covers the rent. So anyway, that's what happens when you intensify. Get those sorts of things. Yep. Well, I mean, if you, no, I guess if you look at the capacity here, we've got the trains running up, so anything within that, and it's also got we've got two arterial routes, one's the motorway and one's the other, the old motorway. So the old motorway lends itself to development where it's possible, where it fits in, because it's a main road, and yeah. So I mean that I think there's a proposal around Nikau Grove, around that area for some development up in that area. So you know, below where they're chopping the trees at the moment. So yeah, I mean that's, I mean doing that will provide more than enough housing capacity for what we're going to have on the Cape Coast in the next 50 years. There's no need to do any of this out here. And the only effect is that there'll be a few three-story houses propping up and really pissing off people next door. And you know, that's what will happen. Well, no, if you do it in a, yeah, but yes and no, but I think it's more understandable to accept intensification adjacent to an arterial route. I mean, like, you know, I could sort of understand it where I was in Mount Albert, you know, like close to the railway lines, New North Road, real nearby, and you know, you just got to look at the big picture, and yeah, that's okay. But when you and also that intensification, you start off with a 4 or 6 story by the railway line, and then it peters down. So you're not sort of so much having that effect of having a big building looking down over a little 1-story house. Yep. Yeah, the immunity of the of people, yeah. Yeah, and character, social, yeah. I mean, it's, yeah. I mean, I've been through the ringer with in Auckland. We took the Auckland Council Parks Department to the Environment Court to stop them developing in the local park. They're doing an inappropriate thing, and you know, it took a hell of a job to stop them. It's very wearying, but we did it in the end. But you know, you're dealing with, you know, a very difficult sort of set of political and council sort of agencies, you know. So it's very hard for people. I mean, you know, like other people here trying to, you know, don't like what is being proposed. I mean, how do you voice it? I mean, I'm here. I mean, I'm only here like less than a year, so we jumped into this, and I'll just tell you what I think, and that's it. I am now, yeah. So I was escaped from Auckland. Yeah. Yep. Right.
Good afternoon.
Good afternoon. Welcome.
My name's Penny Eames, and a little bit about myself is that that my employment through most of mine was arts and arts administration, and that gradually, as I finished my master's thesis on culture and cultural well-being, I found that I had a new occupation as a consultant. I know that's a dirty word for the moment, except that my consultancies were in Britain, Hong Kong, 3 terms in South Africa, Australia, and only on 1 occasion, New Zealand, working with the whole philosophies of cultural economics and the culture of what culture is and what well-being is, and why culture and well-being are really important for the for healthy societies. I'm very interested in the fact that the Local Government Act 2002 carried on with some of the findings and some of the material that was actually in the earlier Local Body Act, and is quite fierce about cultural well-being being part of the work of councils. And I wrote down the wording of the council's mandate for this, and it is that they will recognise and should recognise in all developments cultural and social and environmental well-being for all their citizens. And I don't believe that this particular document that we've got have actually addressed that particular principle. It's a principle of the 2002 Act. Whakatau particularly is a very interesting place, and my full submission, I cover quite a lot of the history of Whakatau, because the history of Whakatau, and particularly Whakatau Beach, which goes back as long as anyone can ever remember, and even earlier than that, with descriptions from people like Hatfield and the missionaries about what was happening. And there are 4 people, including women, who signed the Treaty of Waitangi on the end of the Whakatau River, which is Whakatau, actually Whakatau Beach, what we call Whakatau Beach. Then there started being, over periods of time, there were changes to the area, and sealers and whalers came in quite large numbers. But the industry then became flax, and it was flax rather than necessarily the animals and the whales and things they were cooking. And gradually people started coming and living in the area. And then the first recorded of the big subdivisions, when a man called William Field bought land from Wirrami Parata, which is now considered to be Ye Olde Whakatau. I suspect it was sold for a few blankets and a few other things, but basically it was Soto. And William Field did the first thing that followed by almost every developer after that. He moved the river. So anyone who's been down to Whakatau or else played golf at the Whakatau Golf Club, which I do, knows that as you come down Timuana Road, there is a river on the side. And as you turn to go into towards Fieldway, the river didn't go that way. It went straight along and then along to Tiri. And the reason that was is he wanted to have a subdivision. So he needed to have the land, he needed to lose all the waterdiness. There are amazing photos, and I know that you're going to be shown some of them by one of the presenters tomorrow, that show the Whakatau Beach was a bloody lake. It's even called lake. It was so wet that, in fact, draining was the first thing anyone did when they actually started to follow Field's example and move any river or any water or drainage before they developed the houses. Now, I live in Whakatau Beach, and I live in a pole house. And I live in a pole house because the architect at the start asked us, and we built that in 1986. And so it was quite cheap days in those days. It worked out about 10% of the amount was him organising the poles that the house was built on should go down an extra 6 meters before they could go beneath the water table, because there's a huge water table under our property. And I mean, it was quite silly, long time in advance of other people were doing that. But the house, so it's a very stable house with this that was actually created. Because it is a it's a swamp, it needs to have areas where, in fact, the water can come in. I don't know how many of you went Whakatau on Friday. It bucketed. It's just totally, that water's got to go somewhere. But at Whakatau, it goes back into the water, into the soil. And I watched it happen on Friday. The storm, and the water, and a puddle appeared. We don't ever have puddles in our puddle, but it only lasted about 15 minutes. And the puddle had absorbed into the grass, which made me again come back to, if there had been 3 houses of 3 stories on my bit of land, that wouldn't have happened. Something else would have happened. The water would have to have drained somewhere else instead of being absorbed straight into the ground. I like the word intensification, but I don't like it in terms of some of what I've been hearing. Why I like it is because Whakatau beach, its whole history is about intensification. Waves and waves of it. Going back, some of the first sort of documentation of people coming to Whakatau were the people who were and I'm going to call them the refugees from both the depression and afterwards the earthquake in Napier. It's a wave of people coming. There was several other waves of people coming to Whakatau. They were the women whose husbands had gone to both wars. Well documented, both situations. Lots of documentation of how, though, those people coped and how the locals looked after them. There are all sorts of stories of local women driving people who had come from Napier to dentists and feeding people and putting in barbecues. There's also a little discussion about the local brothel, but I think we could leave that off for today. But Whakatau gradually began to develop with these new lists of people. The new people has gone on, and what we're really waiting to see on the census, what's happened in the last 4 years. And my road, which is not a very big road, there are 5 families where the husband and wife came and bought a batch, and they did it up. And most of them, one of them has got 2 children, a couple of them have got 3 now, and the men pushed the pushchairs down to the beach and back. That's intensification of last year because they were all batches. Now they're almost all homes. And the census will actually pick up how many more children. Intensification's okay, but it's got to have infrastructure that goes with it. We in Whakatau had this growth in people, but there's a whole series of things that we do not have. We've got no school. We've been lobbying since the 1980s for a school at Whakatau. And it has been a nightmare to do that. There's been some little movement just recently, and we feel that we've now found a venue. There's almost nowhere to put it. We've looked at every section there's no room for a school. And we're looking at the school, possibly just at the beginning of Peka, because that's about the only place. But now what's happened, the people in Paraparam, they've got high school and they're too full. And they're saying, why can I get your own secondary school? So we haven't got that. We've got almost no transport to get us to the railway station. And with intensification, you actually need that. So everyone has 2 cars because there's nothing else. There's no way to do anything else. There's no library, but that's, of course, a debate we're having with the council on a daily basis. There's a small medical centre, which has a closed roll. So anyone new can't actually enrol to the medical centre because it's not there. There is almost no service done by KCDC staff. A few at parks and reserves if trees need to be trimmed or if the parks need to be looked after. And our rates paid for by Whakatau people is higher than anywhere else in the country, and yet we have very little. We've documented the amount of service that we get, but intensified. If you're going to have three houses on a section like that, well, I think it's balmy if you haven't got services to keep them there. My specialist area is culture and cultural well-being. And what I wanted to say today in this presentation is that the culture of Waikanai is probably one of the richest ones in my life that I've had seen. Our culture is the histories, the ideologies, and the values of any group of people. That's what culture means. And well-meaning is health, happiness, and the word used in the dictionary is prosperity. Here we've got a situation where we have one of the most fabulous cultures. The stories of the place are just rich and exciting. The values, we know it, there are examples. You don't even need to walk down the street and you have a conversation with someone and someone's talking about their grandchildren, or someone's actually showing you that the baby is around, or if we go to the beach, if someone's throwing a ball, you have to catch it because you're a community. It is a wonderful community. The rituals have come from a whole mix of people who've come to Waikanai Beach. The most interesting one of the rituals is how many people have vegetable gardens. And we've been watching these 5 people who have come and changed their houses on our street. And boy, they have beautiful vegetable gardens. But that's not enough for themselves. They give them to you. They give you a cabbage, or they give you lettuce, or they give you some of the grapes that they had on their grapevine. Or they've been fishing, they give you fish, because that is part of the wonderful philosophy and the mixed empathy that comes with. I mean, I can pay for fish, but gosh, it's lovely if it's come straight out of the sea and has been given to us a couple of hours later. So I think it is really important that we look very, very seriously at this document. I kept on thinking, have they ever been to Waikanai? Have they ever talked to anyone at Waikanai? Why are they talking about Ono Road? That is the most dangerous intersection, that whole place of Waikanai. Have they talked about where the water comes? And why have they now decided that for some reason, 3 houses to take away the space and the trees and the grass and just the environment, the culture that it has got? I think it's not something I want to see. We have been, like our previous one, to the Environment Board, and we've fought over keeping what's called the Futures document, which is produced, and I probably left it somewhere. Oh, here we are. Futures document that took 4 years to write by the people of Waikanai, and it's the sort of Bible of Waikanai people. And it was accepted first by the Community Board, but then endorsed by KCDC. They've taken no notice whatsoever. They don't use it. So we took them to the Environment Board and we won. And we got permission to go on being possibly, they think, selfish, but no, because it is an environment we need. But that's another one of their rituals. They'll go to the court over anything, some of these, because Waikanai is full of lawyers. It's full of past chief executives. I think we've got to think very, very seriously before you make decisions about what happens. On the radio, as I had a meeting this morning, I had to drive back through the traffic jam to get back to my place, and there was a discussion with on the national radio about it's so serious, build 3 houses on one section of 3 stories. This is the guy I was talking to, and he was talking about it because he says you have got to have trees and grass. If you don't have trees and grass, you can't have, you don't have the floods going away. I'm on REMA committee here, which is the emergency. And yesterday afternoon we had one of our meetings. And the only conversation really was really what's happened in Hawke's Bay. And how we can be inundated so quickly because we just are on water, and water, there's lots of it. I mean, it's the whole of Whakatau Beach. It was a lake, so the water can, but a lot of it actually now floats away. And they've at last put in some storm water, because if you see my submission, which was done in September, it asked for a storm water, but they're actually putting that in. So that's what I want to see, that you think very seriously about preserving our very precious culture and keeping the stories down to 2 stories, and acknowledge that if you don't, there is what I would see as an unintended consequence. And that is the very, very rich, and there's some very, very rich people with the houses in Whakatau Beach will immediately put another story on their houses, and you won't get new people. You'll just get the same couple, because they're often couples who come out to Whakatau Beach and buy houses on the beach. Then you will actually have that. That is what will happen. I hope you will listen to what I've said. I brought with me some copies of a book that I wrote before, alongside the first local body bill, which actually brought in cultural well-being as one of the principles of well-being. So I brought you one each as a present.
Thank you.
And hope you might actually like to see that. Thank you. I hope I've said something that actually you'll remember, and I hope you will think very seriously as you read the book about the meaning of culture and why culture is so important to well-being. Thank you.
Thank you.
Thank you. That was really interesting. Thanks for the book.
Oh, so one other thing to say, and I wanted to, because Brian said, the people who ran Rancho have documented with one of the tube that goes right down to the sea. There have been 3 documented tsunamis hit the Whakatau area. The big first one demolished Kenny Marae. And according to but he didn't call it a tsunami. Hatfield didn't call it. But then he was comments on the fact that the population had all moved up through the country. So there is a lot of evidence that tsunami occurred.
When do you know, was it dated? When?
Hatfield would have come through 18, he came through twice, 18, well, pre-Treaty of Waitangi, and then I think he came back just after Treaty of Waitangi.
Okay.
There's a lot of evidence of when he came and left, and what else missionaries do.
If you thought that Waikanai should continue to intensify in Whakatau Beach,
It will.
In the way, what form do you think that should take? If you don't think that the medium density,
I think what's happening now is quite interesting, because it's happened because Transmission Gully and the expressway, basically. So they appear to be almost all of these. Well, my discipline is the ones that I'm seeing all the time with the babies. Is they tried to buy a house in Wellington, or they tried to buy a house in Porirua, and they looked by what's parked outside their houses as if they're builders and plumbers and maintenance people, because it's a lot of work for them in Whakatau. People are always changing their houses. So I think it'll still be something like that. And there are a lot of batches that I think anyone who's keen on who wants 3 stories, they would pick on batch, and they would bowl that batch, and they'd have the whole section and put 3 stories on it. But I think that the fact that these young people, and it's still like that, the houses aren't cheaper, and then they do them up. But then they have children, and then we haven't got a school.
So you're talking about this intensification of the same family building more.
Well,
as opposed to,
there is intensification.
As opposed to 3 properties on one property.
Yes. There will still be one, well, there'll be one house but it will be a doing up of an existing batch.
Okay.
Because there's still quite a lot of batches, except not on my street.
Thank you.
Do you have any knowledge of the Rewa Urupa?
No.
Oh, okay, it's a cultural issue that we have in Whakatau, further south from your property. But I thought you might have some knowledge of that, given your cultural interests.
No, I haven't. I have knowledge and read of iwi and the relationship, and also the report that's just come out of that from Maori, the Waitangi Tribunal, which basically shows that all sorts of things happened that made Mahara Place, taken it away from Maori and turned into housing. But no, I don't.
Yeah, that's the one I'm referring to. But
Oh, you're thinking, oh, that way. Yes.
Yeah.
Well, that's. I don't know how you manage that. I mean, I think that everybody's talking about the same sort of thing.
okay, very good. Well, thank you very much, and that's very helpful. Thank you.
There's nobody in, so give me the.
Thank you.
Thank you very much.
All right, so now we have Malu Jones. Yeah.
That's my name, and I was Maria Louise but I'm a woman in New Zealand, and I've lived in the house for over half my life, so that's sort of how makes me feel. You have got my submission in front of you, and you've got my further submission, and I wrote for the summaries of everybody else. So obviously I take the food. This is my home, and this is where I hope to live until the carrying away, so to speak. Because I see so many awesome examples of life lived from cradle to grave in this area, and I want to be one of those, even though I was born twice. I have put this effort into these submissions because I too am concerned about what is proposed in PC2, but I do want to quantify that to add that it's actually very important to me that I do provide more affordable and safe really dry housing. Okay, so for me personally, for my social conscience and because of my family history, it's actually really important to me that we do intensify and provide better housing options for our vulnerable populations, of which there are many, and they're sort of under the radar. But for me, they haven't been under the radar because of my family history and also because of the way I've chosen to live. I've chosen to share my house with people who are vulnerable and who need a room. Before I married and after my marriage ended, that is how I've lived, and that's how I live to this day. And most of the people I share my home with have been people of colour. Most of them have had vibrant and varied ethnic backgrounds, as well as people with varying ages, ranging from newborns to 63-year-olds. I choose to do that because my father was a refugee when he was as a 12-year-old at the end of the war in Central Europe. His family had lost everything, and what was left of them were reliant on his child labour to support them so they could eat. And they lived in an attic space that was unpowered in the European winter over a garage. And they then had the good fortune of living with the cows in the barn for the next few years because they could keep warmer that way. The cows were very warm. And when he left that place to travel some hundreds of kilometres to live with an uncle to get a building apprenticeship at the age of 15, he hadn't had a secondary education because he'd been a child labourer. And he took with him a suitcase, a battered suitcase of potatoes or corn for the uncle, because that was all they could bring. So I come from that background on that side of the family of extreme poverty and extreme homelessness and vulnerability. And so it's been important to me in a position of relative privilege to provide a roof for people who are not so well off. It's for me, it's a personal thing. It's like paying it back. Those strangers who housed my relative and my ancestors, they helped them survive. They made the difference between salvation and all the other problems. My mother is fourth generation New Zealand Pakeha, and she was what would be described as rural poor, where they lived in hovels on rural land they didn't own, but they had the amazing ability to grow food there with soil, sunlight, rainfall. My grandparents were incredible gardeners and fed so many people with their amazing bounties of food. So food production and food resilience is important to me in my family history, and that is going to be part of my submission. Even though it didn't look like a big part of my submission to council, I think in the light of Cyclone Gabrielle, we need to consider this even more in our local district. So my initial submission, because I live in Hini Martinga nowadays, for the last 13 years, I've lived in Hini Martinga in East Whakatau. I can see that on paper, Hini Martinga is an awesome place to intensify. It is flattish, it is near a railway station, and it is near our public amenities in Waikanai Town Centre. And I can see why it was chosen for 6 stories. However, if you actually live in Hini Martinga, you'll realise that one exit and entrance road is problematic. And you can see from my submission, I have made various suggestions as to how we could improve that, so that intensification can occur, but in a safe way for that part of our community. I too wondered when I saw the PC2 whether people had actually been to Hini Martinga who'd written it. How did they possibly imagine that all those extra thousands of people are going to cross over that one exit and entrance per day safely, timely, when there's a fire and when the school's going in and out, and when people are trying to go to work or secondary school from there? We have a primary school there that is bulging beside Whakatau in central Waikanai. But at least half of the populace, and I'm a registered teacher, so I do know my children have gone to Waikanai school as well. At least half of our school population in Waikanai comes from Waikanai Beach, Pika, Waikanai North. It's not Nui's fault, they're bulging too. I teach there. We need another school, and we need the council to be more active in lobbying for it. Because the infrastructure issues that Waikanai East has are actually caused by the lack of a school elsewhere. If we can reduce those hundreds of vehicles and legitimate traffic movements that occur right across Waikanai to get to Waikanai school and back every day, then we have automatically made Waikanai East safer and better for intensification. Automatic, even without having built an overpass or an overbridge that is mobility scooter or cycle friendly. Now I've got an e-bike, but I take my life in my hands to go from East Waikanai to West. And I really appreciate the cycling networks that are setting up. And I wish I lived on the western side, because then I could just get on my bike and hoot around really safely. But I tell you what, that one stretch between East and West still does my head in terms of safety. And I wanted to be able to cycle to my local places of work, because I work part-time in a variety of different schools, in a variety of different places. And I can see the way things are going. I will be able to do that in the future. But from Waikanai East, not so well. Particularly while we still have a school that is catering for people from far away. It's nobody's fault the way it is. We need that to change. If we build an overpass of some description, even if it's only cycle, tram and mobility scooter friendly, then we've immediately increased our connectivity hugely for that community. And I'm hoping the council will look at that favourably, because we're having to build that over what was the old State Highway 1 plus the railway line. I imagine that's the least expensive option compared to building a vehicular overpass or raising the railway line above our access road, our sole access road. We have no fire station on the east side. We have no medical services whatsoever. We have no supermarket. And our one access road out of that zone going eastward is going over the Aotearoa Road, and no one would recommend that for supplies of food or medical assistance or fire assistance. let alone in bad adverse weather conditions. Like many other people, I've been halted behind barrier arms at various parts of the Kapiti Coast when they've malfunctioned in the last 30 years, 32 years. I've been trapped in Paikakiriki in the middle of the night for quite some time. I've also been trapped on the eastern side of Whakatau and trapped in traffic jams, trapped trying to get back to the eastern side of Whakatau when the barrier arms have malfunctioned. And that is even without a major earthquake event or a major cyclone, a massive disaster of anything. It's just simply malfunctioning. And that's not even counting the normal freight trains, the normal commuter rides. So my first submission was primarily about Hemi Martinga and how it is not yet in a position from infrastructure provision. It is not yet in a position, I believe, where it can safely offer intensification as a good option because of those reasons. So if you can solve some of those infrastructural issues in terms of another school being built to take the pressure off that region and tram, cycle and mobility scooter friendly overpass, then we're looking at a realistic choice in terms of intensification on that side of the railway. The next part of my submission to you today verbally is more a district-wide issue, but it certainly pertains to there as well, and is that a lot of the people who've chosen to live on the Kapiti Coast have actually chosen to live there because they didn't actually want to live in the city. I mean, that's the reality. And if we're going to provide more safe, affordable housing for the people that the sorts of people that I house in my home and have done for many years, if we're going to offer more safe, affordable housing in our region, we should be doing that by going up, but going up in areas where there already is a high level of concrete and asphalt. Please do not build our intensification over our valuable food production soil. Auckland, the Hamilton, the Hutt Valley. We can think of lots of places in New Zealand already where some of our best horticultural and agricultural food production soils are being covered in concrete and asphalt. I see nothing in the PC2 that is valuing our ability to be food resilient here locally, to cut carbon emissions by growing more food locally for our burgeoning population. We are cutting carbon emissions every time we cut food lines. We're not looking at this issue in terms of what the potential, the opportunities that are. We are disregarding soil just as a piece of real estate to put buildings on. Hey, wake up, tribe. We've got heaps of growing conditions on our coasts which aren't actually so productive. First, concrete and asphalt, not very productive in production of food generally. Secondly, the ones that are pure sand, disregarding, of course, our lovely lady who told us about the beautiful gardens in one effect. I can understand that. I've lived in Paikakiriki for 18 years. I know how much hard work it took to grow things in Paikakiriki, and I did so. It took a lot more water, I can tell you now, because of the sandy soil, and a lot more effort building raised beds, etc. But we're blessed with local, amazing soil. We have sun, we have rainfall. We can grow stuff here. Look, we see evidence of it. Not necessarily so much in our sandy zones, which get dry out a lot in summer. We know that already. But in the areas like Otaki and Waikanai and Paraponga East, we grow things really well. Look at the community garden that's growing on the corner of the old State Highway 1, opposite the old Boat City building. Look at that amazing community garden there. There are other amazing community gardens that are developing in Otaki as well, taking advantage of this natural, our natural ability to grow food locally. Please use those as role models of what we can, as opportunities for something to do better to reduce carbon emissions and to improve food resilience in the light of climate change. Gabriel showed us our reliance on the food baskets of the North Island was suddenly called into question when that disaster happened. Not only the transport networks, the rail and road transport networks, but the actual food production baskets themselves. If we have got better local sources of food, and I'm genuine suggest we actually do an inventory at the council. We go around and literally analyse our local area from a food production, through a food production lens. We are setting ourselves up for more climate change resilience, especially if we're going to be feeding a greater population. I had people from the council in high-vis jackets and clipboards come to my house a couple of years ago, completely unwarned that they would come onto my property, and they analysed every single drain and every single downpipe that came off my roof. Now, I felt a little bit nosy at the time, and I was quite amused because most of mine went into rainwater tanks that I was then feeding into my garden. But if we can do that for stormwater, for every single downpipe on somebody's house, surely we can send people around in high-vis jackets with clipboards to analyse the soil on people's properties and their ability to grow food. Or do they already grow food? Have they already got mature fruit trees that have been there for 50 years that grow buckets and buckets of fruit? Because that's what I've got on my place. I don't own a lot of land. I don't have a lifestyle block. I'm still a sole parent with borders, but I grow an amazing amount of food on my property. And if we had more people doing that, we wouldn't have food insecurity with our vulnerable population. And we would have a better quality of life and better climate change resilience. Another issue that we need to consider is, and Simon Upton has made reference to this as the Commissioner of Environment, who has recently produced a report concerned about the loss of green spaces in Auckland. 30% of Auckland has lost, the green spaces have been lost in the last 10 years. 30%. In Hamilton, 20% of the green spaces have been lost in the last 2 years. Those areas are amazing places to grow things, and also areas people want to live in. Clearly. We need to do better than that. Please don't copy the mistakes of our northern relatives. I'm widely travelled. I have lived overseas. I have seen how millions of people are housed in Europe. They still value their mature trees. They don't go chopping them down willy-nilly. They still have apartment living and amazing public parks nearby. But they don't go around chopping down mature trees. They value them. We don't do that here. We have no protection for most of our big trees. They are regarded as a nuisance at best by most developers. And the council does not protect them. I heard it's very expensive to protect and take the local tree. For goodness sake, let us get our values right. Our local mature trees are taonga. Whether they be deciduous or native, they're still taonga. They provide shelter from the rain. If we have heavy climate change induced rainfall, downfalls like we saw in the weather events, we've seen it here locally, we've seen localised heavy rain, we've seen it in the Hawke's Bay and to the north. If we have mature trees, they're helping soak up rainfall. They're helping protect the ground underneath them. They're also providing shade in summer so we don't just produce more urban heat islands. This is not a concept that PC2 has even introduced. PC2 is actually encouraging urban heat islands by chopping down all the mature vegetation and planting little shrubs and little grasses here and there to tick the box for vegetation and green space. Well, I'm sorry, it doesn't wash. Little shrubs and little grasses amongst our lovely high-rise buildings is not going to have the same effect in terms of stormwater management and in terms of shade and cooling our urban spaces, so they actually are better to live in. We've seen the satellite images of the heat that's produced by cities, our world cities. We can do better. We have hot sun too. And my place has got heaps of trees. Now, the local tradies don't like it because they have to carry them through the driveway and they can't take the big trucks down. And I'm a bit sorry about that because it's added $1,000 to my scaffolding bill. But hey, I still got a bit the cooling effect of those trees. In summer, I notice that everybody comes to my house. Hey, cool. It's just trees, mate. They just grow. I chop down the branches that have been there, I burn them in my wood burner and heat up my water. So trees are also providing physical and mental health and whole order well-being properties. And some of our tangata whenua submissions have mentioned that. And there's nobody here in this room here today that I'm aware of who actually knows my personal circumstances. But I have been through a lot of grief and through a lot of suffering in these last 15 years. And I can tell you now that to be able to rest my eyes on either trees or hear the sound of birds or to hear the sound of water, all of these things are beneficial to my well-being. And it won't be just me. And there's the people out here who are going to be living in these high-rise buildings. They too will need to be testing their eyes on something other than a tiny shrub down there or a little grass with pebbles around it. Please let us think of those values too for our inhabitants of our community. So trees also provide, as we well know, ecosystems for birds. We call ourselves the nature coast. Do we still promote ourselves as the nature coast? Because if we do, we're making a mockery of that. PC2 might actually make a mockery of nature coast. If we chop down our tree corridors, if we cover the island and Himimati, which we're so proud of, I remember when I arrived in the capital in 1991, this was mentioned as a great, wonderful asset of the coast, that we have this beautiful tree corridor that the birds can fly from. Cover the island, all those food sources will shelter from storms, and they go all the way to the reserve at Himimati, and gosh, and they're going to go all the way back again. Apparently, according to the things that I read at the time, and I haven't read them recently, that was one of the singular most important factors for our native bird life was to provide a bird corridor. Not just an offshore island, but an actual corridor so that they could shift to follow food sources. Our food corridor are our mature trees and shrubs in Paikakariki and Whakatau in particular. Because actually, the area of Romati and Parapromu don't grow those trees so well because they are purely sand-based. That is just a natural consequence of being on pure sand. So our best mature vegetation that's grown in Paikakariki and in Waikanai, and that's both indigenous vegetation and imported vegetation. But I tell you what, the birds, they actually like those. And human beings love the shade from the deciduous trees in summer, but they don't really want to have their houses shaded over in winter. So we know trees can be an issue in terms of stopping people get the sun needed. Which brings me to another element, sunshine. Apparently, according to PC2, sunshine is an amenity value. Sunshine is being described as if it's a nice to have. Now, most indigenous communities would tell you that sunshine is not just a nice to have, it's essential for life. I was brought up on the south coast of Wellington in one of the shadiest spots that existed, because that's all my parents could afford. I looked out over the beautiful Cook Strait, including the Waihine Storm, which wasn't so beautiful that day. But I looked out over the beautiful south coast, the beautiful sunshine, but I didn't actually experience it. At least I could look out over it. As a student in Dunedin, I lived in some of the worst diets imaginable, and they will never have passed the healthy home standards even in the last 100 years. But one of those places had also had no sun for 3 or 4 months, caused by the bad placement of the house near a cliff. It wasn't caused by a high-rise building, but I tell you now, if we plant a 6-story building right next door to another property, it will have exactly the same effect. 3 or 4 months of the year, that building will receive no sunshine if it's in the wrong, or a cluster of buildings, no sunshine if it's in the wrong place. How dare we tell existing residents who've chosen to live in the County Coast, how dare we tell them that that sunshine is just an amenity value? It heats their home, it lowers their power bill, it reduces carbon emissions to actually receive sunlight into your house. We're not reducing carbon emissions by chopping down mature trees. We're not reducing carbon emissions by reducing sunlight to people's houses. And we're not actually helping our food resilience by stopping people growing food. if we chop off their sense of sunlight. Please consider where we put our high-rise buildings really carefully. We need high-rise buildings to cater for our housing needs. Please put them in places where we are not destroying our local taonga, which is our mature trees and our food producing trees. Please put them in places where they are close to community amenities, where the infrastructure does actually support that, and I mean cycleway infrastructure, as well as a little bit of vehicular infrastructure, let's face it. We do need them, but please think very carefully. And please be prepared to dig up a paddock to put a whole lot of high-rise buildings. There seems to be a huge aversion to what we call greenfields development. I get it. We don't want to just expand suburbia willy-nilly, because that's what New Zealand's been awfully good at in the past. And Auckland and Hamilton and Tauranga would be horrible examples of that. We could say we are an example of that too. If we are citing a cluster of high-rise buildings well planned, with good stormwater provision, good connectivity with local services, whether that be cycleways or minivan that ferry people to the railway station if needed, like a public service of minivans. So we don't have to have a huge bus to have the desired effect. If we put our high-rise buildings in well thought out places where we're not interfering with roof production, we're not interfering with the sunlight of existing residents, then we can actually get the best of both worlds. So we house people who absolutely need it, but we do not destroy the quality of life and our food resilience of the community. And that's what I'm asking the council to consider, putting them in, building above car parks, for example. I've been looking at urban planning and international best practice. It's amazing how creative it is. It's a wonderful field. It's an inspiring field. Vertical gardening, building apartment blocks above existing car parks. So you allow the existing car park to be there, then you build the structure and build your apartments above them. You have not reduced the amount of green space. You could have a roof garden to even enhance it. You could also incorporate compulsory solar generation on these buildings. We have nothing in PC2 that's encouraging harvesting rain. We have nothing in PC2 that is suggesting rain gardens, which are going to be soaking up stormwater, using our natural features to soak up stormwater. The Wellington Regional Council has expressed concern about this as well. What about people who are already generating solar power on the Kapiti Coast? What are we going to do about them if we put a 6-story building next to them, or even a 3-story one right next to them? Is that reducing carbon emissions? What are we going to do? Is that an amenity value that they have chosen to put solar panels on their roof and trying to do the right thing by the environment? What do we do about that? Do we compensate them? Do we make it compulsory that other buildings also put solar panels on their roofs as a community to try and be more resilient? Think about the people in Hawke's Bay. I know people who travel to the Hawke's Bay with portable solar systems to help their mates get cell phone batteries recharged. Solar power suddenly became a necessity, not a nice to have, not just for the rich idealistic ones like me, relatively speaking. Solar power is actually, and wind power, given our wonderful attributes of windiness, we've got capacities as a district to be more carbon emission friendly, but PC2 is doing nothing about them. So I'm really concerned that we have a narrow focus in PC2 that is, it is well thought about in terms of the design of buildings. I think it's wonderful that we've thought about the quality of the buildings, but we're not thinking about where they're placed well enough. I'm sorry if I'm garbled all over the place in various different topics, by the way. Another aspect that I made in my submission was things to do with allotments. I know it sounds very old-fashioned and very British, but it's not just British, it's all over Europe. They've got millions and millions of people who live in urbanised environments, but some of them want to get their hands dirty in the garden. Some of them want to produce food. We've got amazing capacity from a lot of them. Yeah, a lot of system here on the South Coast. Not everybody will be able to own a big garden or a front garden. But the people who want to help grow food, either for their mental health or their physical well-being or everybody else's, they should be able to, with a bit of foresight and with a bit of planning with visionary planning and foresight from the council. We've got that capacity. We've got lots of land that just lies around, sunny burns on beautiful soil, sunny slopes here and everything, nooks and crannies, which could grow food in an allotment system for people who live in apartments. Please let us consider that as part of our community planning, our district planning. Community gardens, the same principle. Please let us look at doing them, but not just on a little sandy corner somewhere that gets shaded out. Put them in a place where it's got good soil, good sun, the ability to harvest rainwater. We also have a situation where we are expecting multi-storey buildings to be the answer for everybody. Can we please also look at the possibility of tiny homes and make it more possible from a planning change point of view? Some people, for them, whether it's spiritual or cultural or family reasons, they really do not want to be living in high-storey buildings, but they would love to live in a little cabin somewhere. Can we please be more open-minded about that? I understand that in the past, there was supposedly local opposition and to the idea of the tiny homes being in our community because it would somehow lower the tone of the district. And it might also lower property values if tiny homes were allowed. This is what I've heard. Help. If a tiny home is going to lower the property value, isn't it? Well, you're not doing it to try and lower property value, but we want our housing to be more affordable. That shouldn't be the issue. I would say having a 6-storey building that blocks all the sun is going to lower your property value quite a lot more than a tiny home. So can we please be open-minded about that and not just look at the going up business as the only solution, please, because we have got other ways of filling this problem and making it go away, or at least much less. Okay, so I'm asking that we recalibrate through the eyes of where are our good soils, where are our mature trees, where are our concreted and asphalt spaces already, where do we have landowners who are more than willing to develop their paddock adjacent to current suburbia. They're more than willing to sell it to developers to go up and up and up. Please let us consider those options rather than willy-nilly putting in 3-storey or 6-storey buildings randomly, it will be pretty random throughout our suburban areas. It's not going to be reorganised, just like it wasn't in Auckland and Hamilton. It's going to be random as to who sells when. And it's going to be pretty random as to what the effects are, depending on how close people live to the and what the angles of the sun are. So can we please consider infrastructure as well as the soil types, trees, and yeah, I do want us to intensify, but I do want us to look at it through these different lenses so that we can choose our places better. Because I feel like we are being, PC2 is painting our district with a broad brush. Like, oh, you are within 800 metres walking distance from Whakatau railway station, therefore you are 6-storey. Well, it doesn't really work for people with mobility issues, does it? Let's go. Doesn't work to get to the doctor, doesn't work to, you know, if we are stranded on the wrong side of the track, so to speak. The other premise is that I do wonder why we are not questioning what our definition of rapid transit is. I haven't commuted to Wellington for work since the mid-90s, you know, with a carpool from Whakatau. But every time I have gone to use the train, and I try to for social reasons sometimes, if I only have to go to CBD, I'll try and use the train. Most of the time I end up getting put on a bus. to Plymouth. And I have been stranded many a time at Plymouth railway station waiting for the bus. Take me back home again, sometimes at rather unpleasant time of night. We are calling our KPL line from Whakatau to Wellington, we're calling it a rapid transit route. That's its definition. From my experience of it, and very random, because it's only when I feel the information to catch the train, that's the reason we've outlined. But when I catch the train, invariably, it is half the time it has been a bus, filled with Hamilton. It hasn't been rapid, it hasn't been reliable. And I think we should be questioning what the definition of rapid transit is. If Johnsonville can be classified as not rapid transit, why on earth is Whakatau classified as rapid transit? If parts of Auckland have also been ruled out because their rail services are deemed to be not reliable enough, why are we? I don't think the council had challenged the definition of rapid transit route in regards to medium density regulation from national government, from these national government. We haven't challenged that because I don't think we actually fulfill those criteria. It's not very rapid, not very reliable, and on half the time it's not on the rail. So let us not fool ourselves, even with the advent of transition gully, which has been amazing to make us more connected with our southern communities. Our rail line is actually not, our public transport on the rail line is actually not that rapid, and it's not that reliable. And this is, all of this is predicated on being close to a rapid transit line. And that is not even counting the east-west connectivity of our communities. I would say the majority of the people who live on the capital coast don't even commute to one, even though thousands do. Majority actually don't. They're retired here, they're bringing up families here, and they work here. The east-west connectivity is actually probably more of an issue on our very strung out series of communities than the north-south one. And I don't think that our PC2 is actually recognising that very well. It's all very well to live within a certain amount of meters of our rapid transit hub, that was our railway line, it's our railway stations, all very well. But what happens then? There are some rather long distances to go to get to our other communities, to get out to the beach communities, to get out to Pika Pika, to get even on Waikanae Hill. We don't actually have a public transport infrastructure or yet a cycleway infrastructure that is actually giving us connectivity in an east-west way, which brings people to those transit hubs. The transit hubs north-south, I get that. Yep, we've got stations there. Padamsey, Whakatau, Padamsey, Paikapiriki, Pukura Bay, if we go that far. Sure, but there's not very good east-west connectivity to be fair. And that's partly our topography. We can't help that. We've got some rivers in the way. We were never designed particularly well for that. We're working on it. You guys are working on it really well with the cycle lanes. It's going really well on the western side of the tracks. Awesomely well. But we haven't got there, and it's not going to support the intensification that has been proposed by PC2. Please let us develop our infrastructure with the intensification or before the intensification, not after. There'll be developers out there just waiting for the gong to fall. Yes, it's our turn to develop this section to 3 stories or 6 stories. Yes, we've been waiting for this. From their point of view, I get it. From Kainga Orders point of view or Tapui Infield's point of view, I get it. They're waiting to make big bucks or house lots of people with both. They're putting on pressure on you guys for that. I get that. But unless those places are being built very close to our transit hub and our shops, then we are just making more problems for our community. Not because they're poor people or needy people, but because we will not have infrastructure to support those populations. We want our populations to be mobile, to either be able to catch public transport and minivans or whatever, because that's going to be the reality. It's not going to be just the train, please. There are not thousands of people who are rushing back and forth between Kaikakariki and Waikanai each day. I can tell you that now. They're either going further afield to work, south in Porirua or Wellington. There'll be a few going to Coastland and back, and a few going up and down for, social reasons, but most of them, they're zip-zapping east-west. Going north-south is only a very small part of their potential journey. We need to, and the people with mobility issues, what about families with lots of young kids? I had a friend in Paris who cycled around Paris with her young children. She had one in the back. She had a series of trolleys that she towed with her bicycle. Now that's not the norm here, and it might become the norm, but in high wind and high rain situations, it's unlikely to be. Are we saying that our young families can't go out when it's bad weather? Have you tried to bring a pram, a double stroller pram on the buses? Have you tried to use public transport to get, for example, from Kaikakariki to Raumati Beach? When I worked at Kapiti College in the 1990s, my car got badly vandalised and I had to use public transport. It took me an hour and a half to get from Kaikakariki to Raumati Beach to Kapiti College. I should have just popped on a bicycle and rode through the QE2 Park. Would have been just as useful. So we do have connectivity issues in our area. We cannot hit ourselves. We have got so many people with mobility issues with our older population. We cannot ask them to go on a push bike. They would love to be on a mobility scooter, a lot of them, or an e-bike, maybe. Do we have sheds to park e-bikes, lockable sheds? I don't want to take my e-bike out and park it randomly on some bollard where somebody with gauze and bolt cutters can come along and make off with that expensive piece of real estate. I'm afraid to take my e-bike anywhere. I've got a really expensive lock for it, but it still can be cut open. Do we have lockable spaces for bikes? Do we have bike sheds that can give some protection from the elements near our railway stations? If we are truly wanting to support active modes of transport on our region, we have to think practically on a small micro scale. What is going to make it work for our people to do this? I'm active. I can still do this. But my mother keeps telling me that people are trying to make her cycle and she can barely walk with her car. She's not on the Kapiti Coast. But there are many people of her generation in the Kapiti Coast who must feel similarly threatened. They will soon no longer be able to drive because they will not be medically fit to drive. What are their options? There certainly won't be active modes of transport. Are we actually catering for our population? So I'm sorry, I'm sounding really hypercritical. These are just really food for thought for you, please, because I do want us to have high-rise buildings. I do want us to follow the best practice models that exist in Europe, Asia, the States. There are places where things are getting better, where community gardens are being built, where alternative models of home ownership are being explored. And I think we can do it, but we do need to widen our vision rather than keep it narrow as PC2 is doing. PC2 is a narrow document, sadly. Narrowly, intensely focused on the values of urbanising our district, whether it's got infrastructure to support it or whether we destroy our ability to produce food, doesn't matter according to PC2. Well, it does matter, and let us do it better because we can. We've got the ability to think ahead. What does our community need? We need connectivity, we need food, we need stormwater resilience, we need climate change resilience and other sorts. And yes, we will be reducing carbon emissions by doing that. But just providing warm, dry, affordable housing is an empty shell if you do not involve infrastructure and you do not involve food production. We don't want our people to be living in empty shells. It's a narrow lens to look at housing. Sorry, I talked too much. If you've got any questions, fire away.
No question, thank you.
No questions, right?
I don't have any questions, thanks. Before.
Thank you. Thank you very much, Ms. Jones.
No problem.
Right. So this takes us to the afternoon break. And in 15 minutes, at 3:20, we'll hear from crew. And so welcome Coastal Ratepayers United.
Thank you.
You've got an extra allocation of time.
Yes, we do. Thank you.
And we're really in your hands to introduce yourselves and then explain how you'd like to run it.
I'd be happy to do that. But before we do, we're expecting Philip Milne to join us by Zoom. I don't know
Ah,
if
yes.
it's online or not.
Okay.
Not yet.
Okay.
Well, he should be on. So
Let's just wait till he's on, eh?
is that all right?
Mm-hmm.
Yeah.
It's pretty punctual.
Yeah.
We could introduce ourselves.
Yeah.
Okay, so I can start and hopefully Philip will join us.
Mhm.
So good afternoon to the PC2 hearing panel. I very much appreciate the opportunity to be appearing before you today. I would like to introduce myself and my team. My name is Salima Padamsey, and I'm the chair of Coastal Ratepayers United Incorporated, shortened to CREW. I appear today with our expert witness, Mr. Sean Rush, and Mr. Philip Milne will be speaking to our legal submission via Zoom. Yeah.
Well, no, mai, thank you for having me. I'm not a member of crew, but I do own a place in Otago Beach, but I've got no idea what the outcome of the process is going to do to it. But I'm here as a technical witness. My background, I was Wellington City Councillor for the last 3 years, so I know the answer to the Johnson Online question, by the way. And I have a master's in climate change science and policy through Victoria University. Prior to that, I worked in the petroleum industry, masters in petroleum law and policy. Quite a bit of experience in the geology and postgraduate work in geology and soil movement as well. But particularly for today, in terms of sea level, it really was the combination of this doing the master's work and being a representative for coastal residents in the south coast of particularly Wellington. And combining all that, I ensured I was up to speed with all the latest stuff coming out of NIWA, the tide gauges and the satellites and so forth. So that's kind of where I hope I can add a contribution.
Right, thank you.
So I take it we're still waiting for Philip. So maybe I can start. And we can take it from there.
I will give them a few moments. It
Okay.
might be.
Okay. Who's this?
Sweet. He's overseas though, isn't he, in Papua? So it's a time zone issue.
Yeah.
It's a time zone issue.
Oh.
Video. It's going to be on audio.
Oh, brilliant. Thank you.
Certainly does, just understand.
Yeah. So then he's on audio, isn't he? Okay.
So are you going to ask him to present first or
No,
So I will do my little spiel.
Yeah,
And then we'll have Sean come in with some of the technical issues that we would like to raise. And then Philip will have our legal submission that he'll speak to.
thank you.
And then if you have any questions, then of course.
Yeah, we'll ask them for each witness as they
That's
go through.
perfect.
Yeah.
Thank you. So can I begin?
Yeah.
Since Cru's inception in 2012, our mantra has always been good science, good planning, and good planning. Today, we have a membership of around 500 people. Regarding the PC proposal to identify coastal erosion areas, Cru has been in this position before. Direct parallels can be made to the council's previous attempt to introduce scientifically and legally flawed erosion lines in the district plan and LIM reports. Some of the following points that I will be referring to are in Mr. Milne's submission, paragraph 22 to 31. As a result of the previous High Court judicial review in 2013, the faulty erosion hazard lines were removed, as were the coastal hazard objectives and policies derived from those lines in the then proposed district plan. As a result, the Kapiti Coast District Council commissioned an independent science panel to review the Shand 2012 coastal erosion report. The independent science panel concluded that the Shand report was not sufficiently robust. An independent review of the then proposed district plan carried out by Richard Fowler and Sylvia Allen recommended that Chapter 4 be withdrawn and a variation be notified. 10 years ago, Cru was right to challenge the science, and a decade later, I know we are right to challenge the science again. In 2016, Cru further succeeded in one of two declarations sought from the Environment Court on the council's refusal to review coastal hazard provisions as part of the proposed district plan, and the council subsequently withdrew further provisions from the proposed district plan. Cru did not succeed in the second declaration brought before the Environment Court and subsequently appealed to the High Court. Both courts accepted the evidence of the council on the timing of the replacement of the withdrawn coastal hazard provisions, that being the notification of the replacement provisions in 2020-2021. The council has not met its obligation to the community or to the courts in this regard. It's a 5-year promise that came and went without any explanation. And the fact that we are here again, facing the same issues of bad science and bad planning, is not of Cru's making, nor is the council's refusal to consult with Cru in any meaningful way. I would like to bring your attention to the fact that there are 37 submitters supporting Cru's submission and one further supporting Cru's submission. It is the panel's decision to make decisions based on good law. I implore the panel to accept Cru's evidence and submissions and reject the council's attempt to backdoor a scientifically and legally faulty quasi-coastal hazard provision into its district plan. Thank you.
So when you say a quasi-coastal provision, what do you mean by that?
So I think that would be better suited for our technical team, our
Okay.
technical witness to explain that to you much better than
Yeah,
I
yeah,
would
all
be
right.
able to do that.
So
Or also Philip Milne.
okay, so it's just if you note that I have an interest in the sense, I want to understand the sense of that phrase, a quasi-coastal provision.
I'm hoping that by the time we have finished our full submission, you will maybe be
Yeah.
able to have that understanding.
Okay, thank you.
Thanks. Well, again, thank you very much for allowing me to come here today. Beautiful coast. I've got 3 main points. I'm going to plan to speak for about 5 minutes, allow plenty of time for questions and let my friend get on with the legals. So 3 points. Point number 1, I'm going to go through Mr. Todd's evidence and refer back to where I have some disagreements in my evidence that I've presented. Now, I have got speaking points that actually do reference the paragraph numbers that might be helpful to give to you a bit later. But in summary, the first point is that there's a confusion between using Ministry for Environmental guidance instead of the Department of Conservation guidance. The second point is that there's an outdated sea level rise projection that the IPCC, that's the Intergovernmental Panel on Climate Change. I should have mentioned I was an expert reviewer for that, the last report.
Yeah, I read that.
Yeah. The projection used has now been described as implausible. And the third point is similar, and it's not a criticism, it's just that there's been new science about ground movement, particularly on the Kapiti Coast, that shows that the Kapiti Coast has been lifting up out of the water for at least the last 10 years, and that will have an effect on your forward projection of sea level, and that has not been accommodated or taken into account with the projections going forward.
So the first point, working backwards, is a net uplift in ground level.
Yeah. So the projection
relative
from
to sea
Mr.
level.
Todd is a 3 millimetre subsidence going forward forever. The evidence that has come out since 2020 at least is showing that Kapiti has actually lifted. And although that's not necessarily a trend to celebrate going forward forever, it should really, it is quite a regular occurrence. We've now seen this happen 4 times, and I can show you a neat little picture of that.
Yeah, no, so I read that with interest. So, but I understood from your evidence that was a slight time frame problem with the way people are reporting this issue, that sometimes they take a time band and say, I think the phrase is subduction movements downwards, but you're saying that I thought you were saying over a longer term horizon, the actual net movement is up rather than down. So I was confused at your 10-year statement, because I thought you were looking, your proposition was you looked at a longer time frame.
A bit of both. So first of all, the policy irrelevant time frame, which is the geological, 125,000 years. I think they I imagine Mr. Todd would agree that New Zealand, by and large, the Kapiti Coast is lifting out of the ocean. So that's what we've seen, and we've got good evidence of that in peer-reviewed papers all over the shop, including Nicola Litchard's work with her former colleague from GNS. So that's that time frame. Then we've got the short time frame, which is these very short data sets of 5 to 15 or so years, which can show what they call an interseismic subsiding trend. And in particular with the new satellite data, which we can talk about a bit later, that's come with this, what's known as the Sea Rise project. That trend has been selected because it doesn't have any of the awkward uplifting events that actually sort of like correct the record. And as a consequence, it shows a deteriorating trend that amplifies sea level rise, but is not likely to be, is not one that we see in the tide gauges, because we have these uplifting events that happen over periods of months to years. Tiny little earthquakes, they call them slow slip events. And I've only really started studying them since the GNS satellite network was installed, and that's only been 20 years. So we're really only just starting to get to grips what they are, but we've seen this happen on the Kapiti Coast now 4 times with a net uplift.
So when that first debate started happening, which was 2012, we're now 10 years on in advance. The independent group panel said, why don't you take some surveys and look at actually how beaches are performing? Is there any technical data or any work of that nature that's been carried out? Because other features of this coast are, for example, differences in sediment budgets and all that sort of stuff.
Not that I'm aware of, not specific to Kapiti.
So that recommendation never obtained traction.
You may have, through that you waded through my my evidence. You know, one of the things that surprises me is that there's very few tide gauges, and the ones that are here along the coast only reported data for a short period of time. So I'm have followed up with Lynn's and heard back from them as to why that is. But
Yeah.
I mean, even relying on these, the GNSS data set has its own complications. So Paikokariki Hill is not likely to be necessarily reflective on a millimetre scale to Paikokariki Beach, just different kilometres away, hundreds of metres up. So, you know, it's the best data we've got, but there are limitations.
And the next one is the scenarios for sea level rise assumptions, and you're, I think, criticising the 8.5, is it?
I don't like to say that I'm criticising the 8.5. I mean, it's a widely used metric.
Yeah.
It's still, I mean, it's been succeeded now because of the 6th assessment report. So it's the SS5 to 8.5, but it's essentially the same thing. Criticism is not how I would put it. It's just that it's now widely regarded as implausible. So the question is, well, what does that mean for policy making? And that's something which, you know, is really something that you can answer today, I suppose.
And then the other key element is what? There was the uplift, the 8.5, and what was the other point?
It was just that. So Mr. Todd's evidence starts out with an incomplete recital of policy 25. And what's missing is the final bit that talks about taking into account national guidance.
Yeah.
And the national guidance in this space was issued by the Department of Conservation in 2017. Mr. Todd's evidence refers to some guidance issued by NIWA in 2012. So it's, although I'm sure it's all very good work, it's a different focus. And then Mr. Todd then focuses very much on the Ministry for Environment's scenario modelling, which is fair enough. Now been updated last year. But what should be recognised is that that has a caveat in the disclaimers saying that it's holds no official status. So I guess what's trying to be said here is that the first point in the methodology of the Jacobs report should have been Department of Conservation 2010 New Zealand Coastal Hazards Objective 5 Policies 24-23. So, and I haven't seen that in any of the paperwork, either Mr. Todd's evidence or in Jacobs, at least in Jacobs 1.
So you say the national guidance is the Department of Conservation guidance, which what? How does that differ from NIWA?
Well, it's written. I confess it's a 100-odd page document, and I looked at it from the point of view of coastal, but I have to admit the final section of it refers to the Ministry for Environment's work. So it says that the Ministry for Environment is putting together coastal planning and so on, and invites planners to take a look at it. So they should work together. But what I'm not seeing in the methodology is that the Department of Conservation's guidance has been applied.
So I'm not sure that does answer my question, but I'll move to a different one. Mr. Banks said, who's the planner for the council, this morning referred also to the National Adaptation Plan, which will have been made under the CCRA. I've read the emissions reduction plan. I'm not sure if the adaptation plan is in the same document. I haven't read the adaptation plan, but does that contain any national guidance of the type which policy 24 refers to?
Perhaps Mr. Milne might be better placed.
Okay, well, that's a question. I don't know what the national adaptation plan tells us about that.
Yeah. And when I first came into the space, it was to look at the vertical land movement and the sea level rise methodology and those sorts of things. And then what triggered the look into the Department of Conservation's work was the Ministry of Environment's work, which I was very familiar with through my work with the South Coast. it can actually be about as long as a piece of string. There's just documents for everybody when you start getting into the space. But I certainly have no knowledge going past that.
Well, there is a point which Ms. Padamsey, is that correct? Is making, that has got some validity, which is the last time the council put hazard lines on, it didn't issue a draft plan, and was based on an assumption of non-managed hazards. So it ignored all the management that was occurring to define the lines. So that was one fundamental aspect of it. And so there was it wasn't a great process. And I think that when the challenges did happen later, the council promised a full process.
Right.
And the council has been caught because it could never have anticipated this legislation which introduced the MDRS. And so the council has been put on the horns of a dilemma and saying, well, do we simply now allow all the intensification that the MDRS would promote without in any way addressing coastal hazards, recognising that we still have to go through this process and we are behind the 8 ball? Or do we simply just don't bite that, or don't take that tiger by the tail? That's, I think, the dilemma. And my question to you, I guess, Ms. Padamsey, is, well, isn't the underlying concern here that you don't want us to make a determination on something which should have a proper process?
Absolutely, and it remains untested. The use of RCP 8.5 and now this new construct 8.5H+ are implausible. Why would you subject the community to science that the IPCC themselves has now said is implausible? It's like what you said with the Shand report. He put accretion at 0. And this is just kind of going in the other direction, in the extreme of it.
Yeah. So my fellow commissioners, when they took this job, didn't realise they were going to be in the middle of a whole lot of climate science.
No. And we did,
all that's everywhere these days.
yeah, and we did have that discussion with council prior to the notification of PC2.
Yeah. So I'm just floating something which has occurred to me, which is not going to be an elegant solution to what is the horns of a dilemma, but what solution is, which is that, and this is an idea I'd like you to think about and come back to us on, and Mr. Milne to comment on. I prefer to put it out there and see what the reaction to it is that we treat it as a qualifying matter for a very limited period, with an express recognition that by a content in the plan that says this has only got a life of this period, it was formed for a particular purpose and function, and it was limited and has a limited life, and the debate properly to be held on that issue is through a plan change specifically addressing coastal hazards. And the reason I do that is because I can see both sides of this argument. I can see the council side of the argument that here we've got the sudden piece of legislation. We're talking about the dress circle pieces of land in the Kapiti coast with the most value. We've got obviously market forces that would operate to take advantage of the increased density that potentially could exist. And we still haven't had that debate. So we need to be precautionary. And there's your point, which is here we are again.
10 years later.
Yeah, so I'm just wondering whether there is a way through this, because I can see both sides of this coin.
Well, may I suggest that we listen to Philip Milne and what his legal submission, and maybe that might shed some light before we get to that. So
Yeah.
You're thinking more or less of a placeholder.
I'm thinking it's very much a placeholder.
Yeah. So I would think, why don't we listen to
Yeah.
Philip and see what he can contribute? And we can take it from, we can continue after there. If you want.
Yeah, that's fine.
Thank you.
Mr. Milne, can you hear me?
Hey.
Yes, I can hear you, sir. Thank you. Nice to see you again.
Nice to
and
see
the
you
rest of the
again.
panel. Now, firstly, apologies. I'm on the side of a road in a caravan. the camera may move, and in fact, it may be simpler if I just if you forget about seeing my lovely face, so that I can concentrate on my laptop, which is on a different device, and I'll just carry on speaking and answering your questions. I have a sort of a brief, well, a brief overview, and then I'm happy to answer any questions around the legal submissions following that.
Okay.
All right. So if I can, you can perhaps look out the window at lovely Hamner spring sunshine, and I'll just go over the overview. Get back to it. So I was going to start with an introduction, but I think Mr. Rush and Salima have introduced themselves. My name is Philip Milne. I'm representing Crew on this matter. So I guess the first point is I have revised the submissions from those that were filed in the middle of last week. I revised those on Friday because I picked up some errors, and also I reorganised them slightly. So I understand that the panel has the more up-to-date.
Yes, that's right. We have a hard copy.
Okay, so I wasn't intending to read those. I'm either assuming that the panel's already read them or will read them. So I was just going to provide a bit of an overview of the argument, and then happy to answer any questions following that if that suits the panel.
Yeah, thank you. We have read that. It's quite detailed, and we've had a lot of reading, but it would be helpful just to have the key highlights come through again.
Okay, so I think, as you've already picked up, really the primary argument is the cart before the horse argument, and that's yes, the council may have been caught by surprise by the intensification provisions, but it has had a long time to be preparing its plan change chapter, and it's long overdue. And indeed, it has promised the Environment Court that it would be notified last year, I think.
Right.
And in that context, my submission is that this panel is not the forum to decide these issues. They're contentious issues. They're incredibly important issues for Kapiti and indeed the whole of New Zealand as to how it manages these things. The council has embarked upon the adaptation panel process, but that process is not particularly well advanced, certainly in terms of public consultation. It's barely advanced at all. And there's a degree of frustration, at least from Crew, in terms of that. So I think the panel, as you've said, have found themselves slightly. We're not expecting to be dealing with the intricacies of methodology of climate change, and I think that sums it up. This is not the forum for dealing with these. And okay, the council has said it's taking a precautionary approach, and it is, I would say, also a fairly broad brush approach. And I with respect to the council, I can see why it's adopting that approach, but there's also a degree of inconsistency. It's relying on a report which hasn't been through any public consultation, hasn't been the subject of submissions, etc., let alone tested via evidence. And as illustrated by Mr. Rush, there is room to debate the methodology involved, and as acknowledged in the Section 32 report and in the report itself, it's not a risk assessment, and the extremities, that's the landward side of the proposed precinct, and not just the landward side, but the extent of it, north and south, is not at a degree of precision that it satisfies any site-specific requirements of the national policy statement. I'll come back to that in a moment. So simply saying that you shouldn't be asked to, or shouldn't have to determine these issues, and that what Crew is asking is that, I mean, it originally asked that you have a much wider, if we're going to adopt this approach, use the whole adaptation area and say, well, there are all sorts of risks in here, including in particular flooding from the Whakatau River and inundation, which go hand in hand with storm surges, etc. And the council hasn't excluded the flood areas, but it has included which are in the district plan, and where it's acknowledged there are also areas of uncertainty around what the 1% AEP is, etc. And that is going to be the subject of a review. Yet it's seen it necessary to embark on this process of excluding coastal erosion, but hasn't excluded coastal inundation. It all seems a little bit rushed and unnecessary, and I guess that comes back to the primary requirement for you, which is whether it satisfies the legislative requirements in terms of being necessary to implement the NZCPS. So that's the first point, cart before the horse. The second point is more jurisdictional, which is that the NZ's, well, no, sorry, I'll go back a step. In terms of the cart before the horse, the other limb of that is that the NZCPS Policy 24 requires the council to give priority to the identification of areas of high risk of being affected. But the council has in fact done the opposite. It's ignored the areas of high risk in the coastal environment, the flooding areas. They haven't been excluded from the intensification provisions, but instead it's given priority to creating the CQMP based on coastal erosion. And in my submission, that isn't consistent with Policy 24, and the priority should be identifying areas of high risk. Now, the Section 32 report acknowledges that the risks here are unlikely or extremely unlikely, I think are the words used. So in my submission, it doesn't comply with Policy 24, and I'll come back to Policy 25 in a moment.
What's the reference for that in the Section 32 report?
Hang on, here. So the relevant pages of the Section 32 report are 153 to 159.
Yeah.
And I think between that and Mr. Todd's evidence, and I think Mr. Rush has also cited this in his evidence, you'll see the references to unlikely and extremely unlikely. I'm just trying to find them, but one moment. So at page 155, this scenario is the most landward scenario modelled by Jacobs, and while it is described as highly unlikely, this scenario does have the potential to occur. So there's a legal issue there as to whether potential in terms of policy 25 of the NZCPS relates to highly unlikely. But there's also an issue in terms of policy 24 and the council needing to give priority to areas at high risk. And it can't possibly say that areas which are highly unlikely to be affected are areas of high risk. So it's not good, not doing what policy 24 is saying, which is giving priority to the highest risk. And indeed it hasn't at this stage identified areas of high risk, low risk, moderate risk. It's got Jacob's report, which has got various lines on it, which haven't been through any public process. So this sort of feeds back to the cart before the horse argument. And the wider or related concern that this isn't the appropriate forum to be debating the methodology or indeed really the interpretation of policy 24 and 25. So that's the primary argument, the cart before the horse. The secondary argument's jurisdictional, which is that in my submission, the precinct as it is not in accordance with 77I of the legislation and with the National Policy Statement 3.33. So in terms of the first bit, in my submission, it hasn't been shown by the council to be necessary to accommodate the NZCPS. Now the council's, the council doesn't seem to be relying on section 6, and I've got a section on section 6 in my submission, but the council doesn't seem to be relying on this being a significant hazard. So it's relying. It's clear from the 32 report, it's largely relying on policy 25. But in my submission, policy 25 first needs to be considered in the context of policy 24, and policy 24 comes first. The council needs to have carried out a proper risk assessment before it gets to policy 25. It can't logically work out which areas are at low or moderate or high risk of being affected, and which areas are potentially affected, which is obviously at the lower risky scale, until it's actually carried out the full risk assessment. And Jacob's report doesn't purport to be a risk assessment, and it is at an early stage. So the council is relying heavily on policy 25, which refers to areas potentially affected by coastal hazards. And that gives rise to the question of whether areas, particularly at the fringes of the proposed precinct, come within that definition of potentially affected. And this also relates back to Mr. Rush's evidence in terms of the methodology and best practice, etc. So in my submission, just to summarise, the controls required by policy 25 cannot or should not be put in place until the location of hazard lines is finalised. That in turn depends upon a risk assessment that's not been carried out. Put simply, the identification of hazards is required by policy 24, and the development of controls as required by policy 25 must be implemented via a comprehensive plan change as intended by the council. The current process is at best an interim measure and at worst an abrogation of the council's responsibility. I mean, I can't really understand why we've got to the point we're at and the council still hasn't introduced a plan change. And as I understand it from discussions with council management in the last week, is not intending to do so for another 18 months to 2 years. So the question you need to ask yourself is whether it satisfies the requirement of being necessary to accommodate the New Zealand Coastal Policy Statement read as a whole rather than relying largely on one policy. 25 and policy 3, the precautionary approach. And in my submission, is not appropriate. I would like to emphasise that Crew is not saying that these areas shouldn't be included in hazard lines. Indeed, it's fully accepting of that, and it's the relief sought in its submission originally sought that the whole adaptation area be included. And that's because there is uncertainty as to what areas should be and shouldn't be excluded from further development or intensification of development. And that's a debate which is a very important debate, which is for whenever the council gets around to preparing its plan. And it's a process which Crew is seeking to be involved in before the plan gets to the point of being notified.
Sorry,
So
where are those adaptation plans?
Sorry, where is what?
Where would I find the spatial extent of the adaptation areas?
You'll have to ask the council officers about that, or
So you don't know personally where it is?
yeah, they're on maps. It is mapped. Ms. Padamsey may be able to assist you on that. I think I have seen a map. They're quite extensive. Suffice to say, I think it goes out to the expressway. It's a large area.
Right.
But there are a lot of flooding areas and ponding areas within that. And so that illustrates firstly, the inconsistency of the council's approach, and firstly, the desirability of actually excluding from intensification provisions areas which really shouldn't be intensified. And relating that back to the coastal qualifying matter and trying to provide a concrete example, and I'm referencing now my own personal submission and that for Manny Flats Limited. If you look at what is proposed, we've got a proposed, and I think it's from recollection, it's map 08 of the proposed plan change. We've got a slither of CQMP starting up at Whakatau River and moving south and terminating at the Manly Flats property, protruding into that by a metre or so. And then we've got an area which would be subject to the intensification provisions, which is also beachfront, and so on the seaward side of Manly Street. And then further down the street, just north of George Street and down to the roundabout by the boat club, what I refer to as Paraparumu Village. We've got an area which the council has zoned for, I think, either 4-storey or 6-storey development as part of the Paraparumu Village Town Centre or whatever it's being called. I can't see the logic of zoning that area for not only intensification, but intense intensification when it's close to a significant stream, which the council has just spent hundreds of thousands of dollars strengthening and carrying out river works. But this area stretches north of that, and as I'm sure Mr. Todd and Mr. Rush will tell you, that's an area of vulnerability. So why is the council including that area but excluding an area up the other end of the beach? Now, excuse the pun, it's not head in the sand stuff. As a resident of Manly Street, I'll be the first to acknowledge that the area at the north end of Manly Street, particularly around the Whakatau River estuary, has been eroding, and it will continue to erode, and with sea level rise it will erode more. So eventually there will have to be restrictions on development. But the question is, where should the dividing line be? And this is not the forum to decide that. And it's illustrated by my own submission, and it's illustrated by the Manly Flats submission, where you've got this ridiculous slither of the precinct infringing on a property. But if you then go to the other side of the property, 125 Manly Street, that's available for intensification. So if this plan change goes through, the limb for Manly Street, if one of the 6 owners decides to sell, or the company decided to sell, because each of the titles is freeholder within a company share arrangement. The limb would say, well, this property is in the coastal qualifying management area and it's not available for intensification, but the next door property at 125, that's fine. That's available for intensification. So that has immediate effects on property value, but it's based on an arbitrary approach, and one which is acknowledged that the particular effect of concern is extremely unlikely. So I'm not saying that that Manly Flats shouldn't be in a hazard zone. I'm simply saying that it's too early to tell, and that this isn't the forum to do it, even by way of an interim approach. And getting back to the chair's question earlier on about one potential option.
Yes,
But anyhow, I think that's all I can really say on the subject at the moment.
So the slight dilemma that we have is that on the one hand, it's the cart before the horse. In other words, we shouldn't be even engaging in a discussion about the merits of the science. On the other hand, to assess whether this technique is appropriate, we have been asked to say, well, you don't meet this standard necessary, or you don't meet this test, which is high risk, which requires us to some extent to analyse the science. Do you see what I'm saying? We're sort of being pulled in different directions.
Absolutely, I fully understand, and indeed, to an extent, crew is being pulled into different directions by this, because on one hand, it thinks allowing intensification along coastal strip is undesirable for amenity reasons and natural character, but on the other hand, it acknowledges that there are areas of risk. It's simply saying that it's too early to determine where those go. And I guess the other point is the council's putting a lot of reliance on a precautionary approach, to hold things in case, suddenly things are developed and intensification springs forth and compromises what it's supposed to have done already but hasn't quite done. The reality is there are very few undeveloped sections along this bit of coast, and it's not going to suddenly spring into 3-story development. The council already, under its general provisions, allows a reasonable level of intensification. So intensification can already occur. So it gets back to a judgment call by the panel as to whether this is necessary to implement the NZCPS, and that's partly an interpretation issue around policy 20, the meaning of policy 24 and 25, but it's also a practicality issue in terms of do we actually need intensification along here? And if we don't have this interim measure, is there going to be is there actually a risk of significant intensification that's going to in some ways compromise what the council wants to do in the future? The reality is that if the council puts in hazard lines, the dilemma for the council and the community is there is also the development has already occurred. There's a huge amount of development along here. Virtually every property is developed. The the development has already occurred. What we're talking about is whether some of those properties potentially go to 3 stories or not. But that's sort of a tip of the iceberg in terms of the wider issue of the consequences for the development that's already happened. So getting back to your question before, I don't think that a compromise solution of putting in a time limited management precinct is the way to go. In my submission, the better way to go will be for the council to rely on its existing provisions, inadequate as those may be, because that's actually the best we've got. That's what that's the best information we've got. It's in the district plan. The best information the council has is not the Jacobs report, which has not been through any public process, and although it's been subject to a limited peer review, has not been subject to the sort of technical advisory group, I think it was called, that looked at the previous hazard lines, and it has not been subject to any public consultation.
All right.
But yeah, I'm happy to answer any questions around the submissions.
I have just one other question. If you look at policy 24 sub clause 1, which you've quoted, it starts off with the first clause, which is to identify areas in the coastal environment that are potentially affected by coastal hazards.
Mm-hmm.
And then it goes on giving priority to the identification of areas at high risk of being affected.
Yeah.
So the question of, does it meet the test of being high risk, doesn't really do justice to the whole sentence, which enables identification of areas that are potentially affected, whether they're high risk or not. It's simply saying prioritize the areas that are the highest risk or high risk. And so in these circumstances, the council hasn't done the job of identifying the high risk areas, but it has said it's identified potentially affected areas. Is that not a potentially legitimate implementation of the NZCPS?
Yes, it is. And I entirely see what the council is trying to do, and I can see what policy 25 is trying to do. But the qualifier on that is that there's two qualifiers. Firstly, what's meant by potentially, and should that include areas which are extremely unlikely to be subject to the risk? Is that what potentially means? Or does potentially mean something else, i.e. a low level of risk as opposed to highly unlikely? So there are some interpretation issues there, and I know that in the Ware decision, the court looked at these questions of the meaning of the words potentially unlikely, but it wasn't really in the context of the NZCPS. And then the second point is the one I made earlier, which is, does policy 25 in reality or depend firstly on the exercise in policy 24 having been carried out first? Before you include areas potentially affected, isn't policy 24 saying that the council should first set about identifying the hazard prone areas and carrying out a risk assessment and working out which areas are subject to which level of risk? And in my submission, the Jacobs report isn't adequate for that purpose, and for the reasons explained by Mr. Rush and other reasons which we haven't gone into, is focusing on the extreme in terms of unlikely scenarios, and hasn't properly taken into account firstly, a more realistic emission scenario, and secondly, the uplift. So the two topics that Mr. Rush deals with in his evidence. But yes, I can see where the council's come from. Do I agree with that as being the appropriate, or this approach as being appropriate in the circumstances? The answer is no.
So my questions to the council on this topic should be the following. Is this implementing policy 24 and 25 as opposed to section 6?
Well, I think it's clear that it can't be. It can't be implementing.
I'll just run through the questions and then get your comment at the end.
Sorry.
If the answer is yes, does the Jacobs report do the job of having regard to A to H? In 24.1, and if not, what's the why is it necessary for the purpose of section 77I to implement it as a qualifying matter here? Is that a logical sequence of questions to ask?
Yes, it is. I think the first question regarding section 6 is unnecessary in the sense that I don't think the council's saying for a moment that it's a section 6 matter, because it can't be, because it's on its own evidence. It isn't dealing with significant hazards. So the council is relying on policy 25, and it doesn't seem to be relying on policy 24. So I guess the question there is it relying on policy 24, and has it carried out, looked at all of the things in policy 24, or have Jacobs, in the light of of that being the best available information, the closing words of policy 24, which is where Mr. Rush's evidence comes in on a couple of points, whereas the council's approach seems to have been the Jacobs report itself is the best available information. But it's only the best available information in my submission if it's actually also been based on the best available information. And for the reasons given by Mr. Rush, we say that it's not.
Right. I see. So you think the council's relying on 25.1, 25A?
Well, according to the Section 32 report, that seems to be where all of the emphasis is put. The Section 32 report doesn't spend a lot of time talking about policy 24, but it does spend a lot of time talking about policy, mainly policy 25, and a brief reference to precautionary approach in terms of a wider policy consideration. So policy 3. Of the NGCPS.
Yeah, so I'm just trying to get my head around that. So it's not actually about identifying coastal hazards in that sense. So it's not doing that job. It's actually just managing a risk of increased social, environmental, and economic harm. So it's if the council's relying on 25, it's not doing an identification job, and this is the dilemma with these things, because in a way they take on a life of their own, which is your point, and I accept it. But it's a sort of multifaceted problem, if you see what I'm getting at.
Yeah. Which I guess gets me back to my original point, which is it's in my submission, it's not a problem that you should be having to grapple with. It's not sufficiently clear. Well, it's not clear at all that it is necessary to do this. Now, if we segue out of coastal risk and into issues that Auckland and other places are facing around heritage precincts and the like. It's a lot easier to say, well, we've already got a line around this area. And in fact, the submission for the Whakatau group, residents group, highlights this. So the council's already identified an area of high amenity value or heritage value or whatever. And then the issue becomes, you know, is it necessary to exclude that? Can that does it fit within one of the exceptions in the intensity part of the legislation? Whereas in this case, in this case, we haven't got that. We haven't got anything in the district plan. All we've got is a report which hasn't been through any public process or even public consultation at this stage.
Well, even in relation to some things that are in the plan, the council has said the driver is toward, we need to respect the Parliament's intent in enacting the MDRS. So even though we have areas that are distinctive in character and have been through a long community process, we have to implement Parliament's intention. That's where you got to.
It says that, but there's a degree of inconsistency. And if I could take you to page 156 of the Section 32 report, and the top bullet pointed paragraph there, the council tries to provide a justification for excluding the flood hazard area, well, for not including coastal inundation, because it says it's dealt with under its existing flood management policies. And then it goes on to say those areas are dynamic, and the 1% AEP flood level is to be determined using best available information, etc. We only need to look up to what's happened up north to see that the consequence of climate change is not just sea level rise, which so the council's focusing on one thing. It seems to be ignoring uplift, according to Mr. Rush. It's focusing on sea level rise and consequential erosion. Yet it goes on to say, however, a review of the district plan flood hazard provisions is planned as part of a future flood. You know, that's exactly the same issue as here, yet the council hasn't excluded known flood hazard areas from the intensification provisions.
Yeah, and I have raised that. I've raised it.
Stronger.
Yeah, I've raised that with them.
Yeah, well, there's much stronger justification there, because those they've already been mapped. Those maps are probably already out of date, because what was a 100-year flood event previously is probably a 50-year flood event, given the changing climate patterns that New Zealand is now subject to.
Yeah.
So it's partly an inconsistency argument, but I'm also saying, well, the council can't say it's necessary to do this, but it's not necessary to do that. And I
well,
try
they
to
would,
illustrate.
they would say, I would say to that, they're sitting in the middle of that, being picky in the middle. That may be that you're saying that that's not necessary is untrue, but that doesn't mean the other one is not necessary, because you haven't seen that as necessary. This one is not necessary.
Yeah,
that doesn't follow to me.
I agree, which is why Crew's submission asked for a wider CQMP based on adaptation area. In other words, if you want to take a precautionary approach, then exclude anything that's possibly going to be in your adaptation areas, and your adaptation area is huge. Exclude the lot. Don't pick winners or potential winners by focusing on one bit of the coast and then ignoring other bits of the coast, but as I've illustrated with the lower end of Manly Street, the southern end of Manly Street. You know, why on earth is the council allowing intensification with tower blocks, by the sound of it, seaward of any road in Kapiti. And that's why I suggested a rather arbitrary but tidier solution in my own submission, which is, you know, just exclude all of the properties seaward of the roads parallel, immediately adjacent to and parallel to the beach, or both sides of those roads, rather than trying to prejudge where the hazard lines are going to end up, and also prejudging what management or mitigation measures, adaptation measures the council's going to put in place. And again, that's illustrated by the Manly Flats Limited situation, where the point of risk is created by a council access way with damage to the foredune combined with a stormwater pipe. They're all risks which can be readily managed. And so it doesn't make sense to simply say, well, you know, this property is at risk because there's a low-lying area beside it, which provides a pathway for inundation, which is true at the moment. But it's an area which has been created by the council, or by the council allowing public access down there. So again, those are the sort of points that the eventual plan change will have to deal with. Not only the question of where the line should be, but the more contentious issue of what happens within the areas seaward of those lines, and where will the management occur? What areas will the council protect and not protect? And that's why, in relation to my own submission, I've urged you to actually visit that part of the coast. If you walk between that access way between 127 and 129 Manly Street and walk north of there, you'll see the increasing erosion. But the only erosion you'll see south of there is the erosion immediately around the end of the council stormwater pipe, which was caused by the water coming out at the end of the pipe, not by sea level rise or any change to the pattern of aggregation which has occurred. And when I get to my own submission, I've asked Salima to table some photos which illustrate that. But yes, I can see your dilemma, but I simply don't agree that this is necessary to implement the NZCPS. And also, NZCPS is there to implement the Act. So the starting point should be Section 6, Section 6H. And that's not talking about extremely unlikely events.
All right, I'll ask. Have you got any questions? Well, my commissioners have affirmed their reluctance to get into the technical science. Just one other question. As I recall it, with sea level rise, there is also a slight change to the groundwater levels. So this sort of inland impacts are actually less understood but real. Is that part of your point about the flood hazard areas as well, being worse, potentially worse as well?
Yes, and indeed, and I think we've actually seen it in the last. I'm straying into evidence here, but it's lay evidence, I hasten to say. After recent heavy flooding, i.e. last year, Kapiti is still waterlogged, and there are large areas of high groundwater table, and it's inevitable that the effect of sea level rise will be to further raise the water table, and that creates issues in terms of getting rid of the stormwater and you know, I think it was only last year, but certainly within the last 2 years, large sections of Manly Street were flooded. Cars were creating tidal waves because the water simply couldn't get away down to the beach because the pipes didn't have the capacity to take it out to sea, or were blocked. I'm not sure.
I get the
You'll
sense
need to ask the council officers about that.
I get the sense that your view from a sort of high level sustainability point of view is actually large parts of the coast are simply not suited to the MDRS for a whole range of reasons, whether it's natural character, stormwater infrastructure, coastal hazards, the whole 9 yards.
And
the poor old council's been stuck with an MDRS, and this is an exemplar of why the MDRS is a foolish piece of legislation. No disrespect to the Wharenui and Pipatia.
You've summarised my thoughts entirely. My submission was that the council should actually have focused, rather than focusing on excluding the parts of the coastal strip, and a very small part, or relatively small parts of the coastal strip, based on uncertain predictions around coastal erosions. It could have looked at its own district plan and said, we have classified almost all of the coastal strip as being of high natural character, and asked itself the question, is it appropriate in terms of the NZCPS to allow, and Section 6, to allow intensification immediately adjoining an area which we have designated in our district plan to have high natural character? And if it had asked that question and carried out the necessary landscape and natural character assessments going with that, not where areas are high or low, because that's already been determined, but what is the impact of, or what would be the impact of intensification, then it would get to the point of saying, well, actually we could exclude all of this area in a qualifying matter in terms of avoiding inappropriate development in the coastal environment. But it hasn't done that. It's focused on one narrow area, and elsewhere it's said within the Section 32 report that the consequence of excluding these areas in terms of the level of availability of land for potential dwellings is minor, but and the numbers are all in the report there. Well, equally, if they had have excluded all of the areas, at least all of the properties seaward of Manly Street and the other equivalent streets, then that also would have had a relatively minor impact in terms of the availability of land for intensification. And it relates to my other point about, why on earth is the council proposing an even higher level of intensification in areas like the Kena shops and the Whakatau shops?
Right. So the site visit you wanted us to do was what address?
But there's a walkway in Manly Street, which is next to Manly Flats, the Manly Flats property. So the walkway is between 127 and 129 Manly Street. And if you go to the end of that walkway and turn right, if you walk down the beach, you will observe an increasing level of erosion. If you turn left and walk down the beach, the erosion goes for a few 20 metres or so. That's current erosion, not taking into account sea level rise. And that immediate erosion is created by the stormwater pipe, which you will see at the end of that walkway. So it just illustrates where the erosion is occurring and not occurring. And I think you may have already, have you heard from Mr. Gunn today, or are you going to hear from Mr. Gunn?
No, we haven't heard from Mr. Gunn.
I think he's mentioning cuspate headlands or something. If you look at an aerial photograph, there's a point which is created by the land accreting, and it's illustrated by and that accretion is in large part caused by the shelter created by Kapiti Island. That's my understanding. You can ask Mr. Todd about that. Who long ago may remember that he was my tutor when I did coastal geomorphology, but I don't pretend to be an expert. And it's created by the sediment coming out of the Waikanai River, and sediment levels will increase with increased rainfall. So that's another factor which isn't taken into account of all of this. There will be increased sediment, and that sediment will end up somewhere. And then if you look at the photos, which I have asked to be tabled today, if you look at where the beach was in the 1950s, it was just about lapping at the doorstep of Manly Flats Limited Properties, which was then a motel unit. And it's now, by my calculation, around 50 to 70 metres seaward of that point, because of the property, because that's the cuspate headland that's created by the sheltering effect of Kapiti and the sediment patterns. So
Right.
the land has been accreting there.
Is this the one that's black and white and looks like it's got Heidi High Village?
Heidi High Village, indeed. There was a huge camping ground behind the flats, and at the bottom left-hand, there's a long building at the bottom left-hand side of that photo, which is Manly Flats. So you will see that if you go down to the walkway, and indeed you can, it's public land. You can walk right in front of the flats there. We're no longer resident there, but we still own one of those flats. So I'm just discouraging my wife from joining us for a cup of tea. Anyhow, I'd encourage you to go and look at that. And then there are also some more recent aerial photos, albeit just cribbed off a screenshot from Google Earth. So I think they date from 2016, but the council can provide whatever its most up-to-date aerial photographs are, and you'll see how all of that area has accreted, and that accretion is largely starts around about that point and goes south. And as far as I'm aware, the Jacobs report doesn't include any analysis of any real prediction of what's going to happen to that area of accretion, whether it's actually going to accrete more with the combination of the uplift that Mr. Rush has spoken about and increased sediment flows out of the river.
Certainly, it's not atypical of anything probably north of Raumati in terms of accretion on the coast.
Yeah, I can't answer that. I know there are areas of erosion further down the coast, largely in the Raumati area and obviously Paikokariki. I don't know exactly what the history is around the area of the boat club, which is within the higher intensification area, whatever that's called. But that's a question that you should be asking of Mr. Todd in terms of whether that area is also an area of potential erosion. To me, as a layperson albeit with stage 3 coastal geomorphology, it seems a daft place to allow intensification so close to a much more significant stream than some of the other ones, and a stream which has flooded in recent times, and which the council has deemed necessary to strengthen. But yeah, I can't answer that question. It just seems daft to me, but maybe there's a good scientific reason for saying that area won't erode, whereas further north will.
Yeah.
And I assume that that relates to where sediment goes. So, but I don't know whether Jacobs have studied all of that. I haven't pored over the Jacobs report in terms of what it has and hasn't included. I do come back to one point that you made earlier, which is the question about whether the Jacobs report has covered all of the matters in Policy 24. And I think that the answer from Mr. Todd is, well, yes, we have. But I'm struggling with that a little bit, because if you look, for example, at where the line is, and just simply because it's the bit that I'm more familiar with, the line at the northern end of Manly Street, it's not a straight line, it's a curved line, but it's not indented in and out. It doesn't take into account the low-lying areas of the dunes. It doesn't take into account the council's stormwater infrastructure and the effect on that on erosion. So I'm struggling to see that the report satisfies all of the requirements of Policy 24 in terms of all of the things it needs to look at. But then there may have been some looking at it, but I don't think it's in the level of detail that the Policy 24 envisages. And then that brings us to the National Policy Statement in 3.33, which does require a level of site-specific study, which in my submission just hasn't been done. And I'm interpreting the word site down as going to the level of individual properties. And I think if you ask Mr. Todd, that you will find that the study doesn't go to that level. It can't predict whether 125 Manly Street is likely to be subject to erosion or potentially subject to erosion, but 127 won't be, or 125 won't be. And it doesn't go to the site-specific level of looking at all of the inundation pathways and erosion pathways created by the access strips. And I can't remember how many access strips there are down Manly Street. It's probably about 6 low-lying areas which create areas of weaknesses in the foredune. Have those all been studied and mapped? I don't even know that the one between 127 and 129 has been studied at that level. But those are questions for Mr. Todd.
Okay.
But my reading of and there you may have noticed there's one section I deleted from my earlier version of the submissions around the need for specificity, because the council wasn't relying on other matters which did require site-specific analysis. But then when you go back and read the MPS at 3.33, it seems that there, well, in my view, there is a level of specificity required. In other words, you shouldn't, 3.33 seems to be saying no property should be excluded unless the council has got a proper justification for doing so, and that's based on a site-specific analysis. And I just don't think that that's been done.
Right. Okay.
The council is treating, in that context, the council is treating the word site as area and saying, well, we've done enough to say there's a potential risk in this broad area, but that's not a site-specific analysis.
Okay. All right. Well, I think that's been a very useful discussion, and I understand your points.
Thank you.
So we'll reflect on that.
Yeah, I had intended to discuss separately the Manly Flats in my own submission, but I've probably sufficiently dealt with those in passing. I would encourage you to look at those aerial photographs, and yeah, I'm not saying as the investment advisors would warn you. What's happened in the past is no basis for forecasting what will happen in the future. So I'm certainly not saying that because it's been accreting since 1950 or something, that will necessarily continue. That's not my area, but I'm just saying that that's something which is going to need to be sorted out with more precision in another process.
Yeah. I found that very useful. Thank you. I appreciate your time and taking time out of your holiday.
No problem. It only began at 5 a.m. this morning. Thanks very much.
Thank you.
Thanks, Philip.
All right. So well, there's some more deeper questions he wants us to explore there. So we probably need to penetrate that and reflect on that. But we may have some further questions or issues, so we'd like to come back to you if we can.
Yes, and we would welcome to come back to the panel and bring clarification.
Yeah.
When required.
Thank you. That's very much appreciated. So I think that brings us to the end of the day, does it? I just had another question of Mr. Conway on an unrelated issue. That I was reflecting on, so I'll just deal with that. Going back to this question, which is related to the Rewa Urupa, I wanted to postulate this question. It strikes me that the regime in section 80 and 77 I and maybe O and P, N and O. Let's say, for example, you're implementing either the MDRS or the policy 3 in an area in a township which has got a lot of heritage values. And it says, well, you've got to look at the extent to which is necessary and appropriate to retain those values. And in the course of doing that, you then come across an assessment that says, well, we actually don't need to retain all of that, but there's a part here which collectively, if we retain, would be a better package. So, for example, you lost some heritage, but if you retained not just the facade, but the entire portion of a building, it would be an acceptable result. In a sense, you're not just retaining the status quo for that building, you're actually increasing the amount of protection for some components. In other words, you're concentrating the heritage protection to components rather than a more broad brush approach. So you're balancing policy 3's objective of getting more intensity, but preserving the core elements of part 2, which is a slightly different direction to the current direction, which is more broad but less intensive. Imagine, I'm not sure I'm expressing it there. Imagine that concept. That's pushing you in a direction which is more like the Karewa situation. You know what I'm saying? Which is, you are actually providing for part 2 matters in an enlarged degree, in a different form than the current plan. But that's a consequence of the fidelity to addressing the issues. And I wonder whether if that's true, or if that's a possible construction of the regime, it's an illustration of how part 2 matters may actually bite more strongly in the process of addressing that. I'm just conceptualize that. I'm not sure I put it that well, but it seems to me potentially the case that the Act has confronted that situation the way it's worded it. In other words, that they can't eliminate the possibility that there would be tighter controls in part, as part of the accommodation of the more liberalising environment that has arisen.
Yes, I guess the way I think about that is, in that example, you start with existing qualifying matter, that predated the IPI. And you would have a consistent level of protection that applied to that, and the IPI would recognise it. So part of what you were looking at is whether the IPI process might be able to gather more information on the particular components of that qualifying matter that have higher or lower value, and adjust the qualifying matter accordingly with an increased level of protection.
That's expressed it well.
And it seems feasible that could help with these provisions, way that you can relate to provisions. And I suppose in each case it would depend on having that base level of information to ascertain whether that increase and decrease in protection respectively match what you were seeing in front of you. And so I suppose for Kāre Warewa, we come back to the question of what the evidence is on the merit of the listing and the resulting appropriateness of higher or lower levels of intensification or none at all in those relevant areas. And I imagine that's part of what you record in terms of implementing that particular component.
Yeah, it seems to me that if a submitter came along and said, I own this block of shops and they've all got heritage value, and what I suggest is you intensify this bit and we put higher levels of protection on this bit to get a total package solution that meets part of the objectives of the intensification instrument and partly heritage, that would be within scope of the process and feasible as an option if provided for in a submission. And it's hard to see why, if the council came up with the same idea, it wouldn't be also something it could do. That's just what I'm thinking about. Because I can see some of the merit in Mr. Slyfield's argument about the natural sense in which a qualifying matter is, like, it's what does qualifying mean? Does it mean it qualifies for consideration, or is it qualifying the NDRS? And qualifying is it's a gerund, it's a type of word that can operate as a verb or a noun, and it's like, what is it relating to? Is I guess what I'm thinking about.
Yes, I think I'd probably conceptualise it as the qualifies the implication of the NDRS rather than qualifies for something else. But I think we'll probably consider it in both ways.
Yeah, well, if you consider it in the second way, it sort of lends support to Mr. Slyfield's analysis, which his function is actually to mitigate the operation of the NDRS or Policy 3, as opposed to having or qualifying for consideration as a matter. And I'm struggling with the words a little bit. Maybe it's too late in the day to grapple with that.
Well, if I can respond on that briefly, I understand that approach. I think that's probably looking at it the way that Mr. Slyfield is, and I appreciate we're talking a lot about what he said before he said it. We'll be looking forward to having a chance to speak himself. But the way I would conceptualise it is the RMA provides for things like Section 6 matters. Those have effect throughout the RMA as Section 6 matters. For the purpose of an IPI, those happen to trigger provisions as qualifying matters, but that's not the only thing that those matters can do. So for the purpose of the IPI and NDRS,